Hey guys. Oof. This was a wild time to get ready. So I appreciate you hanging in there with me. I can never read what this says. All right. So welcome. Happy Tuesday. My name is Lacey Jane, and this is Criminally Confident. If you are here, I greatly appreciate it. Whether you are live or you are watching on replay, please make sure to hit that like button. That's that thumbs up button. And subscribe to the channel. It really helps the algorithm. And you guys are doing so much out there. And we're giving away free gifts like this week and next week. How awesome is that? So, if you're interested in that, there's like a pinned comment in the comments section that you can sign on up for it. And yeah, let's go ahead and see if nope, hasn't started yet. We're here today because we are going to be streaming the remainder of the hearing that that started on January 16th for Tyler Robinson. He is the alleged perpetrator in the horrific and despicable crime against Charlie Kirk. So if you did not watch the last court hearing with me, it was quite tumultuous. It was just supposed to be like an in and out hearing, and it ended up being far more than that. So yeah, so right now we are waiting for that to get started. Let me put it up here on the screen. And hi, maybe per usual, I am going to be doing a little bit of a get ready with me. So hair and makeup, and today's product spotlight of the day is most definitely dry shampoo. We're having one of those days. Okay, kids? Okay? All right, cool. All right. Once this comes on, then we will be ready to go. And I even had to do like a math equation to figure out what time this was going to start, because I normally start at 3:30. If you're an OG and you watch me regularly, I don't come on before 3:30, but got to do what you got to do. All right. So, like I said at the beginning, like and subscribe. And then in the comment section, you'll see like a pinned comment from me that says fill out the Google form. And that's just to be included in the prize wheel action that we have going on next week. So make sure to do that. What else? I did a brief members only stream on Saturday. And oh, you know what? Before I go into that, I know that there's a bunch going on right now, like literally right now. So I do want to just like say I greatly appreciate your patronage and you guys showing up for me. Because there's 100 different cases like starting at 3 p.m. So what I'm going to do, pardon me, is this is my bread and butter. Because I was a very strong supporter of Charlie. One second. I was a very big supporter of Charlie, and so I want that to be like my focus. But until that starts, I can technically put on this charger is making noises. I can technically put on one of the other cases that is going on right now.
so evaluated, and the court will impose only those sanctions that are appropriate and proportional under the circumstances. Before imposing any sanction, the court will make specific findings on the record. In addition, the court may consider any remedial measures, including immediate suspension of video transmission for the hearing in which the violation occurs, with proceedings continuing on an audio-only basis, and disqualification, if necessary, narrowly tailored, of the news organization that filed the request in order for electronic media coverage of the court proceedings for that hearing from serving as pool camera operator in this matter, where such a measure is required to ensure compliance with the standing decorum order and protect the rights of the parties. Any such remedial measure would be considered only as a last resort and only to the extent necessary to address the specific violations at issue. Counsel will have an opportunity to provide input before the court makes any final determinations regarding sanctions. The court values that input and will give it careful consideration. I want to be clear that these measures are intended to preserve open and transparent courts while ensuring fairness to all parties, and the court remains fully committed to the presumption of open proceedings under the applicable rules. Rather, these measures exist to protect the constitutional rights of all parties while preserving the integrity, fairness, and orderly conduct of these proceedings. With respect to media coverage in the courtroom, the court offers the following additional guidance to assist everyone in navigating today's proceedings. The pool camera has been relocated to the rear of the courtroom. The camera operator shall not zoom in on any individual seated at counsel table.
It's really bad audio.
When counsel tables
That's
are
not me.
filmed, the camera must remain in a wide shot that includes all individuals seated at the table. Attorneys and witnesses may be filmed individually when standing at the lectern or seated in the witness box. I would also ask counsel to be mindful that microphones are located throughout the courtroom and may pick up conversations. Counsel may wish to consider using screen protectors on laptops and taking reasonable steps, such as covering one's mouth when speaking, to avoid the inadvertent capture of private communications, whether by camera, microphone, or those present in the courtroom. Third, the court wishes to address the camera operator. At this time, Mr. Josh Demick, could you come forward to the lectern?
Oh, shoot. Oh, shoot. He gonna get spanking?
Could you please state your name and spell it for the record?
Yes, my name is Josh Demick, Josh-Demick.
Thank you. My intention is not to cause you any embarrassment or discomfort, although it's probably not feeling that way on your end. I simply want to ensure that the expectations for today's proceedings are clear. During today's hearing, what is your primary role?
My role is to cover the hearing that we have going on this afternoon, and I have read over the decorum and the EMC as well. My plan is to solely focus on the individuals that will be speaking up here.
All right, you anticipated my next question, which was, have you read the December 23rd, 2025 standing decorum order, which you have, and I appreciate. And do you understand the guidelines as they relate to your responsibilities today, including the additional guidance regarding camera position at counsel table and the filming of attorneys and witnesses that I just put on the record that was not in the decorum order?
Yes, Your Honor.
All right. Do you need any additional time to review the order or to reposition the camera to ensure full compliance?
No, Your Honor.
All right. Do you anticipate any difficulty complying with the order or today's guidance?
No.
All right. Thank you, Mr. Demick.
Thank you.
Before I let you go, as I just asked questions of the pool camera operator, Mr. Demick, I'll turn to counsel. Do you wish to weigh in on what the court has just done?
No, Your Honor. Thank you.
Thank you.
Yes, thank you, Your Honor. Richard Novak for Mr. Robinson. May I speak from here?
Yes, Mr. Novak.
All right, thank you, Your Honor. We appreciate that the court, on its own accord, moved the videographer. I don't know where the still photographer is, but we continue to be concerned that any video images of Mr. Robinson during court proceedings, close-up images of Mr. Robinson during court proceedings, interfere with his right to a fair trial. I think I heard everything the court said about the videographer, but the still photographer is still seated in the same place where they were last week. And we would ask the court to order the still photographer not to take any photographs of Mr. Robinson's face or person during the hearing. In the same way
seems a
that the
little
videographer has now
excessive.
been ordered to be focused on
Aggressive.
the court, the witness, if somebody's testifying, counsel at the lectern, or generally the people seated at counsel, what the court referred to as counsel table. We do not want to see still images again of Mr. Robinson's face in the media with more speculation about meaning of his facial expressions or the lack thereof. And so we really appreciate what the court did on its own, sua sponte, I guess we would say. But we have the same concerns about the still photographer.
All right, and before I address that, any questions as it relates to Mr. Dimick? I want to excuse him to go back. Standing in front of the court is no fun. I recognize that.
I was just trying to keep him up there as long as possible.
All right, Mr. Dimick, thank you so much.
Thank you very much.
All right, before I address that, I'll allow the parties to be heard before I address what Mr. Novak has brought up as it relates to the still photographer,
Uh-oh.
to the state.
Okay.
Your Honor, I think Your Honor is appropriately concerned about the video, any close-ups of Mr. Robinson. I'm not sure that a still camera presents the same concern.
I agree.
This is a public hearing, and
It's hard to hear.
this is a public hearing, and I think that
You heard me.
that it's appropriate that still photography be taken.
Yeah.
I don't know that it raises the same concerns that Your Honor's raised with the video.
Thank you. Any other party wish to be heard?
Sure. I'll jump in there.
I'll be brief, Your Honor. Michael Judd on behalf of the news media. We agree that with what the state has just said. The concerns that I understand the court trying to address involve the capture of moving lips that can be used by lip readers. We have dealt in the past with inadvertent overhearing of actual conversations. I don't think still cameras present that same issue. The idea that a participant in a public hearing, including the defendant, cannot have their image captured by a still camera because a facial expression is somehow too much to let the public see, we simply don't agree with. It is, of course, the court's prerogative to set the guidelines that it believes are appropriate to balance these interests, but it will come of no surprise to the court that the news media believes that that particular measure of saying even a photograph of a defendant in a public courtroom is too much to allow without threatening fair trial rights in a way that goes beyond that balance. We think that's too far.
All right.
Yeah, I agree. Good job,
Mr. Novak,
lobbyist.
I do have a question for you. Has there been a violation of the decorum order by the still photographer in any of these proceedings?
I am not aware of violations by the still photographer, but I am very aware, if I may, of what we believe is unfairly prejudicial media content based on the images. And
Welcome, Virgo. We are on the same
video
page.
images, yes, can be embedded in electronic media, but still photographs also are still appearing. Still photographs from the courtroom are still appearing in print media and in less, what we've referred to as less formal media channels. So we are still very concerned, and I don't
harder.
understand why there would be any even marginal negative access to the public to this hearing by the still photographer being in the back of the courtroom and taking photographs of the court, meaning your honor, of witnesses on the witness stand, if that's what the court's going to permit, of counsel, I don't have a problem with that. But we continue to have grave concerns of huge photographic lenses being focused on our client. And the results of that, and I'll just make a representation to the court that while we were in court last time, Mr. Burt and I both received, literally in real time, long ranting voicemails from people who were watching the proceedings. Now that was on video. I received another one of those calls today referring to my client's facial expressions from somebody who decided to leave a long, aggressive message on my office phone. And I'm very concerned that even still images of Mr. Robinson's visage in the courtroom are going to interfere with his right to a fair trial. And we've reached the point, because of the prior violations that have occurred and because of the nature of the media coverage, where Mr. Robinson feels like he may have to make a choice between two of his Sixth Amendment rights. And that's the right to a fair trial and the right to be present. And we want him to be able to have both of those rights and all of his rights. And the way he can exercise both, his right to be present and his right to
Did you guys lose that?
camera
Okay.
to
Never
where the
mind.
video camera was ordered to be.
Thank you, Mr. Novak. Thank you to all
No.
parties. I appreciate your input. This is an important matter, and the court takes it very seriously.
Oh, yeah.
I note that there has been no violations of the December 23rd, 2025 decorum order by the still photographer. That being said, this court wishes to exercise caution and will request that the still photographer go behind the bar, to the bar being
So dumb.
the separating lower wall, and reposition his camera at that place. I appreciate the patience of all parties as we do this. And again, this court is balancing open and transparent courts with the constitutional rights
Thanks.
of all
Virgo.
parties involved. All
She's
right.
just
While that's occurring, I'll turn to the state. The court would appreciate a brief
Mine.
update on the status of discovery.
let's go. Let's get to the good stuff.
Your Honor, Chad Greenender for the state. To date, we have shared with the defense 100% of what we have received from law enforcement. With that said, we have been informed late last week that there is approximately, well, there are several terabytes of digital evidence from phones and other digital devices that the State Bureau of Investigations has in their possession. We are collecting a 20 terabyte hard drive to two of them, one for us and one for the defense. We did receive a letter, I think, this morning from the defense outlining their expectations with respect to how that would be received, original form, and more specifics as well. So we're in the process of coordinating that download onto those hard drives of the digital evidence that's been collected, and we will provide that as soon as we receive that downloaded to the defense. We are still working with law enforcement on the download of approximately 30 days of all of the surveillance video at UVU. We were told it was approximately 300 terabytes, and that's being downloaded 24/7. So that is still in process. So we're actively working on that and looking forward to collecting that and passing that along to the defense. It will need to be shared in some sort of similar fashion, I'm sure, with respect to hard drives.
Thank you, Mr. Grunander. Does defense want to be heard?
That is correct, Your Honor. Stacey Visser on behalf of the defense. We are in communication with the state about what we believe is missing at this point. And we are anticipating a large amount of digital discovery in the next few weeks that we will need to process.
All right. Thank you.
May I supplement this conversation, Your Honor?
Briefly.
Thank you, Your Honor. We've kind of divided up discovery responsibilities, and mine is to address what I'll call non-digital forensics. So there are many items of seized evidence that have been sent to various law enforcement labs around the country without getting into the details. We have some very, what I'll refer to as summary reports of those evaluations. But as the state attorneys know, we're going to need all of the underlying data, notes. These relate to things like DNA and other forensics. So if we haven't provided them with a very, very detailed list of the types of documents we need, we will. But I think, and Mr. Grenender could speak to this in more detail in terms of the status of that, but I think that's another big chunk of materials that presumably the state attorney's office has not received yet from law enforcement. And so obviously they haven't had a chance to give it to us. And we haven't had an opportunity to look at it or to have our own experts review those types of materials.
Thank you, Mr. Novak. All right, before Mr. Grenender.
We'll make a point to a follow-up on that with the law enforcement agencies. We'll communicate with defense counsel on that, Judge.
I appreciate the cooperation between the parties.
I'm so sorry.
Before the court proceeds further, it's appropriate to address the record. The court notes the recent filing by victim representative Erica Kirk involving the statutory right to a speedy disposition of the charges under Utah Code Section 77-38-7 sub 2. This court raises this issue solely to ensure that the record accurately reflects the statutory obligations governing the matters presently before it, and not to suggest any view regarding the merits or outcome of these proceedings. Under this statute, a crime victim has a right to a speedy disposition of charges free from unwarranted delay.
The audio is
When
not
considering a
bad on my
defendant's
end.
request to
It's
continue
there.
a previously scheduled
Problem.
trial
I promise.
or other significant criminal proceeding, the court must inquire into the circumstances asserted as the basis for delay and must consider the victim's interests in timely resolution together with the defendant's constitutional and statutory rights. The court emphasizes that the defendant's rights to due process, to present evidence, and to receive full and impartial consideration of all arguments
So annoying.
remain paramount and undiminished. The court's responsibility to balance these interests faithfully and without preference to any party. As previously stated on the record at the September 29th hearing, justice demanded that both of these principles, the rights of the accused and the rights of the victims, be honored without compromise. With that framework established, the court will hear briefly from counsel concerning how you propose proceeding today.
Thank you, Your Honor. Richard Novak, again from Mr. Robinson. We're prepared to continue with Mr. Gray's testimony. We did file what I captioned a renewed request that this court proceed under a particular section of the Utah Code to refer this motion to the Attorney General. So it's obviously up to Your Honor to decide if the court wants to address that renewed request in writing now or at a different time. I do want, whenever it is the court's view that it's timely, to address the issue that the court just brought up, which is how the court, well, what I want to address is how the court will manage the question of whether Mr. Robinson needs more time to prepare for the preliminary hearing. So the court got an update on the status of discovery. The court noted Ms. Kirk's filing, which of course we are all aware of, and we understand her rights as the representative of the victim in this case. there are challenges under Utah law when the defense needs to communicate to the court the details of its diligence in terms of preparation for a hearing, because we're not going to make a public filing of work product. And I'm sure the court understands exactly what I mean.
Yes.
So what I'm saying is the court brought up the filing and the significance of that for future proceedings. We're going to need to have, if I may, what I would call sort of a case management conference at some point about how the court will manage our need to be able to share with the court the status of our work, which we believe is confidential and privileged, in light of the fact that every time we file something and ask the court to designate it as private, we have counsel for the media trying to
Where's everybody
unseal it.
from in the chat?
And we
Where are you
also
watching
don't
from?
intend to disclose to the state the status of our diligence. And so I'm not asking the court to address it now. I guess I'm just trying to put a Post-it note on somebody's list. It's certainly on our list. And we didn't really intend to bring that up at the outset of today's proceeding. But since the court mentioned Ms. Kirk's filing, it just seems like the right time to mention that. So we're prepared to proceed with further testimony from Mr. Gray and keep going with the evidentiary hearing unless the court wants to address what I captioned our renewed request.
Thank you, Mr. Novak.
Thank you.
To the state.
And Your Honor, the state's prepared to go forward with the evidentiary hearing. We are prepared also to address this renewed request. If Your Honor would like to do that at the outset, I would suggest that Your Honor set a time limit on that argument so that if, assuming that motion's denied, that we can move on with the evidentiary hearing. We've got witnesses who've been subpoenaed. They're ready to testify.
Like 3 times
All
now.
right. Well, I appreciate that update, and I do want to give some guidance of how today's hearing is going to go. And both parties have touched upon that. Based on the record before the court as it relates to the evidentiary hearing, and in order to ensure a fair, orderly, and efficient proceeding, the court will proceed as follows. First, we will address what Mr. Novak just brought up in regards to the referral to the Attorney General's office briefly, and you'll see why I say briefly with my next statement. Counsel will have until 4:30 to present evidence, including cross-examination and any redirect. Motions for supplemental briefing are denied at this time. as the court
Audio.
finds the issues adequately framed for today's proceedings. These parameters are not intended to limit any party's substantive rights, but to keep the proceedings focused and free from any unnecessary delay. Upon the close of the evidence, the court will proceed to argument. Each side will be allotted 15 minutes. Mr. Novak, or to any of the attorneys who would be making closing arguments, if you intend to reserve time for rebuttal, please allocate your time accordingly. This court will conclude at 5 o'clock. And in addition, the court anticipates issuing its ruling via WebEx in order to give the evidence and the arguments presented today the careful and deliberate consideration they warrant. That proceeding will be scheduled at the conclusion of today's hearing. And so, counsel, with that in mind, we will turn to the motion to refer or the motion concerning the Attorney General's office. I will hear from both parties. It is your time. I am not putting constraints on who you call, what questions you ask in part, but keep in mind these time constraints as we address this issue. Mr. Novak.
Thank you, Your Honor. We filed what we captioned the renewed request because obviously at the last hearing, we brought the request verbally. And obviously the court's read our renewed request and our points and authorities. We received the brief written by Mr. Ballard, which is very clear and very well written, and we understood.
They're way too nice to each other.
We just disagree fundamentally on what that code section means. We disagree fundamentally on the suggestion that there's a separation of powers problem It is ultimately this court's responsibility to ensure that parties are represented by conflict-free counsel. Obviously, in the legal profession, there is an initial expectation that counsel will avoid conflicts. But there are always situations where a party needs to bring a conflict on the other side to the court's attention, and the court has both the statutory authority and the inherent authority under the common law to do something about it. So we do believe that this is well within the court's discretion. The statute actually tells the court that it needs to encourage the state to seek assistance. That seems to be a gentle way to say that the state
Is not
at
doing their
least
job.
disqualified from litigating its own disqualification issue. And then I'm going to reserve the rest of my time for our evidentiary hearing and closing arguments.
Thank you, Mr. Novak.
Thank you.
Turning to the state, Mr. Ballard.
Your Honor, it feels like Groundhog Day.
Yeah.
Here we are, we've got, again, we're supposed to be having an evidentiary hearing, and Mr. Gray should be on the stand, and instead we're arguing again this issue about whether this court can refer this issue to the Attorney General's office. And I guess if I were in Your Honor's position, I'd be wondering why the defense insists on raising this issue in a way that doesn't allow this court or the parties to be able to fully analyze it and brief it. The defense finally did file a written motion, but waited until Friday afternoon to file that.
Well, it's
So, as
Tuesday.
we've outlined in our alternative point in our response, I think this court would be well within its discretion to just deny that motion as untimely. But on the merits of that motion, I think, as we've explained in our response, and Your Honor's indicated that you've read that, I think we've explained clearly why this statute does not apply in the way that the defense claims it does.
He's messing
And I'm
with the
happy to walk through
volume.
the statute and the points that we've made. I don't want to belabor that. If Your Honor has any questions about the statute, I'm happy to answer those. But I think it's clear that this statute does not allow the court to replace a prosecutor. At best, what it allows is the court to recommend that the county attorney seek the help of the Attorney General's office. So I don't believe that this statute has any application. The cases that the defense has cited are irrelevant to this issue. And for those reasons, unless the court has any further questions about the state's opposition, I'd submit it.
Thank you, Mr. Ballard. Anything further from the parties before this court issues a ruling?
No, thank you.
All right. So before this court's defendants review the request to refer the pending motion to disqualify to the office of the Utah Attorney General. In support of that request, the defendant relies upon Utah Code Section 17-18A-304, which provides that the Attorney General shall assist a county prosecutor only if the court finds that the prosecutor is unable to satisfactorily and adequately perform the duties of prosecution and recommends that the prosecutor seek additional legal assistance. The defendant argues that where there exists a non-frivolous basis, factual basis, suggesting a potential conflict of interest, the court should make such a finding and recommend assistance from the Attorney General. The court has carefully considered that argument and reviewed the briefings. However, the statute does not adopt the standard proposed by the defendant, nor does such a standard appear
Oh
in
my
existing
God.
case law or court rules. The statute requires specific findings regarding a prosecutor's inability to satisfactorily and adequately perform prosecutorial duties before referral is appropriate. At this stage of the proceeding, the court is not persuaded by those statutory conditions have been met. Based on the record presently before the court, there is no indication that the Utah County Attorney's Office lacks the resources, knowledge, or ability to litigate the motion to disqualify on behalf of the state. Accordingly, the court cannot make findings required under section 17-18A-304 to justify referral to the Attorney General's office. For these reasons, and without expressing any views on ultimate merits of the motion to disqualify itself, the defendant's renewed request for referral is respectfully denied. All right, counsel, let's go ahead and proceed. Mr. Ballard.
Thank you, Your Honor. Could I just clean up one piece of the record? Your Honor referred to the statute as 1718A, but I think it's actually been renumbered. It's
Oh, thanks, maybe.
17-68-304 is the current citation.
Agreed.
For the record, we
I
wanted
appreciate that correction.
this to
and-
proceed.
And that is correct. I appreciate that. And to clarify the record.
So this is
thank you to both
disappointing.
Parties. And so my ruling reflects that 17-68A-304. All right, counsel, are we ready to proceed with continuation of the direct examination of Mr. Gray?
Yes, except to quickly implement the exclusionary order that the court entered at the last hearing with respect to prospective witnesses.
Oh my God.
The court will take a very brief 3-minute break in order to accomplish all parties speaking with whoever needs to be spoken to and for them to be excluded, and then we will proceed. It is now 1:38. We'll come back at 1:41.
Okay.
There's a brief recess.
All right. So I think we've learned a lot of things since the last trial. One of the most important things is to better utilize our time in the courtroom. For example, if you were not here with us during the last hearing, it was quite frankly ridiculous. They just allowed the defense to go on and on and on because the defense had the wrong time up on the podium, and it was like 5:30 Utah time, and it was like 8:30. No, it was like 7:30 Florida time, because I was 2 hours late to dinner with my husband and friends. And it was just nonsensical, in my opinion. And weird questions were being asked. And I think we all came to the agreement that we want this case to be airtight. We don't want there to be any loopholes found. We want to make sure that the state is able to provide a rock solid case. We want the defense to not have any problems providing their defense, so that this doesn't go to appeals. And right now, all I'm seeing is a lot of slippage through the crackages of the systems of law, and a lot of loopholes for them to be able to come back and be like, well, we tried to warn you. This is why we should go to appeals, and it's going to be granted. I feel very, very strongly about this. So I'm actually, I don't know if it's like an ego thing with Graf. I don't know if I don't know if he is just, it doesn't seem like he has like a tumultuous relationship with any of the attorneys. Because you can pick up on that sometimes. And it's just really disappointing to see this. It's really disappointing. And I feel like that we're just setting ourselves up to see Tyler Robinson again and again and again and again, because he's going to win his appeals. Because this judge doesn't have the foresight to consider what the defense is saying. And I think that the defense has a genuine concern. And oh my God, how many terabytes are we talking about? That was crazy. Absolutely insane. Excuse me. Virgo, so the sheriff doesn't have any reason to believe that that gun couldn't have not shot that bullet. Like I am very eager to see. Eager isn't the right word, but so I hope you understand what I'm trying to articulate. I'm very open to seeing the case put forth, because I know there are a lot of questions about it. I get that. And as I say to my followers all the time, like, what I love about this channel is that we can all have differences of opinions, and you're not going to be exiled. You are allowed to say what you think. I adore the First Amendment. There are parts of the First Amendment that I want off of my YouTube, which I'm sure you can understand. But that's where I'm at with it. It's the court thing has changed to that. So hopefully they're going to get started soon. Yeah, it's like 2 minutes past. What in the world? There's so much going on today. There's so much going on. Hopefully, you know what? This break could be a good thing. Maybe someone is going to tell the videographer that it's that the video is picking up too many mics, because it definitely doesn't sound right. Sounds bad. I like that, maybe. I mean, we've been through a few trials together by now, and yeah, it comes down to forensics to me, and it comes down to critical thinking.
No, not that I can remember. That's completely.
Okay, well, I'll represent to you that it was 5 days after the hearing on January 21st. Does that refresh your recollection at all?
Oh, are you talking about after the hearing? I'm aware of that, yes.
Okay, and
Yes.
how did that come to be? Because you testified that your office has no involvement in the investigation.
Well, it was a point that you had pointed out, and so out of an abundance of caution, I believe it was Mr. McBride that decided to go ahead and do that.
Okay, and have the adult child be interviewed.
Yes.
So it's your understanding that Mr. McBride advised SBI to do that interview?
That's my understanding.
Yeah, that's gray.
Okay. You also testified on January 16th that you weren't really sure whether your office had a written policy for how to deal with either actual conflicts of interest or the appearance of conflicts of interest.
Yeah, I assume that they did, but I couldn't point to one at that time.
Okay. And then after the hearing, did you locate a written policy?
I did.
Okay. And at the time that you were discussing with the prosecutor whose adult child we're talking about, the fact that that child had been at UVU on September 10th and had witnessed many of the events surrounding Mr. Kirk's death, Did you actually consult that written policy back in October?
No, but I followed it.
Had you previously read it?
I'm sure I had at some point. I mean, it's a pretty standard policy. If there's a conflict within the office, then, or a potential conflict, then the attorney will notify us, we'll review it and decide whether any action is needed, if at all.
Okay, but when
And-
I
and
asked,
That's what we did.
when I asked you on January 16th, is there a written policy? Your answer was, I'm not sure.
Right.
No, he was asking about the guy on the stand. That is Gray,
There
the
was a
attorney.
subpoena for documents that you received and complied with over the last week or so, correct?
Yes.
Okay. And one of the things that we asked for in that subpoena was any memoranda or writings that memorialized how your office handled the potential conflict of interest.
As I understood the subpoena, it's any discussions regarding whether or not there is a conflict.
Right.
And so, yeah,
And so what I take from the return on the subpoena, if I could call it that, is that there isn't any memo to the file. There's no legal analysis. There's no memorialization of the decision that you made that there's neither an actual conflict or an appearance of a conflict.
no, there's not.
You mentioned when you were testifying at the last hearing that you are the president-elect of SWAP. Could you just remind the court what SWAP is?
SWAP is a statewide association of public prosecutors or public attorneys and prosecutors. It's basically a lobbying group with respect to legislative matters that affect prosecution.
As a lobbyist, that is the most
And
horrible
how long have you
name
been a member
ever.
of SWAP?
For about
As long as you can remember?
the 3 years that I've been county attorney, I've been a member, a board member of SWAP.
And are you familiar with a document that they produced called Utah Prosecutors Best Practices?
I know that they have that document, yes.
Did you consult that document with respect to what your office should do in connection with the
Of course they
potential
didn't.
conflict of
Come
interest or
on.
the appearance of a conflict of interest that we're discussing?
I don't believe I consulted it. I relied on my 25 years of knowledge of conflicts and so forth.
Okay.
Your Honor, what I would like to do, if I may, is approach Mr. Gray with a document that I'm just going to mark for identification as Exhibit I, and that's because we've previously marked for identification.
I gotta take my
A through
vitamins.
H, if I have my alphabet correct. And
Yes.
if I may pass one up to the court, I will, if the court needs that.
No, feel free to approach Mr. Gray and present Exhibit
thank you.
I.
I'm convinced that Nutrafol kept me from getting sick on my cruise because of all the vitamins in it.
Oh, I'm sorry.
Just gonna say that.
Have you seen this document before?
I've seen it, yes.
All right.
I mean, there's a lot more than just conflict in our best practices.
Absolutely, but we're just
Yeah.
going to talk about that, okay?
Yeah.
All right, so what I'd like to do is turn your attention to page 2 of that document, which has a whole section addressing conflicts of interest. Would you agree with me that it starts in the middle of page 2?
Yes,
All right. And you see what I'll refer to as General Standard 1.30, conflict avoidance.
yes.
All right, could you just read that aloud for the record, please?
A prosecutor should not hold an interest or engage in activities that conflict, have a significant potential to conflict, or are likely to create a reasonable appearance of conflict with the duties and responsibilities of the prosecutor's office.
What do you take to mean a reasonable appearance of conflict?
Maybe.
There has to be a real
I don't think so,
actual
though.
conflict, that there could be actually an appearance of that conflict.
And that would be in the views of the public, right?
That would be based on Supreme Court case law and case law generally.
But it's an appearance. What I'm asking you is, would you agree with me that there's an appearance to the public?
Yeah.
Objection. This calls
impropriety.
for a legal conclusion, Your Honor.
Witness,
Mr. Novak.
well, the witness testified that he's been aware of conflict principles for 25 years. So I think he should respond to that question.
I think this is a good argument to have with the court after the evidence has been presented, whether or not there's an appearance of a conflict, what that means. But I don't think the witness's opinion about it is evidence.
Well, I mean, I kind of think it is.
Thank you. I'm going to sustain the objection. Mr. Novak.
Understood.
Okay.
Mr. Gray, why don't you turn to page 3, and that would be standard toward the bottom. 1-3.3C. You see that?
The fact that they're in the same
Yes.
ward together
Okay, could you
really
read
bothers me.
1-3.3C aloud for the record?
If a prosecutor believes that public perception of the integrity of the prosecutor's office and public confidence in the handling of the case would negatively be impacted by a potential or alleged conflict of interest, the prosecutor should consider recusal.
You hear that, Judge?
All right, Mr. Gray, I want to ask you some questions about the decision to file a notice of intent to seek the death penalty against Mr. Robinson and the fact, which is beyond dispute, that a adult child of a member of the prosecution team was present at the shooting of Mr. Kirk. All right.
Yeah. Very close by.
I
You
can't.
state
It won't
in
let me,
your
Virgo. I'm sorry.
opposition.
I tried.
Well, let me back up. You testified on January 16th that you are the one who drafted the opposition to the motion to disqualify, correct?
Yes.
All right. So even though there's no affidavit by you, you stand by the contents?
Yeah, I said to the extent that we could either proffer that information or testify, and here I am.
Okay. So my first question is there a formal written policy or guidelines or procedure? I don't want you to get hung up on my nouns for when your office decides to seek or not seek the death penalty in a case.
Oh, that's not what I was going with.
Anytime that it's an aggravated murder case, there's a potential for that.
Okay, so I understand that because that's what the statute says.
That's right.
But my question is there a policy, a procedure, a protocol, something in writing?
No,
Okay. And is it your view that it's your decision alone because you're the elected county attorney?
yes,
Okay. And in this case, did you discuss that question, whether the state should seek the death penalty, with your team before that decision was made?
yes,
And did that conversation include the adult prosecutor whose child is the adult student at UVU we're talking about?
no.
Are you saying that prosecutor was specifically excluded?
No, maybe I misunderstood your question. I thought you asked whether or not we discussed her status as a
Then
as a
let me
witness
back
there.
up because it was a bad question if you didn't understand it.
Okay.
Those are the rules. Right? Okay. So
Okay.
you discussed with your prosecution team whether or not the state would seek the death penalty against
Yes,
whoever the state accused of committing that crime.
yes,
All right. And the,
I should back up. I mean, I don't know that we had a discussion before they actually had an arrest. I mean, that was 2 days later, but certainly in between the time that we filed and then we did have a discussion.
okay, so what you're saying, if I'm not trying to put words in your mouth, but just so the record is clear, is that after Mr. Robinson was arrested, your team had a conversation about whether or not it would file a notice of intent to seek the death penalty.
It was rather informal. I don't know that we all got together and said, what are we going to do? I would talk to different members of my team. But I had pretty much made up my decision. And so they knew where I was going.
Did you make up your decision before there was an arrest?
I thought that based on if we had the evidence that, yeah, we would be seeking the death penalty.
And you were already aware at that time that the child of one of your team members was present at that event, right?
Sure.
All right. Now, what you're saying is that and that you discussed that with all of the team members, even if informally.
As far as the death penalty?
Yes.
Yes.
Okay. And you didn't exclude from that
No.
conversation the prosecutor whose child we're talking
No.
about. That prosecutor was included in the conversation
Yes.
about whether to seek the death penalty.
Yes.
All right. And you're aware, because I think you were present, that there were a number of press conferences held by elected state officials both before and after Mr. Robinson's arrest, correct?
Yes.
Okay. The governor, who's a former licensed attorney in Utah, held a press conference on September 10th. Were you present there?
Probably. I was present at two different press conferences.
So there was one on the 10th and one on the 11th.
I know he made other statements as well, so I'm not quite certain. I know that I was at two different press conferences.
So when Governor Cox announced at a press conference that the state was going to seek the death penalty, had you already told Governor Cox that that was your decision?
I believe his statements, the only thing that I can remember of his statements is he said, by the way, or something to that effect, Utah has the death penalty. And so that's the one statement that I'm aware of. I mean, it wasn't exactly a demand for the death penalty, but so, I mean, the death penalty, ultimately, I made my final decision by the time we filed charges, if that's.
And
Okay, but
that's
the question
why
I asked you was, had you discussed with the governor your intentions?
At some point, I did. I
people-
told the governor that I intended to seek the death
And was
penalty.
that
Stop
before
operating.
Mr. Robinson was arrested?
I don't recall if it was before or after.
Okay, I'm going to represent to you, and we can file an exhibit on this in a bit, that on September 11th, the governor said at that second press conference, we are working with our attorneys, getting affidavits so we can pursue the death penalty in this case, and that will happen. And you were standing next to him when he said that, right?
I probably was.
Okay. Had you already told him that you've discussed this with your team and this is our decision?
I may have. I remember telling him that I would be seeking the death penalty.
So what you're saying, sir, is you never listen.
Or communication isn't your strongest suit.
Did you tell the governor that the child of one of the members of your office was present at the shooting?
No.
Did you tell anybody else in state government that the child of one of the members of your team was at the rally?
Not that I can recall. It just wasn't part of my thinking.
Okay. Are you aware whether the member of your team told the governor or anybody in state government about that?
I don't know. Certainly not when I was in the room with them that I can recall.
Now I'm going to ask you the same questions about federal officials. Did you inform any federal officials that one of your prosecution team members a senior member of your office, had a child who was there at the time of the shooting?
No.
Did you tell anybody in federal government or federal law enforcement that you were going to be seeking the death penalty before Mr. Robinson was elected? I'm sorry, before Mr. Robinson was arrested?
I mean, other than, I mean, when I talked to the governor, Kash Patel and Dan Bongino were there as well, so they heard my statement that that's what I intended to do.
Okay. And were you aware that before you filed that notice, the President of the United States went on national television and said, I hope he gets the death penalty?
I mean, of course, he said
I
that.
had heard that he said that, yes.
That was before you filed the notice?
Yes.
All right. Now, you stated in your briefing that your decision to file the death penalty notice when you did was partly because you ran for elected office 3 years earlier on a commitment to seek the death penalty.
Yes.
Oh.
So you made a commitment. Sometimes we call that a campaign promise. I'm not trying to make light of it, but that is what we frequently call commitments that we make to the voters, right?
It was a commitment that I would seek the death penalty in all appropriate cases.
Okay.
And you knew before you filed the notice that the governor thought it was an appropriate case,
Yeah,
and the president thought it was an appropriate case.
yeah.
Did Mr. Patel express his views?
Not that I recall. I mean, he was doing the bidding of the president, so, but I did find it a little interesting, Governor Cox, because he plays no part in the decision. So,
Did you tell Governor Cox after he made those public statements, this is not your decision, this is my decision?
no,
Who would say that?
Was it important to you that the people you selected to be on the team for this prosecution remain on the team? I mean, you handpicked this team, right?
I did handpick this team.
All right. And the person whose child we're talking about is a longstanding, experienced senior member of your office,
Yes.
right?
Yes.
It was important for you that they be part of this case.
I want the best people on my team, and I believe I chose the best people.
May I have a moment?
Of course.
Of course. We love you. Of course, brethren.
Thank you, Your Honor. We have no further questions for Mr. Gray. And if I may, what he told me is that he, after the examination, I assume that there's some cross-examination, he'll be available to be on call, so we don't need the court to address that with him, but he's going to leave the building, which is fine with us.
Yeah, but I'll be available to come back if needed.
Thank you, Mr. Gary. Thank you, Mr. Novak.
Thank you. And I'd just like the record to reflect that it's 5 minutes after 2 when I've concluded my direct.
I appreciate that.
Did you?
Not yet. Not yet.
To the state, Mr. McBride.
To the state. Sorry for all that.
I'm going to refer
memory.
to the prosecutor in your office whose child was present at the shooting as Prosecutor A. Do you know who I'm talking about?
Yes,
Have you ever met Prosecutor A's child that was present at that shooting?
not that I could remember. I could have in passing, but not that I can remember.
Did the presence of Prosecutor A's child have any effect on the decisions you've made in this case?
0.
Did that child's presence have any effect on your decision to seek the death penalty?
0.
Why did you choose to seek the death penalty in this case?
Because the evidence that had been gathered supports the aggravated murder charge, and I believe that the death penalty is entirely appropriate in this particular case.
Sorry, guys. I'm adding tags to this video.
On September 10th, you've testified that you learned that Prosecutor A's child was present at the shooting, correct?
Yes.
Did her presence affect the decisions you made on September 10th at all?
No.
Will you describe how her presence affected your decision-making on that day and in the few days following before you charged?
It had no effect whatsoever. I mean, quite frankly, as I think I testified earlier, I didn't even give it a second thought after I was told about that.
There's been some question about the reason you chose to seek the death penalty at the time you did. Now, the law in Utah allows you to wait to announce the decision to seek the death penalty until after arraignment, correct?
Yes.
Why did you give the notice of intent to seek the death penalty at the time you did rather than waiting?
I had learned from experience in a prior case, in particular, the Michael Jane case, that in a highly publicized case, the longer that you delay that decision, even though, I mean, I may very well make the decision early on, and I have in certain cases, but the more delay, then it just creates all this unnecessary public speculation and everything else. And we actually, in the Michael Jane case, I went to my attorneys and I said, yeah, we usually wait. But so I was waiting, but then Channel 2, I believe it was, contacted me and said that they had learned information that we were taking the death penalty off of that case.
Okay.
And so I had to hurry and call them before that, say that's not true. And within a month, I filed the death penalty. But it creates unnecessary angst with families of victims.
I'm almost done.
I knew that this particular case was, I mean, talk about publicity. It's even more so in this case than it was in Michael Jane case. And I wanted to shut that out so that we didn't have to deal with that. And so that Erica Kirk didn't have to deal with that uncertainty.
Okay, as you made the decision in this, so that's the reason you made the decision at the time you did.
Yes.
Is that right?
Yeah.
To avoid that uncertainty, speculation, and so forth.
Okay, groovy. I'm done.
Yes.
Was that decision made because Prosecutor A's child was present at the event?
No.
Keep asking, keep getting the same response.
You talked about a campaign promise. When did you run for county attorney and make that campaign commitment to voters that you would seek the death penalty in appropriate cases?
It was,
What year?
it was about 4 years from this very time.
Okay.
So
At that time, did you know Prosecutor A?
I knew of him, but I mean, because I had handled,
Had you met him personally and interacted with him personally? Or
No.
You just knew who he was?
Yeah.
Okay.
I mean, at some point after I won the election, I met with him and others to determine who.
Understood. But at that time, when you were making that campaign commitment, was it because you knew Prosecutor A?
No.
Okay. Was it because Prosecutor A had an adult child?
No.
Okay.
Oh my God.
Decision making. As far as the decision making in this case goes, who makes the ultimate decisions on major decisions in this case?
I do.
Does Prosecutor A, does the buck stop with Prosecutor A?
No.
Almost done.
There's been some evidence that deputy county attorneys in your office went to the command center at Utah Valley University on September 10th and the days after that.
Yes.
Is that a normal process?
Yes. In any homicide case or big case, we'll have attorneys respond to the command post to offer any assistance that may be needed, which may include search warrants or discussions about the need for certain evidence.
So having attorneys appear at Utah Valley University that day was not unusual?
How many? I mean,
No. My question is, having attorneys
yeah,
appear
no,
at the
not unusual at all.
do you know which attorneys went?
Yes, I know that I went, Mr. Grunander went, you went, Ryan McBride, and David Sturgill went. And I don't believe any others. Somebody else may have gone there for a short period of time, but I don't recall seeing them there.
Did those attorneys go there because Prosecutor A's child was present?
Not to my knowledge, no.
Aside from charging, have many major decisions, aside from charging and the notice of seeking the death penalty in this case, have many major decisions been made in this case?
I mean, major decisions. No, I mean, what comes to my mind is one major decision was to make sure that defense counsel gets discovery in a timely manner. That was, quite frankly,
I like you.
foremost on my mind once we filed the case. And I personally directed procedures to be put in place so that there would be no mistake as to what the defense counsel received and what we had. I mean, every time there's a motion, obviously the team is working on it. We work on it together. But I mean, as far as trial strategies or things like that, none of those decisions have been made.
Is it fair to say that aside from charging and the death penalty decision, is it fair to say that the most important decisions are yet to be made in this case?
Yes.
And that includes trial strategy,
Yes.
preliminary hearing strategy,
Yes.
any plea negotiation.
Yes.
In all the decisions that have been made up to date, has Prosecutor A's child come up in those decisions?
No.
I should say, aside from this motion.
Aside from this motion, yeah.
And so aside from this, I'm going to ask that question again to make sure the record is clear. Aside from this motion to disqualify the Utah County Attorney's Office, has Prosecutor A's child come up in any of the decisions made in this case?
No.
Okay.
Has Prosecutor A's involvement in this as a witness here affected the prosecution in any way in this case, in your opinion and observation?
No.
Do you believe it will affect the prosecution in the future?
No.
Why not?
Because I mean, this is somebody that happened to be there. What we're concerned about is the evidence supporting the charges.
That guy has a deviated
That's
septum.
first and foremost.
Do you hear it?
And that has nothing to do with somebody that happened to be there. I mean, quite frankly, completely irrelevant to anything that matters in the case.
Okay. A couple other follow-ups. Earlier, you testified that Prosecutor A received you were with Prosecutor A when Prosecutor A received a message from his child that Charlie Kirk had been shot.
Yes.
Is that right? And then you testified that Prosecutor A left to go to the scene. Do you know why Prosecutor A left? Was it to go to the scene and help law enforcement or to be with his child?
To assist in any way we can with law enforcement.
Okay. You previously testified that you did not consult the Attorney General's office about whether or not this was a conflict of interest that would require your office to leave the case or to refer the case. Why did you not consult the Attorney General's office?
Because what they would have done is, researched it and then come back. And I've done that for, over 30 years in my practice. I'm capable of doing that.
I researched it where?
Case law and so forth. Again, I mean, I do not believe that
Everyone's
there's
entitled
any
to their own
conflict
opinion.
whatsoever. I made that conclusion. I stand by that. I mean, out of an abundance of caution, we certainly notified counsel out of an abundance of caution. And I think that's the appropriate action to take. So again, I understand what the concern about conflict is whether or not it has any possibility of affecting your decision-making as a prosecutor. And I didn't see how this does in any way.
Okay, if I can have just a moment.
Always. Hello, Riley. Would you like to come up here? I have a puppy here.
You said you had some neighbors that had children that attended the event where Mr. Kirk was shot.
I was told that they were there. Yeah.
When did you learn that those people were there?
I don't know, a couple weeks after, I believe, after the event.
After the charging decision was made?
Yes.
How closely do you know the children that were there?
Not well at all.
Okay.
I mean, maybe a hello or something out on occasion. But as far as I know, I'm not even sure that they even live in our ward at all at this point.
See?
Okay.
See?
Thank you.
All right. Mr. Novak.
No, thank you, Your Honor. I don't have any redirect at this time.
As previously discussed, may Mr. Gray be excused?
For now, yes.
Thank you. Thank you, Mr. Gray. Mr. Novak, your next witness? Or I'm sorry, Ms. Nestor.
Your Honor, at this time, we were going to call the adult child, but I believe that individual's attorney, they're ready? Okay, then they are ready. So we would like to proceed with calling the adult child at this point.
They just said her name.
I think it would be appropriate to hear whether or not we close the hearing or at least come up with some ground rules about preventing any photography or.
Well, you just said her name,
how
so.
the court desires to handle it.
Thank you. I'll hear briefly from the parties. I did read the proffer of facts regarding the closure of portions of the evidentiary hearing on the motion to disqualify the Utah County Attorney's Office. And I'll hear any additional argument or statements prior to making a ruling.
Your Honor, Ryan McBride for the state. We do move to close the hearing for the testimony of the adult child. I think the rationale that I explained previously still stands. The rules of judicial administration allow closure for privacy and safety reasons. I believe with the proffer of facts that the defense has accepted here, we
She's
have
not a
shown that
child.
there are privacy and safety reasons that favor closing the hearing. Defense counsel has stipulated a closure of this portion of the hearing. The media in the past has stipulated to closure of the hearing. I think the record is adequate. I think the safety concerns support closure. And absent any questions from the court, I would make that motion now.
Thank you. Anything further from the parties?
No objection, Your Honor.
All right. So the prosecution cited to the media. Did you want to weigh in?
He does not object to the closure of this court.
Thank you.
This is unbelievable.
The court has reviewed the parties' prior arguments and materials submitted in advance of today's hearing, including the filing entitled Proffer of Facts Regarding Closure of Portions of the Evidentiary Hearing on the Motion to Disqualify the Utah County Attorney's Office. The defense has requested that the testimony of certain witnesses, specifically Prosecutor A and adult child witness, be received in a closed session pursuant to Utah Rule of Judicial Administration 4-202, citing concerns related to personal privacy and safety. The court acknowledges that Rule 4-202 permits limited closure of court proceedings in appropriate circumstances. At the same time, this court is required to consider countervailing interests identified in Rule 4-202, including the public's right to observe the conduct of public business, to understand the operation of government and maintain confidence in the judicial process. This court must also be mindful of the constitutional rights of Mr. Robinson, as well as the constitutional and statutory rights of Ms. Erica Kirk in her role as victim representative. The purpose of today's evidentiary hearing is limited and specific. The court is asked to consider the defendant's claim that a member of the prosecution team, referred to as deputy county attorney in one of the motions, has a personal conflict of interest, that any such conflict extends to the Utah County Attorney's Office, and that disqualification is therefore required. The court's role at this stage is to receive relevant evidence and to rule based on the record and applicable law without reaching the merits of those claims in advance. The parties have filed public motions outlining the anticipated evidence and testimony related to the motion to disqualify, including the state's opposition, the defense reply and request to take evidence, and the defense original motion. Those filings describe the general subject matter expected to be addressed at today's hearing. If the adult child witness is called to testify, which is the request at this point, the court will consider that testimony as part of the evidentiary record. After careful consideration of the record, the arguments of counsel, and the interests identified in Utah Rule of Judicial Administration 4-202, the court finds that closure of the adult child witness's testimony is not necessary and would not be narrowly tailored under the circumstances presented. The court further finds that the interests of openness and transparency outweigh the asserted grounds for closure as to that testimony, and that the rights of the parties and witnesses can be adequately protected through least restrictive means available to the court. For those reasons, the request of both the state and defense to conduct the adult child witness's testimony in closed session is partially denied.
Do you like him?
The court acknowledges that Utah Rule of Judicial Administration 4-202 permits limited closure of court proceedings in appropriate circumstances, and also acknowledges the concerns raised regarding the personal privacy and the safety of the adult child witness. This court's responsibility is to balance those concerns with the constitutional rights of the parties and the strong presumption in favor of open and transparent judicial proceedings. Therefore, the court finds that a brief and narrowly tailored procedure is appropriate to address these competing interests. Accordingly, the courtroom will be temporarily closed, and all parties and members of the media will be excluded for the limited purpose of calling the adult child witness to the stand to state identifying information. Once that limited portion of the proceeding is complete, the courtroom will be reopened and members of the public and the media will be permitted to re-enter. During the testimony of the adult child witness, no audio or video transmission will be allowed and no photographs of the witness will be taken. At the conclusion of the adult child witness's testimony, audio and video transmission of the hearing will resume and will continue through the remainder of the proceedings. The court finds that this procedure is narrowly tailored, uses the least restrictive means available, and appropriately balances the interests of witness safety and privacy with the public's right to observe these proceedings. We will proceed accordingly. We will take a brief, we will go ahead and clear the courtroom and go into a closed session. And the only remaining parties will be the attorneys, and we will take it from that point. Court will be in brief recess for 2 minutes.
All right.
Okay, so what we're going to do, I'm going to keep this on in the background so I can hear when something happens. But I'm going to put something else up. And I have an idea. I just want to make sure that hang in there with me, guys. Just trying to talk and do two things at once. Blah, 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 blah. Where did it go? There's so many things going on right now. It's wild. Okay. We are going to watch this.
Trying to access the documents for the same purpose of moving this case forward. And it's been difficult. And so now we're put in the position of trying to take what has been produced and get an e-vendor involved, which is going to cost more money, of course, but we're getting an e-vendor involved, just as Mr. Diller is, to try to better access these documents. And then I would just.
This is the hearing that took place regarding the Karen Reed wrongful death lawsuit. So I figured we could watch that while we are waiting for the hearing with Tyler to start again.
Just say to, from what I have been able to see with the 518 videos, they're not, as far as I can tell, categorized in any way. My operations manager has told me that we can see that there's driveways, there's Ring doorbells, there's some body cams, there's cars backing up, which I can presume is Ms. Reed's. There's some audio files that sound like they're coming from dispatch, but nothing is date and time stamped. We're having a difficulty sort of trying to weed through it and discern what is relevant.
Bye.
And what is not
Have a great
relevant
one
from those videos.
Come
and then
back
with
soon.
respect to the folders that I believe Mr. Rosenberg has referenced, we're having a hard time opening those as well. They seem to be either corrupted or not in a proper archive format, to the best I understand what my technical people have told me. So I can just say, Your Honor, we are having some similar difficulties that we would love to get past with the cooperation of all parties in the court.
What depositions, if any, have been noticed by CNC?
We have not noticed depositions for two reasons. One, there will probably be very few from us, Your Honor. But two, we want to only notice depositions that we truly intend to take and are not duplicative of other parties. So we have talked with Mr. Diller and conferred with him on the short list of folks that we would anticipate that we would like to depose. And frankly, we've also talked to counsel for Waterfall about this. And then, of course, Mr. Diller has talked to me about some of the folks at McCarthy's that he would be looking to depose. But on both sides, it's a relatively short list, Your Honor. And as soon as we get through these documents, we are in a position to proceed with that type of discovery and with depositions.
Thank you. Why don't I hear from Waterfall, please?
Thank you, Your Honor. David Hassett. Judge, we have responded to the plaintiff's discovery, interrogatory answers, and document responses. We've also propounded discovery to the plaintiff and to the individual plaintiffs identified in the suit. That discovery is outstanding by agreement. As to the documents produced, we also have not yet commenced deposition. The documents that we have gotten through the discovery to date, we've been working through and expending efforts to get to the documents, understand the documents. We've had some challenges, but we've been trying to implement some workarounds, but that is not completed yet. And we also have a discovery e-vendor that will be assisting us in the pursuit of getting our arms around all those documents. We have been in discussions with Attorney Diller and Attorney Smith about the depositions we would be taking. There are obviously some overlap with the depositions that the Reed team would be taking and the O'Keefe team, but that the separate depositions of patrons or witnesses, we conferred about those. I agree it's a relatively short list, and the hope was first to review the documents before starting that process.
Wow, this is
Do the challenges you have encountered include the inability to access the documents produced?
Not all of them, Your Honor. We have been able to access documents, but we haven't been able to access all the documents. For instance, some of the folders that were described by Mr. Rosenberg and Mr. Diller, they will open up and they'll be blank, there'll be nothing in there, or they're corrupted. I believe we've had some communication with Mr. Rosenberg's office about some access to files in our own IT support internally. So what I would say, Your Honor, based on 990,000 pages, there is a percentage that we haven't accessed properly or completely. One thing I will also add is that there is a load file that we recently received that has metadata. It appears that that will assist in terms of accessing documents or files that we've struggled with. So that's something that we intend to do next.
When did you receive that?
I think it was in the last week, Your Honor.
Okay.
Your Honor,
Thank you.
can I just note, Your Honor, I haven't heard from either of the two bars about these issues. I'm happy to work with them, just like I've been working with Mr. Diller to have these documents assist with whatever technical issue that they're having. I just haven't been aware of those yet. So if they reach out to me, I'm again happy to help with that. But I understand there is a lot of paper here, and there is a need for e-discovery vendors because primarily the plaintiffs have asked for all of these million pages of documents. So I understand why all of the parties are explaining the need to access things in order to go forward and proceed even further with discovery. But I just want to be clear,
please.
there, to the extent there's any technological issue, parties need to reach out to us and let us resolve those, which we will do.
But the common theme seems to be that they're all having some difficulty.
Well, I agree with you based on what I just heard, Your Honor, but I'm not aware of that until just this moment. The only party I've conferred with about these issues is Mr. Diller, and we've been talking about it for...
Thank God. Thank you, maybe. That was miserable. All right. This, so this case actually means a lot to me. I have been entrenched in learning about this case since it happened. I was in high school, and I vividly remember it. I've seen all the 48 hours and Datelines, and I had no idea that they had found that DNA had led to a suspect. So when I found this out yesterday, when I saw like that the case was moving forward, I freaked out. Like, this is incredible. So I'm really excited. Excited is a strong word, but I'm really looking forward to sharing this with you. So I hope that it's received well by you guys, but let me know. I'm always open to recommendations and suggestions. Thanks. I hate that they don't provide time stamps. It's really low audio. That's not mine. That's them. So did they just not do opening statements live? Edrick Faust opening statement. Okay, I found it on another.
She was strangled and she was left for dead on her bedroom floor. Her bed was set on fire. A fire, ladies and gentlemen, that smoldered for a considerable amount of time before it finally erupted through the roof of the house that she shared with two friends at 160 Fawn Drive here in Athens, Clarke County. On that morning, Tara's life ended. And what started was a 2.5 decade long saga that has hung over the Baker family and hung over this entire Athens community like a specter. Ladies and gentlemen, this trial represents the final chapter in that tragic saga. The chapter where the state will prove to you beyond a reasonable doubt that the defendant, Edrick Faust, is guilty of extinguishing the bright light that was Tara Louise Baker 25 years ago, where the state will show that he is guilty as charged of the crimes in this indictment. So you've heard the indictment a few times by now. Judge Lott read it in its entirety at the beginning of jury selection. The judge also just went briefly over what the charges are again here this morning. I'm not going to spend too much time going through the indictment itself right now. There will be a time and a place for that at the end of the trial. But again, ladies and gentlemen, you know now that the defendant, Mr. Faust, is charged with 12 counts. Count 1, malice murder. Counts 2 through 5, felony murder. Count 6, burglary. Count 7, aggravated sodomy. Count 8, rape. Count 9, aggravated assault. Count 10, aggravated sodomy. Count 11, arson in the first degree. And count 12, possession of a knife during the commission of a felony. All those charges stem from the morning of January the 19th, 2001. And I expect that that's going to become clear over the course of this trial. Ladies and gentlemen, these are obviously heinous crimes. And in order to prove them, and to prove that the defendant is the person who committed them, the state is going to have to present some very grisly evidence. And that's going to come in the form of both testimony and photos. Ladies and gentlemen, some of this trial is going to be difficult. But it's unfortunate, but it's necessary. I just wanted to give you a heads up. On January the 19th of 2001 at 11:22 a.m., Athens 911 started receiving telephone calls in the area of Deer Park regarding a fire at 160 Fawn Drive. Now, if you're not familiar with Deer Park, just to give you a little bit of reference, if we had, make sure I've got my orientation right, down Lexington Road, away from downtown, heading out towards Oglethorpe County. When you get past, Gaines School, Tuxton United Methodist Church is there on the left, right off Lexington. And the road immediately past Tuxton United Methodist Church, before you get to the Walmart, is Cooper Road. So again, heading that direction from downtown, left on Cooper Road, past the church. And then actually Deer Park, which is where Fawn Drive is located, is just on the right. And so when they get this call at 11:22 in the morning, the fire department is immediately en route. The firefighters actually kick in the door, the front door to Tara's house because it was locked. And when they did so, they encountered smoke in the main living room area of the house. And I'm going to, in just a few minutes, not yet, going to be able to show you what the inside of that house looked like. So these firefighters kick in the door, and the first thing that they notice, apart from the smoke, is back in the right corner, which is where the kitchen is located. Through the smoke, they can actually see the eyes of the stove. It's one of those old school stoves that has the circular heating element. They can see those glowing red. And so through the smoke, they go over there to the stove. They realize that the knobs that would turn on and off those eyes have actually been removed from the stove itself. And so the firefighters put those knobs back on and turn the stove off. They opened the back door to the house to ventilate, to help start getting the smoke out of the room. To this point, I don't think.
Hey guys, I'm going to make sure, let me restart that. I am going to get Old Man Riley's dinner together really quickly. So I am going to put this on. And once again, we are waiting for the Tyler Robinson trial to resume. If you could make sure to please like this stream by giving it a thumbs up. Subscribe to my channel if you aren't already, because it's free. And yeah, I'm doing a giveaway, a bunch of giveaways next week. So there's a Google form link in the chat that is pinned. If you fill that out, you will be entered to be on the prize wheel. And yeah, good deal. I'll be about 8 to 10 minutes. Thanks, guys.
They've completely ascertained exactly where the fire was coming from. The back left bedroom of the house, and there's actually a bathroom door right next to it. It'll make sense in a few minutes, are closed. And so they go over there and they kick those doors in as well. And when they kick open that bedroom door, they are immediately met with flames rushing out over their heads. Firefighters enter and extinguish that fire. And in that moment, ladies and gentlemen, they discover Tara. She's naked. She's in between the mattress and the footboard to her bed. The footboard had been ripped away from the bed frame itself. So she's in that little V-shaped space in between. They notice a computer cord, what appears to be a computer cord, is wrapped around her neck. And so realizing what they've seen, the firefighters back out and turn the scene over to the police. And law enforcement does arrive. And so what we have here, ladies and gentlemen, is a sketch made by Athens Clarke County Police as to the interior of 160 Fawn Drive. I won't spend but a couple minutes going over it. The front door here is at the bottom with the arrow pointing up. Again, you see the kitchen in the back right with the stove, which is what the firefighters reported seeing glowing red when they came in the door. And what I want to focus on is what's in the top left of that diagram, what is referred to as bedroom 3. That was Tara's room. And you can see bedroom 3 has a bathroom connected to it, and then there's a door leading both from the bathroom, a door leading to the living room, and one leading into Tara's room. So that's the basic layout of 160 Fawn Drive. You can see there's a back door, which again has the arrow pointing down. And right next to that is a window that is situated right above their dining room table. You're going to see photos that will also help kind of explain the layout of 160 Fawn Drive. So that's the house as a whole. And this is Tara's room as the police encounter it. And again, I've tried to explain, but I think this does a better job showing exactly the orientation of her body inside that bedroom in the back left of 160 Fawn Drive. So again, you can see the footboard having been ripped away from the frame and her body lying in between. So upon arrival, Athens Clarke County Police starts processing the scene. I expect you're going to hear from a number of witnesses that Tara's body, despite having obviously been in a room that was consumed by fire, her hair was actually still intact. I expect you're going to hear that several witnesses actually recall the smell of shampoo still coming from her hair. Again, there was a printer cord wrapped around her neck. I believe the printer itself was there in the room. And there's one thing that the police noticed that firefighters hadn't, was that Tara actually had a stab wound to the right side of her neck. And I think it was on the diagram, the knife was right underneath her body with blood on it. Officers also noticed a clock on the wall in Tara's room. That clock had stopped at 9:32. In processing the scene, officers noted that it appeared as if the doors and windows had been wiped clean. There's a screen to the back, that back window, the one that's right next to the back door, that showed signs of having been tampered with. And I expect there's probably going to be some confusion about exactly where that screen was when the firefighters arrived and when law enforcement arrived, but we'll get to that. Ladies and gentlemen, at 160 Fawn Drive, I submit that the evidence is going to show that any physical evidence that could have conceivably been helpful was collected. As an example, I think you're going to hear they even took the drain assembly out of her bathtub. A little bit more about the fire. I expect you're going to hear evidence that the bed, Tara's bed, was the source of that fire. And a little bit more, actually, I expect you're going to hear that there was a blanket that had been in the living room on the back of a recliner. That blanket had been removed from the recliner, taken over to the stove, set on fire, and then thrown on Tara's bed. I expect you're going to hear that there's actually still some remnants of that blanket on the stove itself. In learning about the processing of the scene, I expect you're also going to hear that there were no fingerprints of any evidentiary value that were taken in the house or off of Tara's body. I expect you're going to hear that hairs were collected from her body and from her room. And I also expect you're going to hear that her laptop was missing. The next thing I want to talk a little bit about, ladies and gentlemen, is the canvas of the neighborhood. By canvas, I mean police getting out and knocking on doors and seeing what, if anything, people had seen that morning. That was obviously done in this case to a significant degree. I expect you'll hear one witness recalled seeing a white male running in the area, open area behind Tara's house and near Tara's house around 7:45 that morning. I expect you're going to hear multiple witnesses talk about describing a black male with an orange shirt or sweatshirt at various places in Deer Park around 8 o'clock to 8:15 that morning. I expect you're going to hear one witness who described smelling a faint odor of smoke as he was leaving for work around 8:40, 8:45 that morning. At the time, ladies and gentlemen, there's just not much to go on as it related to that canvas. The next thing I'd like to talk about is the autopsy. Tara's body was taken over to Atlanta to the Georgia Bureau of Investigation's Department of Forensic Sciences the next day, Saturday the 20th, her birthday. And an autopsy was conducted by a medical examiner named Dr. Andrew Faust. And here's where the evidence I submit maybe get kind of difficult. There were photos that were taken at that autopsy. And you're going to see some of those photos when Dr. Faust testifies. It's going to be hard. You're going to see and hear about contusions surrounding Tara's vagina and anus. You're going to hear that stab wound that the officers noted when they got in to her bedroom had actually severed her jugular vein. You're going to hear about the ligature mark that was encircling her neck, and that her hyoid bone, which is a bone in your neck, had been broken. You'll hear about a subarachnoid hemorrhage to her head, which is indicative of blunt force trauma. You're going to hear about defensive wounds, defensive type wounds to her hands. Dr. Falzon, after conducting the autopsy of Tara Baker, listed her cause of death as ligature strangulation and a stab wound, with another significant condition being blunt force trauma to the head. He ruled the manner of death, obviously, a homicide. As part of the autopsy, a sexual assault kit was taken based on the way Tara's body was found, based on Dr. Falzon's observations. So a sexual assault kit involved oral, vaginal, and rectal swabs of Tara and smears that were created based on those swabs. And I expect over the course of this trial, there's going to be a great deal made about how one of those swabs was mislabeled. I expect the state's going to be able to clear that up as this trial unfolds. As part of the autopsy, head hair and pubic hair was retained, and fingernail and toenail clippings were taken. The next thing of significance that I'd like to talk about is some of the early forensics that were done in connection with this case. You're going to hear from Jennifer Corsi. At the time, back in 2001, Ms. Corsi was a forensic biologist at the GBI Crime Lab. She actually now works at the U.S. Army's Criminal Investigation Laboratory. She made a career
Oh, my
out of this
phone
type
is
of work.
updating.
Ms. Corsi is the one who actually did chemical testing on that sexual assault kit, the one that we just talked about.
Okay.
You'll hear that her testing failed to reveal the presence of any seminal fluid, and that she took microscopic examinations of the vaginal smears and observed no spermatozoa or partially intact spermatozoa. And so, ladies and gentlemen, based on the existing technology and the existing protocols in existence back in 2001, there was nothing further that could be done with that sexual assault kit. I expect you'll hear that Ms. Corsi, then Fincher, so if I use both names, please forgive me, did confirm that the blood on Tara's fingernails, the only DNA in that on those fingernails belonged to Tara, that there was blood on the knife, and the DNA from that blood also only belonged to Tara. And there was no blood on the toenails that were taken. Not necessarily Ms. Corsi, but other forensics going on in the early days of the investigation. There were attempts to
There's still nothing going on in the
fingerprints of any
Tyler
sort of evidentiary value, nothing to
Robinson
go on.
trial.
I mentioned the hairs. Submit to you, there was nothing that would help in the investigation at that time. I'm going to shift gears a little bit and talk a little bit more about Tara. In January of 2001, again, she's living at 160 Fawn Drive. She had two roommates, Ashley Peavy, now Ashley Hall, Valerie Lowe, now Valerie Lang. And I say that because, again, I might refer to them as both. I just wanted to get out in front and explain why that might be the case. So the three of them, Tara, Ashley, and Valerie, had moved into 160 Fawn Drive in August of 2000. All three of them were in grad school at UGA, but pursuing different programs. Tara obviously was studying law. I expect you're going to hear evidence about Tara's morning routine. If she had a 9:30 class, which I expect you're going to hear she did that Friday, property law class on the 19th, then she was a pretty early riser. Up around 6:30 in the morning. First thing she'd do is take a shower. Expect her here. She'd come out and eat her breakfast. Every morning, same thing, cheese grits. And she'd come out and eat those cheese grits, her hair's still wet.
Yes,
And then she'd
girl.
go back into her room and sit on the
Cheese
floor in front of the
grits.
bed to blow dry her hair. And it took a while, ladies and gentlemen, because I expect you're going to hear Tara had a lot of hair. I expect you're also going to hear about how Tara was trying to buckle down in January of 2001. As that new semester in law school had gotten underway, she was spending less time at home and more time at the law library. But Saturday was her birthday. And on Friday night, she was going to go out and have some fun with some friends. They were going to go to the Winery, which is a bar downtown on Broad Street. I don't know if it's still there, but it was in 2001. But talk about Tara's last hours. Go through what we know about Tara on Thursday, January the 18th. We know that both Ashley and Valerie were leaving for the weekend. They were both leaving that Thursday. Ashley left late that afternoon. She and Tara had been at home together before Ashley left. We know that from approximately 7:30 to approximately 9:30, Tara was at the law library here on North Campus, not too far from the Arch. She's there with a friend named Katie Lonstein. Around 9:30 that night, Katie leaves, goes home. I think there was a discussion about, hey, call me when you get there, make sure you get home safe. And Katie indicated that she would do that.
Please make sure to like the stream.
Why is
Thank
that
you.
significant? Because Tara called her. Tara called her at 9:46 that night to make sure Katie had gotten home. And ladies and gentlemen, that is the last time that anyone is known to have spoken to Tara. Friday, again, January the 19th. I think it was kind of a cold, overcast, rainy day, kind of day that it seems like we've been having a lot of those lately. Again, expect you're going to hear evidence that the neighbor across the street smelled smoke, excuse me, around 8:45, 8:40 as he was going to work. Point out once again, Tara misses property class. It started at 9:30 that morning. The clock on the wall stopped at 9:32. And then again, ladies and gentlemen, 11:22 is when the fire
Focus
is
of the
reported
fire.
at 160
Got it.
Drive. I'm going to talk a little bit now about Chris Melton. Some of you have heard his name already in jury selection. Chris Melton was Tara's boyfriend. You're going to hear a lot about the relationship between Tara and Chris leading up to January the 19th of 2001. What I expect that you're going to hear is this was a relatively typical relationship between two very busy people in their early 20s. Tara and Chris met when they both attended college at Georgia College in Milledgeville. It's now Georgia College and State University in the late 90s. Tara and Chris were introduced through mutual acquaintances and hit it off, and they began to date. When Tara graduated from Georgia College, she went back home to the Lovejoy area. And for those of you who don't know, Lovejoy is off I-75 south of Atlanta, and she got a job at a law firm there. Chris didn't finish school. He also moved back home in with his parents as well. That's in Covington. When Chris moved home, his mom told him he had to get a job. And so he got one. Chris became a plumber. And so at this time, Tara and Chris are in a long distance relationship because Covington, Lovejoy, about an hour and a half apart, maybe a little bit less. Tara moved to Athens, I believe in 1999, when she got a job at a law firm here in town. So at that time, Tara's in Athens, Chris is still in Covington, and so they're still kind of doing the long distance thing, right? Maybe not quite as long, but certainly not in the same town. And they found it hard to find time to get together. And so Chris moved to Athens. He got an apartment with a roommate at a place off Millage Avenue. And he was commuting back and forth to work. Most of his work was in the Loganville, Gwinnett County area. But I expect what you're going to hear is that Chris and Tara were trying to figure out how to have an adult relationship. I started law school in August of 2000. I expect you're going to hear that during that fall semester, that first semester, Ashley and Valerie are going to mention to you that Tara was spending a lot of time.
I need to mention something because it's going to drive me crazy if I don't. In case you haven't heard this, TMZ received a ransom note for Savannah Guthrie's mom, Nancy, as well as a local TV station. And they have provided information that either there is a leak in the police department, which, that can happen, or this is the real deal. But they provided information that validates that they know information that is being kept private right now, that only someone who was there would know. I know we're all thinking like, oh my God, but it's TMZ. I have found TMZ, they have reported on things without having like secondary sources, which is not journalistic integrity to its fullest, but they've also been right about an annoyingly large amount of things. I don't watch them regularly, but it seems like it's like the real deal. I don't know what your guys' thoughts are on it, but I felt like I had to mention it because this is wild.
In Chris's apartment. Now, that doesn't mean Chris wouldn't come over to her house too. He did, maybe just not as often. But when they did, they'd spend the night at each other's house, both at Millage
Like
Avenue
Case,
and
maybe.
at Bond Drive. This is normal relationship stuff. Moving into the spring semester, January 2001. Now remember, Tara was trying to buckle down. More time in the library. Well, at that time, Chris also had good things going on. I mentioned that he had taken up plumbing. He was working for a company, but around this time, he started maybe thinking about going out and doing work on his own. You know, his business was mainly in the Loganville, Gwinnett area. And so at this time, you know, he's using his truck, not a company one. It's his gas, his time spent commuting. And if he's traveling back and forth from Athens to Loganville every day, he's not making money. And the reason why I point all that out, ladies and gentlemen, because I expect the evidence is going to show that at that time, Chris moved back in with his parents in Covington. So he could spend more time working and less time traveling to and from. Now, ladies and gentlemen, I expect that others might have thought that the relationship between Chris and Tara was starting to fizzle. Again, I think the evidence is going to show that this was just a relationship between two young people whose presence and whose futures were still being figured out, with some highs and some lows.
Okay, so if you are unaware about the case that we are watching, so Tara Baker was a law student in Georgia, and she was dating this guy, and it was long believed that the guy she was dating, Chris, like kind of like the prosecutor was just saying, their relationship was a little bit tumultuous, and it had some weird dynamics, to say the least. But she was supposed to go out that week or leave for the weekend, and she had been at the library earlier that night, and when she was at the library, that was the last time that anyone had seen her alive. And basically, she was found with her apartment on fire, and she had, I can't say all the words because I'll get dinged on YouTube, but she had been assaulted in absolutely every possible way imaginable. The guy is facing like 12 charges for what happened to her. And what makes it so unique is that they were, this is a very, very, very cold case. I mean, this happened in 2001. So there's questionable things that took place in terms of the investigation, but you have to realize DNA had just been around for like less than 10 years at that point. So it was, there's going to be a lot of inconsistencies, which is what the prosecutor is like trying to get ahead of by saying like, well, I suspect you're going to hear about this and hear about this. But that's like the short and skinny of it. If you guys have any questions about it, there were several datelines, 48 hours, 2020s done about this case. If I'm not mistaken, she the guy lived close to her, and I'm trying to see, I Googled it really fast. I'm just now bringing it up. to see if there's anything that I missed. It says like who the attorney is. But I don't know. I mean, honestly, how would they be able to charge him with all of those 12 counts if they didn't have like legit traceable evidence? It's going to be a really difficult case, I presume, for the defense to argue against. All right. So with that being said, we shall move forward.
But nothing out of the ordinary. In fact, I expect you're going to hear that Chris had gotten Tara a very sentimental Christmas present just a few weeks prior to her death, and it made her really happy. He was going to come to Athens Saturday to celebrate Tara's birthday with her.
And I have to mention, I went to the other school in Athens. I went to OU. So every time I hear Athens, it's kind of weird.
Chris saw the potential for a future between them. Others may have made assumptions otherwise. But the bottom line, ladies and gentlemen, is evidence will show you that there is nothing to suggest their relationship was in a bad place. Let's talk about what Chris was doing on January the 19th of 2001. As I just got done explaining, he spent the night before, Thursday night into Friday, at his parents' house in Covington. And from 7:15 that morning until long after Tara's body is discovered, his whereabouts are accounted for.
Also, please make sure to like the
7:15 or
stream.
thereabouts. A coworker,
Gotta keep
Josh
saying it.
McCurdy, came over to Chris's house, or Chris's parents' house, to be clear. And Josh was with Chris all day. There's a brief period of time at around lunch, 1:30 to 2:30-ish, where they were not together. 1:30, obviously, after the fire at Fallon's Drive. But other than that, they were together all day.
It's like, no way, lady.
Made numerous stops throughout the day. You're going to hear a little bit about some of those stops. What I expect the evidence is going to show is that at 9:08 that morning, Chris went into a Wachovia in
The testimony of prosecutor.
Defense.
We join in that motion.
And is the media wishing to weigh in on this portion?
Again, the media does not object to the closure of this court.
All right, thank you. Let me address this issue. And a lot of this is repetitive, but being that this is a motion being made, I will put on the record the preamble to my ruling. The court has reviewed the parties' prior arguments and the materials submitted in advance of today's hearing, including entitled Proffer of Facts Regarding Closure of Portions of Evidentiary Hearing on Motion to Disqualify Utah County Attorney's Office. Defense has requested the testimony of certain witnesses, specifically Prosecutor A, adult child witness, be received in closed session pursuant to Utah Rule of Judicial Administration 4-202, citing concerns related to personal privacy and safety. The court acknowledges that Rule 4-202 permits limited closure of court proceedings in appropriate circumstances. At the same time, the court is required to consider the countervailing interests identified in Rule 4-202, including the public's right to observe the conduct of public business, to understand the operation of government, and to maintain confidence in the judicial process. The court must also remain mindful of the constitutional rights of Mr. Robinson, as well as the statutory rights of Ms. Erica Kirk in her role as victim representative. And I also note that she filed today notice in regards to open and transparent courts. So I just want to touch on that. I acknowledge that filing as a victim representative. The purpose of today's evidentiary hearing is limited and specific. The court is asked to consider the defendant's claim that a member of the prosecution team, which was previously referred to as deputy county attorney in the motions, has a personal conflict of interest, that any such conflict extends to the Utah County Attorney's Office, that disqualification is therefore required. The court's role at this stage is to receive relevant evidence and to rule based on the record and applicable law without reaching the merits of those claims in advance. The parties have filed public motions outlining the anticipated evidence and testimony related to the motion to disqualify, including the state's opposition, the defense reply and request to take evidence, and the defense original motion. Those filings describe the general subject matter expected to be addressed at this hearing. The defense asserts that the prosecutor's familial relationship with a witness creates a concurrent conflict of interest implicating Mr. Robinson's due process rights. The prosecutor's role, duties, and actions in this matter are therefore relevant to the issues before the court. If the prosecutor is called to testify, as it seems they will be, the court will consider the testimony as part of the evidentiary record. After careful consideration of the record, the arguments of counsel, and in the interests identified in Utah Rule of Judicial Administration 4-202, the court finds that closure of the prosecutor's testimony is not necessary and would not be narrowly tailored on the circumstances presented. The court further finds that the interests of openness and transparency outweigh the asserted grounds for closure as to that testimony, and the rights of the parties and witnesses can be adequately protected through least restrictive means available to the court. For those reasons, the request of both the state and the defense to conduct the prosecutor's testimony in a closed session is respectfully denied. You may call your next witness, Mr. Burke.
Let's go. Your Honor, I call Prosecutor A.
All right.
Oh, the kid.
And I assume from the court's ruling, we do not need to do a closed session as to his identity.
We will not be doing a closed session as to his identity.
Thank you.
If I understood correctly, they said that they were referring to the kid as Prosecutor A, but that seems silly.
All right. Well, I'll go ahead and swear in the witness.
Yeah, it's the prosecutor. Not his kid.
Yes.
Mr. Burt.
Thank you. Good afternoon, sir.
Good afternoon.
Could you tell us your name, please?
Chad Grunander.
And could you tell us what your business or occupation is?
I'm a prosecutor at the Utah County Attorney's
I know
Office.
his name now.
How long have you been a prosecutor at the Utah County?
Almost 22 years.
Sir, in front of you, there's a number of exhibits, and they're marked, I believe, D through G. Do you see those there?
Yes, I do.
Okay. I'd like to go over those briefly, and then we'll proceed with your questioning. Do you recognize Exhibit D?
I do.
And could you tell the court what that is?
This is a biography that lists my name, my title at the Utah County Attorney's Office, with a brief description of what my duties are, my responsibilities, my education. It speaks to a little bit about my career and some of the cases that I've prosecuted over the years.
Your Honor, I'd move into evidence D, Exhibit D.
To the state. This exhibit is received and admitted into evidence.
Thank you. Next, Exhibit E. I wonder if you could identify that for the court.
Yes, this is an email that I sent to you as well as co-counsel for Mr. Robinson. It looks like I copied our prosecution team on this email as well. It was an email that was sent on the morning of October 1st, 2025, that disclosed an issue that came up with respect to this case that we felt was important enough to tell you, let the defense know.
Thank
This
you.
is my email.
I'd move E into evidence, Your Honor.
To the state. E is admitted into evidence and received.
And how about Exhibit F?
Yes, I see that. This is a photograph. It looks like it's a still shot from probably a TV screen from a Fox News alert that shows the amphitheater where Mr. Charlie Kirk was killed on September 10th.
And was this photograph used by you and an investigator to take some measurements out at the scene at some point?
It was, yes. In the middle of the photograph, you can see a dark bag. It's actually a dark blue bag that belonged to my daughter. She was at the scene on that day when Mr. Kirk was shot and killed. And I don't know if this was sent to me or I found it, but that just
That's
indicated where
wild.
her bag was left behind when she left the scene. I used this along with an investigator to determine the approximate distance where she was standing when Mr. Kirk was shot and killed.
And what was that distance that you determined?
85 feet.
When did you make that measurement?
That measurement was done the day before, I believe, that I sent the email. So I believe that would have been September 30th of 2025.
Okay. Move that into evidence, Your Honor. Exhibit F.
The state,
No objection.
it is received and admitted into evidence. Thank you.
And Exhibit G.
Yes, I see that.
And could you tell the court what that is?
It looks like it's an email from Ms. Nestor, co-counsel, from Mr. Robinson that was sent to you as well as other attorneys, defense attorneys on Mr. Robinson's case. I became familiar with this document when you, Mr. Burt, sent this to me about 2 weeks ago or so. And that was the first time I recall seeing this and reading it. Some of it is redacted.
Right. Does that email, the unredacted portion, relate to a conversation that Ms. Nestler had with you on October 9th of 2025?
Yes, I can't say for sure it was October 9th, but we had a conversation on that day or right around that date over the phone, and Chris Ballard was also present with me. But yes, this reflects that conversation.
All right. And I move that into evidence, Your Honor.
As it relates to G.
Before determining if I object, I'd like to prepare a witness on the accuracy of this.
Let me ask if I could one more foundational question that could go to that.
Sure, we'll go to Mr. Burt and then to Mr. McBride. And so
Thank you.
It's not admitted into evidence just yet.
Did I send you that email for the purpose of you reviewing it and making sure it was accurate?
You did.
And did you have a response back to me as to whether or not it was accurate and how you would agree or disagree with the content?
I did. I don't know that it's word for word accurate, but the substance essentially is accurate. This is what we talked about and what was communicated.
All right. With that, I would renew the request to introduce G.
To Mr. McBride.
I will say, one.
Counsel, just no questions been asked. I'm just waiting for Mr. McBride.
If I can provide a witness about the contents here.
You may.
Sure.
Did you write this email?
I did not write this email.
This was an email that was sent between defense counsel that memorialized your conversation with defense counsel. Is that right?
That's correct.
Okay. I want to ask you about some of the contents here. Chad is sure he talked with a few people in the office about his daughter's presence. Is that accurate?
Yes, that's accurate.
Does that give a time frame for when you talked to the people about your daughter's presence?
This does not give a time frame.
It obviously had to be before October 9th, right?
Correct.
He definitely shared it with the whole, I'm quoting again, he definitely shared it with the whole prosecution team prior to notifying us. Is that accurate? Did you speak with every member of the prosecution team, meaning all the attorneys in your office, about your daughter's presence?
All of the attorneys assigned to this case?
Yes.
I believe so. I don't think I spoke to them each one individually, but they would have been present when it was talked about at some point, I'm sure.
Okay, let's see. Okay, I think that's all I have.
Thank you, Mr. McBride. And two, defense has renewed their motion to admit G into evidence to the state.
I don't object to the admission of G. The accuracy has been addressed by the witness. So,
all right. Exhibit G by defense is admitted into evidence. Mr.
Thank you.
Burt.
You want to make a clarifying comment?
I did. Right towards the end, before the redaction, it says his daughter has not been interviewed by any law enforcement. that was true at this time. I believe since then, she has been interviewed by law enforcement, my daughter.
Okay. So when that was written on the 9th, she had not been interviewed by law enforcement.
That is my understanding, yes. That's
And
correct.
when was she interviewed by law enforcement?
I believe it was after our last hearing in between January 16th and today.
And can you tell me what role, if any, you had in arranging that interview?
I didn't have any role in that. I was just informed that it was going to happen.
Okay, thank you. Now, I'd like to direct your attention to September 10th, 2025. Can you tell me where you were around noon of that day?
I was up in Davis County, in Layton, at a convention center. I was there with my boss, Jeff Gray. I was actually presenting to the elected county attorneys in the state of Utah at a conference.
And was anybody else from your office present at that conference?
No, just the two of us.
Did something happen in relation to your daughter while you were at the conference?
Yeah, shortly after I finished presenting, we were standing around. I was standing next to my boss and some of the other county attorneys in the state, and I started to receive some texts from my daughter that were sent to our group family text group.
And can you recall for me what the content of that initial text was?
Yes, there was a text that came in, I think at 12:25, I believe, that was in all caps, and it said someone was shot or someone got shot. There was another text that came in.
Maybe he's been
I
asking
may have
a
seen
whole
it
lot
at the
of
same
questions.
time.
I
but
don't
it's
know
the
which one you're
same
referring to.
timestamp that said something to the effect, I'm okay. Everyone's running inside.
Okay. And just to refresh your memory, we were recently provided with some of your daughter's emails and screenshots, one of which was a screenshot of a outgoing phone
sorry.
call to you at 12:28 p.m. Do you recall that?
I do. I believe I actually tried to call her, and I don't think she picked up, and then she called me.
All right. And according to the screenshot, that was a 1-minute call. Do you recall what you said, what was said during that conversation?
I think I was checking on her well-being to make sure she was okay. I don't know that we even talked too much about the facts, what occurred. It was a short phone call, but I wanted to make sure she was okay. That's why I called.
Sure. What was your initial reaction when you learned that she was present at what probably you didn't know much about at that point?
Well, I was startled. I was concerned for her welfare. I understood almost immediately when I found out about it that she was okay, that she was out of danger, but it was concerning.
Now, did you know that she was attending this event?
I did. She had talked about it in the days preceding that she was going to go to this rally.
And did you have some discussion with her about whether that was a good idea, bad idea, or you had no position on it?
No position. We didn't talk about that.
And what did you talk about in relation to Charlie Kirk? This is before September 10th.
Just that I had become aware, probably through her, that he was coming to UVU. She would watch Charlie Kirk from time to time online, and she was excited to go see him at this rally.
Okay, so 12.
Do you guys know that UVU has already bulldozed that area? It's kind of like the Idaho 4 situation. They had just got rid of the house really quick. It was a very weird thing to do so quickly, in my opinion.
28, you have this phone call with her. And then do you recall you communicating back with her by way of text?
Yes, I remember asking her a question a few minutes later, asking whether she heard what sounded like a gunshot.
And is that the reference? I think it's attached to the opposition to the motion as Exhibit B, an entry at 12:35.
That sounds right.
Hannah, did you hear a gunshot or what sounded like a gunshot?
That's correct.
That was from you to her by way of text.
Well, there's her name.
And did you get a response back from her?
Yes, she responded, I for sure heard it. Everyone started screaming and running. A few people said they saw the shot hit his neck, ... not sure.
So at that point, did you share the email exchange or the text exchanges with anyone, either verbally or actually sending the text to anybody?
I know I spoke with Jeff Gray about these text messages. I may have even alerted him to the fact that there had been a shooting prior to even sending that text to my daughter, just because we were right there together.
Right.
But we did talk about that briefly. Within a few minutes after receiving that last response, I know I called our office. I spoke with Chris Ballard to put him on notice that this had happened at UVU. I don't believe it had hit the media yet, news media anyway. And then shortly after that, I also called David Sturgill, another prosecutor in our office, to make him aware of it and to ask him to make himself available for questions and to assist law enforcement with any questions they might have while we, Mr. Gray and I, needed to travel down to Utah County.
And were you still at the location of the conference when you were making these calls?
I believe so, yes.
When did you actually leave to head to UVU?
Probably, I want to say I made that last phone call to Mr. Sturgill about 12:44. I think probably by 12:50 or so, I was probably on the road heading down to Utah County.
Do you recall, again, this is referencing Exhibit B to the opposition, at 12:40, you sending a text to your daughter, quote, I'm getting live information, but I can't share it right now.
Yes, I remember. I think that was on the family group text.
Yes.
I think there was chatter on that group text from my sons. I think my wife as well. I think someone may have asked me, can you tell us anything or what's going on? And I just let them know I'm learning things, but I can't talk about it.
Yeah. And when you say you were getting live information, who are you getting live information from? Do you recall?
Can you remind me what time that text was?
That was 12:40 p.m.
Pearl?
On the 10th.
I do not recall, counsel. I think I had just communicated with my daughter
Such
is
dry
all.
hands.
I don't know if in those text exchange, I don't know if my kids were online and seeing something through social media that they were sharing with me. I'm not sure.
Okay. Before you left
Sure.
to head to UVU, did you speak to anybody else in your office?
I believe it was just Chris Ballard, David Sturgill. It's possible I may have spoken with a legal assistant of ours, maybe Haley Christensen, maybe Tammy Painter, but I don't specifically recall that.
And of those people you spoke with, who did you mention your daughter was present at the event?
I don't have a specific memory telling Chris or David about my daughter, but that's how I learned about it. So I'm confident that I shared with them that my daughter was present when this happened, and that's how I found out.
Did you drive by yourself to the UVU?
I drove down to Orem and parked my car near the In-N-Out in Barnes & Noble. Jeff Gray met me there. He came down, left probably 15, 20 minutes later after I did. We met there, and then the two of us drove from that location to UVU.
And what did you do there at the scene once you got there?
We tried to understand what was happening. It was quite chaotic. There were a number of local law enforcement agencies that were already there present. Federal law enforcement agencies were arriving. We were trying to connect the dots as far as what had happened, make ourselves available to answer questions, to assist in reviewing warrants, for example, which did happen later. It was just very busy, very chaotic.
Sure. How long did it take you to get from the conference to the scene?
Oh, probably took me approximately an hour to get down there, maybe less. I waited for Jeff for a few minutes, and it probably took us 10 minutes to get into the command scene.
During that time period, did you have any communication with anybody about where your daughter was at that time?
I don't believe so. I don't know that I knew precisely. I'm confident I didn't know precisely where my daughter was at that time. Just that she wasn't in harm's way, at least at that point.
But at that point, you didn't know whether she was still at the scene or had gone.
I knew she had left because when we talked, I believe she had made her way to the parking lot and was waiting
Always
for a
get off
friend
the end.
to go home. So I knew she wasn't at the scene itself.
When you got there, your understanding why she was gone.
When I got to the campus,
Yes.
yes, she was gone by then.
Okay. Did you have some communication from anybody about a piece of property of your daughter's being there at the crime scene?
Yes, she had informed me that she left her book bag behind in the amphitheater, which is the subject of Exhibit F, in part at least. And that was communicated later that day to law enforcement that her book bag was there. It had her laptop, books and notes and things in it.
You didn't see it there when you were at the scene?
I actually did at one point take a picture because I believe later in the day I spoke with my daughter. I asked for a description. I don't think I knew exactly what her bag looked like. And I think I was standing on the scene and through a window took a picture of what ended up being her bag, sent that to her, and she said, yeah, that's my bag.
And did you request anybody in law enforcement that you have permission to take that bag at that point because it belonged to your daughter?
I just let them know that that was my daughter's.
Situation.
and that
I grabbed
as
my
soon as
shit.
the scene was released, as soon as possible, if we could retrieve that bag.
Do you recall who in law enforcement you spoke to while you were at the scene at the UV?
I think I mentioned it once. She's with the State Bureau of Investigations. I should know her name.
But I also watched it.
Female, Polynesian. I know one of my co-counsel would remember her name. She helped process the scene.
All right. And did you mention to her or anybody else that your daughter was a potential witness at that point?
I'm sure I mentioned that my daughter was there and left a bag behind. I don't think I would have. I'm confident I didn't characterize it as she's a potential witness here.
Or say that she was there during the incident that happened?
I probably communicated that.
And that would have been to one or more law enforcement people?
Correct. And I know I was also speaking with David Sturgill in my office about it because he was on the scene. I was back and forth to the office in the command scene at UVU over the next couple of days. And so I spoke with him about it as well.
Okay. And did, to your knowledge, anybody request to interview your daughter around the time of the 10th?
Evil
No, not to my knowledge.
Brett.
How long did you stay at the scene that day?
Yes, I talk about you.
I was at the scene. I don't believe I left to go back to the office that first day. We were probably there until 9 or 10 o'clock into the evening, maybe even 11 o'clock later into the day.
Now, at that point, you were the chief deputy in the office, correct?
Correct.
What were your responsibilities in terms of charging?
In terms of charging this case?
Yes.
Took a phone call from
I was
Don
part
Jacob.
of the effort in deciding what charges were appropriate here. In our office, we have a policy that the county attorney, Jeff Gray, when any homicide case, he has to approve the charges.
Right.
So I talked with Mr. Gray about the facts of this case as we understood them as they were coming in over the next few days. I'm sure I consulted with Ryan McBride, David Sturgill. They spent the better part of 2 days on scene, helping law enforcement.
You want me to cut your nails?
Chris Ballard, I would have talked to Chris about that. It would have been a team effort in large part, but the ultimate approval was Mr. Gray's.
You oversee the major crimes and general crimes divisions, correct?
I do.
And major crimes in your office includes homicides, I assume.
We don't have a homicide unit, but we have a special victims unit for sex crimes, and then we have a violent crimes unit. Most of our homicides are prosecuted by our violent crimes unit, but they're also specifically assigned given where the case gets, what court it gets assigned to, and the skill set of those attorneys and experience, et cetera.
Okay. Now, because of your connection in the case, did you become aware that on the morning of the 12th, early morning, that Mr. Robinson was arrested?
Yes,
About 4 o'clock in the morning?
I became aware of that, yes.
Okay. And are you aware that at 7:18 a.m. on the 12th, a affidavit of probable cause was filed by a state investigator by the name of Brian Davis?
I would have become aware at some point of that. I don't know exactly when, but I would have known that upon his arrest and booking, there would have been an affidavit attached.
And what role did you play, if any, in drafting that declaration, or at least overseeing it?
I was not involved in that. I didn't oversee that.
What was your role at that point in terms of overseeing what was going to happen to Mr. Robinson?
Mr. Robinson.
In large part, making sure that we had attorneys that were on scene at the command center available to assist law enforcement, communicate with Jeff Gray what we were learning about the case, trying to get the best understanding we could as far as what was happening, what the facts were, in anticipation of having to bring charges within the next few days. So as far as making assignments, I was probably speaking with Mr. McBride, Mr. Sturgill about their involvement, and just generally trying to learn about the case.
Were you aware of the media attention that was being devoted to this case early on before an arrest of Mr. Robinson?
Did he live
Yes,
under a
I was
rock?
aware there was a lot of media involved. I remember going home the first night and it was all over the news media.
And were you aware that by September 11th and before the arrest of Mr. Robinson, that the governor of the state was announcing that the death penalty would be sought in this case?
I recall hearing that the governor had talked about the death penalty. I don't remember him saying it would be sought, but I remember him saying something to the effect that we still have the death penalty in the state of Utah.
I'm sorry.
Something to that effect.
Sorry.
What is your understanding of when the decision was made to seek the death penalty in this case? The date and time, if you know.
I wouldn't know the time, but I do recall early on, probably the second or third day, there was discussion that if we have the facts to support it, that Jeff was confident that he would be probably seeking the death penalty. I don't know if he had made a hard decision on that on the second or third day, but he was definitely considering it.
When you say the second or third day, are you talking about the second or third day in relation to when the incident happened on the 10th?
It would have been after, it would have been probably the 12th or 13th.
Okay.
It was after, it was
What incident?
following his arrest, I believe.
Oh, okay.
You're aware, are you not, that on the 13th, your office issued a press release, which included your name, indicating that we, the office, anticipated filing an information by the 16th.
I remember discussion about that press release. I don't remember the specifics of what was in the release, but that sounds right, because upon someone's booking, we have a certain amount of time in which we need to have an information filed, unless we seek an extension, and that would have been the 16th.
And so on the 13th, when that press release was released, had the decision already been made to seek the death penalty in the case?
I don't know, counsel. I don't have. So the 13th, this happened on the 10th. So the 13th, that was a Wednesday. It may have been made on that day, but I'm not entirely sure.
Or it could have been made before that day? True.
I suppose. I suppose. But that would have to be a question for Jeff Gray to know for sure.
Well, as a chief deputy in the office, is that a decision that you normally would have been part of the process in deciding?
Oftentimes, yes. And I'm sure that Jeff ran it by me, but by the time we were talking about the death penalty, my role was, do we have the facts to support an aggravating factor under Utah law that would support a potential death penalty case? But I don't remember a conversation with Jeff Gray where he asked, what would you do in this situation? But there would have been discussions, I'm sure.
Who in your office at that time, around September 10th, had more experience than you in prosecuting homicide cases?
That's actually a good
Maybe
question.
Tim Taylor, who's now in our civil division. That might be it.
Within the criminal,
Within the criminal division, probably no one.
and had your role in prior cases been such that you were consulted on the decision of whether to seek death or not?
In this case, was I consulted?
Now-
Or in other
No, let me
cases?
rephrase it. My apologies. In other cases that you have
So
been
nice to
involved
each other.
as the lead prosecutor, was it routine for Mr. Gray to seek your advice as to whether to seek death or not in a case that you were primarily in charge of?
Yes.
And can you give me an example of where that had happened?
The prosecution.
Objection, relevance.
Counsel, could you repeat the question that you asked? I want to
Sure.
make sure I'm.
That's how I
reading
felt
this.
with you,
The
maybe.
question is, can you give me,
Can you repeat the
you had
question?
said there have been cases where he's consulted you on whether to seek death or not. I asked you whether you could give me an example of such a case. And that was the objection.
All right. And as to relevance, Mr. McBride, I'll hear your argument.
Yeah, what his role has been in the past and talking about, he's already testified, he has had a role in those discussions in the past. Now we're asking what specific instances he has had involvement. I mean, I don't know, we're going to get into the facts of these cases. We need to bring this back to the question, which is, what role did his daughter's presence at the event have on the decision-making in this case? That's what we need to get to. And I don't think how it's happened in other cases is relevant here. We move along, we got 45 minutes until this hearing ends.
Whoa!
Thank you, Mr. McBride. Mr. Burt.
You know, I think Mr. Gray referenced in his opposition, his statement that the
Damn.
reason he was seeking the death penalty in this case was because of what happened in the Janes case. And I believe that this witness was the lead prosecutor in that case, was consulted about the death penalty, so it relates directly to what Mr. Gray testified about.
I will overrule the objection, but counsel, we're not going to go far down that path.
I understand.
Thank you.
Go ahead.
Yes, Michael Jane is a current prosecution. It's an aggravated murder case that I'm currently the lead prosecutor on.
All right, and generally in your office, is Mr. Gray typically involved in hands-on litigating a case as opposed to being the administrator in the office?
No, not typically.
Okay, and in cases where he's obviously the county attorney, but you're prosecuting a case, it's typical for him to seek your advice on whether to seek or not seek death, correct?
Seek.
Sure.
Okay.
That's fair.
Now, on September 16th, your office filed a notice of intent to seek the death penalty, correct?
Yes, I believe it was Jeff Gray that actually prepared that notice and caused it to be filed.
And what discussion, if any, did
Quite a
Mr. Gray have with your team regarding whether that notice should be filed at that time?
I remember Jeff expressing to us that the decision was made. He'd made the decision that he was going to announce the death penalty, seek the death penalty in this case. He wanted to do it earlier rather than later and decided that to do it at the same time we charged the case. And so I don't know if it was filed I think it was filed a few minutes or so after the information was filed, but it was filed prior to Mr. Robinson's first appearance, which occurred later that afternoon on the 16th.
In the opposition to our motion, Mr. Ray indicates in reference to the Jane case, quoting here,
don't
the
know the
county
Jane
attorney
case.
concluded from the outset that he would seek the death penalty, but choosing to follow the convention of some, the county attorney initially opted to wait until after the prelim. Do you know what he was referencing when he referred to the convention of some
Is
in
which
terms of
cur-
what the practice was?
Maybe ask. Yeah, I can't talk.
The statute calls for, I think it's within 60 days after arraignment, which takes place after a preliminary hearing, is when the notice of intent to seek death needs to be filed. Many prosecutors wait until after a preliminary hearing to file that notice.
Yeah, I mean, that would make
In
sense.
Michael Jane, we didn't, but it was a handful of months or so after the information was filed before the notice of intent to seek death was filed. So I think the majority of cases, that notice of intent to seek death is probably filed after the prelim.
And do you know the reason for that policy, for that practice?
Probably, well, I can
Well, hello, valued member. Welcome.
give you my input. I mean, I think you may have a better understanding as far as the strength of the case, where it's headed. There may have been plea negotiations that occurred in between that time. So could be for a few reasons.
Also, you might know a little bit more about the defendant's background by that point.
Sure. On the mitigation or aggravation investigation, sure.
Have you ever had a case in your office where a decision was made to seek the death penalty solely on the basis of the facts of the crime without regard to the defendant's background?
That's quite a question.
I'm not aware of that.
Now, let me ask you a couple of questions about Exhibit E, and then we're almost done here. Exhibit E is your email to the defense in which you state, "We don't believe the following creates a conflict for me in Tyler Robinson's case, but it's something that should be disclosed to you, his attorneys." And then you outline basically what we've been discussing here today, correct?
Correct.
And can you tell me how that decision was reached to send this email to the defense, what the considerations were?
Sure. The considerations were that I would be part of the prosecution team. I would be assigned to this case to help lead this team. And my daughter was present. And there's an argument that can be made with respect to a conflict. And so our practice, my practice is to, if there's an argument, disclose it. We're not in the business of hiding anything. And so we knew from the outset that once counsel was appointed, that we would be disclosing this to the defense, and they would respond accordingly, however they thought they should.
Reference has been made to these Utah prosecutors' best practices, Exhibit I. You're familiar with those?
Exhibit I, not specifically, but.
Oy vey.
Let me show you that. Can I approach her?
We'd really like it if you didn't. God, oh my gosh, wouldn't you be so upset if you had been subpoenaed now 3 times and didn't have the chance to be questioned? Uh-oh. Evil Kitten is here to save the
Yes.
day.
It's
You are
20,
gen-
it's 29 pages long, so you'll have to refer me
I'm
to.
not going to ask you to read the whole thing, but you're generally familiar with that, right?
From time to time.
And there's a statement in there, I'll read it to you, which says if there's close cases should be resolved in favor of disclosure in a situation where there might be a potential conflict.
Sure, I would agree with that.
And did that motivate your behavior here in terms of why you disclosed what you did in that email?
As far as it being close, is that the question?
Well, did that motivate your behavior in disclosing it?
What motivated my behavior was to just act with professionalism and integrity, disclose this to the defense. But don't mistake our disclosure, my disclosure, our abundance of caution, our professionalism, integrity to be a concession that we believe there's merit to this alleged conflict.
Sure. And you realized in disclosing that the ultimate decision is really the court's, right?
Correct.
All right. And there's a section of those guidelines that says if a prosecutor
That was
believes
spicy.
that public perception of the integrity of the prosecutor's office and public confidence in the handling of the case would negatively be impacted by a potential or alleged conflict of interest, the prosecutor should consider recusal. Did you take into account that standard when you were making decisions about what to disclose and what the significance of the fact was that your daughter was present at the scene?
Sure, we considered the appearance of conflict here, but when we learned and had a good grasp of what her experience was, or perhaps most importantly, what her experience wasn't, what she didn't see, we felt confident that there's just simply no conflict here. And once people become aware of the facts, there's no appearance of conflict.
Now, you had made that disclosure to us on October 1st, correct?
Correct.
When had you conducted the investigation about the measurements?
The day before.
The day before.
Mhm.
And do you know when Mr. Gray conducted the subsequent investigation into whether you could see her position from where the alleged shooter was?
That was much later.
So that part of the investigation had not been done at the time you decided there was no conflict.
That's correct.
And similarly, no one in law enforcement had interviewed your daughter, independent of you and what we see in the text, prior to you deciding that there was no conflict here, correct?
Yes.
Lastly, I wanted to ask you about the email from Ms. Nestor that summarized the conversation you had with her, because you said there was maybe some clarification needed there. She said in the email, Chad is sure he talked with a few people in the office about his daughter's presence. When did those conversations take place?
It would have started almost immediately after receiving her text. I spoke with Jeff Gray about that. He was made aware of her presence. Within minutes after I made a phone call to Chris Ballard and then David Sturgill, I'm confident that I mentioned to them that she was present.
And that email then goes on to say he definitely shared it with the whole prosecution team prior to notifying us. Is that correct?
Yes, I believe so. I think we talked about this issue, and it was decided as a team that, yeah, no question, we're going to disclose this. So I'm sure it came up.
And was that in one meeting? Was it in several meetings? Was it discussing it with each team member individually? Or give me a better sense of that.
I don't know that I spoke with every team member individually, some of them for sure. Mr. Gray, Chris Ballard. I'm sure I had conversations with Ryan McBride and David Sturgill as well. I don't know about Lauren Hunt. Lauren is on this case as well, other than outside of a team setting. So there would have been discussions as a team and then also individual discussions.
I see. Could I have one moment, Judge? I think I'm done.
Of course. the state.
Will you please describe the effect when you learned that your daughter had been present on September 10th? Over the next maybe 8 hours, you drive down to Utah County, you drive to Utah Valley University. What effect, and you're interacting with law enforcement, what effect did your daughter's presence have on the discussions you're having with law enforcement, your work as a prosecutor at that point?
Other than informing the investigator, I can't recall her name right now, about her book bag being present, putting law enforcement on notice that needed to be retrieved once the scene was released. It was busy. We were trying to learn about the case, the facts of the case. I don't know that I talked much, if anything, about my daughter's presence there. The effect it had on me, I mean, obviously concerned when I first heard and saw these text messages. That's why I called her, to make sure she was okay. She was out. She wasn't in danger any longer. And then there was work to be done. And so we got busy trying to understand what had happened that day and start to put the pieces together. I'm sure I reflected on it from time to time, but I don't specifically recall.
Okay. Did it affect any decisions you made as to what you're doing as an attorney out at the scene?
No, absolutely no effect.
As far as the charging decisions, there's been some discussion or testimony about how the charging decisions were made in this case. Did your daughter's presence have any influence on the charging decision that was made in this case?
No, none at all. What was important was, did we have the facts, substantial evidence to support an aggravating factor? And look at the case law. And there's the Johnson case, the Pierre case, the Sosa Hurtado case. I was researching those cases, considering the zone of danger, if you will, which is talked about, I think, in the Johnson case. And it was clear that my daughter was not within the zone of danger. It had no effect.
Okay. Did it have any effect on the death penalty decision, your daughter's presence?
Not from my perspective, and I don't believe it had any effect on Mr. Gray's perspective.
Was your daughter's presence discussed as that decision was being made?
No.
Has it had any effect on the decisions that have been made in the prosecution of this case since?
No.
Now, as a father, have you monitored your daughter's condition?
Sure. Her emotional condition?
Yes.
How well of course.
And what's your understanding? How has her presence affected her? Has she had to get therapy?
No, she has not.
Has she had to miss work or school?
No.
Have you noticed a change in her demeanor or behavior at home?
No.
Just a moment, if I may.
I said Buffalo, and we love our valued members here.
Your conversation with her. Once again, you were asked, or one of the statements in there is that you talked to the whole prosecution team about your daughter's presence. What do you mean you talked about your daughter's presence? Just that she was there, or what? And I want to ask you this question outside of the current motion to disqualify, because I know this motion to disqualify has brought her presence into center focus. But outside of this motion to disqualify, what did you mean you told others, or you talked to others about her presence?
Well, I had informed them that my daughter was there when Charlie Kirk was shot and killed. She was at the rally. And I'm sure we talked about what her experience amounted to based upon the text messages that I had received. I know we talked about my disclosure, the disclosure email. In there, I talk about her emotional state. So I probably shared with them that she seems to be doing fine, that she hasn't needed to speak with a professional about it.
Did you learn anything from your daughter's presence that you hadn't learned from other evidence in this case?
No,
For example, that Charlie Kirk had been shot and killed.
that's correct.
Did you learn that from your daughter's presence, or did you learn that from other evidence in the case?
Well, both, because she informed me that it looked like Charlie was shot. So I would have initially heard that from her. But there is other evidence, yes, direct evidence.
Would her testimony be admissible in trial?
I don't believe so.
That Charlie Kirk was shot and killed?
I think that calls for a legal opinion.
Counsel,
It's probably true.
I'll sustain the objection.
Let me make sure I've just asked that question adequately. Was there any information you gained from your daughter that you did not gain from other evidence that was collected in this case?
No.
Thank you. Nothing else.
Thank you, Mr. McBride. May this witness be excused. Oh, I'm sorry, Mr. Burt. Thank you.
You mentioned that the decision to seek death was based on the assessment of whether the aggravating factor was present or not, correct?
Correct.
And the aggravating factor is creation of danger to other people in the zone of danger.
Was another put at great risk of death?
Is the way the statute reads.
Correct.
At the time that decision was made, had you done any investigation yourself on who was or was not in the zone of danger?
We, I believe, as early as the second day, and I'm referring to, I think, the 11th, walked the scene as soon as law enforcement released the scene. And I positioned myself up on the shooter's perch, if you will. And at that time, I knew, based upon the photographs, of where my daughter was. And given where the shooter was and shot and killed Mr. Kirk, yes, I would have known that she was not within the zone of danger.
Was not
by the
expecting
second day.
words.
And the measurements you took in that regard took place when? End of September?
End of September.
Okay.
That's correct.
And that was the first measuring that you were involved with or that you were aware of?
Yes.
Thank you. That's all I had.
All right.
Your Honor, I do have a follow-up on that.
All right, Mr. McBride.
I want to ask you a little bit more about that zone of danger. Were you aware of other evidence that there are other people in the zone of danger?
Yes, absolutely.
What kind of evidence?
There was a substantial amount of social media evidence that was coming in, videos of the actual assassination of Charlie Kirk. There was the questioner that stood in front of him asking the question when he was shot and killed. There were others near him. There were people to the left and to the right of Mr. Kirk, people right behind Mr. Kirk as well, several individuals.
And that testimony and that evidence, does that come from your daughter?
No.
Comes from other people who recorded.
Yes,
the
it
incident.
did.
Is that right?
Correct.
It did.
Same question. That's
She put that in the text.
redirect. Thank you. Nothing else.
Thank you, Mr. McBride. Anything further for this witness?
No, Your Honor.
May this witness be excused.
Unbelievable that he didn't follow up with that because that's what the text said.
To defense.
Your Honor, at this time, we don't intend to call any more witnesses and we would submit on our motion. I do believe the state may have a witness or two.
All right, turning to the state.
I just heard him say nothing further. I hate when they do that. I swear, if you wasted all this time You don't call up a witness. I will.
Standing right by the lectern when you'll be sworn in.
Maybe not. Just posted a link to make sure that
Here, if
you
wouldn't mind
are
having a seat right there, adjust the microphone. There should be
to check to see if you can
a bottle of
receive
water
gifts.
if you get
Please do that.
thirsty or dry. And just bring that microphone a little bit closer just so that the record picks you up.
Who is you?
All right, Mr. McBride.
Before we turn to Sergeant Hull, the state has submitted an affidavit from Agent Cole Christensen. I've just conferred with counsel. I think we're both on board that the court can consider that in reaching its conclusion on this matter today. Save us having to call him as a witness.
All right. What was the proposed exhibit number for that?
It's an attachment to the state's pleading, addendum C.
And so how is it going to be marked? Just for
They're not
record
going
keeping for this
to.
hearing.
Let's call it State's Exhibit 13.
It's
All
wild.
right. The state is moving that into evidence to defense. Any objection?
Your Honor, I think it's already been submitted and attached to the motion, so no objection.
All right. State's Exhibit 13 is received into evidence in this case.
Will you
Will,
please state your name?
you don't know what
Agent
it
Dave
is.
Hull.
It could be
And
just
what
as
is your
good as that.
position?
I'm an investigative agent with the State Bureau of Investigations.
What is your role?
Your Honor, could you ask him to move that microphone a little closer? I'm having trouble hearing Agent Hull.
You need
I
to
like
bring the
his
microphone
haircut
almost
from
to the point where it's
2009.
uncomfortable to you. So bring it forward. And we just want to make sure the record picks you up.
Did you
Okay, is that
hear
better?
her?
Yes, thank you.
I want to ask you about some of the evidence collected in this case. Are you aware generally of the evidence that has been collected in this case and the investigation that has been done?
I am, yes.
First off, will you describe basically the scene where Charlie Kirk was killed when he was shot and killed?
Yeah, the scene is essentially an amphitheater setup. Mr. Kirk's stage was set up at the base of the amphitheater. And then there are, I guess, semicircular tiers that move back up and away from the stage
New
area,
Zealand,
creating the
mate.
amphitheater.
And how many people approximately were present?
Estimates for attendance at the event itself were about 3,000 people. And then the campus was open to regular students that day also.
How did the State Bureau of Investigation determine who to interview of those 3,000 people?
There were several processes used. There was a general request for information that was put out for
G'day,
people
mate.
who attended the event. There was a time when people who had attended the event returned to collect personal belongings, and posters and requests were made for people to provide information. People who had volunteered information. So several different sources and several different ways that we made contact with the public.
Okay. And were all of the witnesses of equal value? Those that were present at the event?
Essentially, yes. There were one or two who were able to provide different information, but essentially the majority of people who provided information provided confirming or repetitive information about their experience.
Okay. I want to ask you about videos that were collected. Well, first, do you have an approximate number of how many witnesses were interviewed out of those that were present at the event?
I know that as a state entity, we're able to obtain over 40, what we would call an 1102 or a witness statement, which is a written statement. I also know that the FBI provided us with a number of written statements and interviews that they conducted also.
So did you say 40?
At least 40. It would be more than that.
Okay. Plus FBI collected additional statements.
Correct.
Okay. Did you collect videos that some of these people had taken?
Oh, we did, yes.
I would like to present State's Exhibit 1.
Oi, mate. From the down under. Do not make fun of my accents, Riley.
You should see it appear on your screen in a moment.
Hello to all my viewers, the hundreds of you out there. Please make sure to hit the like button and subscribe, please. Thank you.
Okay, if you can just pause that for a moment, Kimberly, thank you.
Confidence over facts.
Do you recognize State's Exhibit 1?
I do, yes.
What is that?
That was a video provided by an individual named Mr. Lyman, who was behind.
Okay, so there was a lot of controversy going into today about this video. So it's, if you aren't watching the screen, please direct your attention to the screen because this will be interesting.
Where the stage is set up, there's a kind of a walkway that goes under a building. And then behind that, there were vehicles staged, and that's where Mr. Cook arrived on scene.
For the purposes of this hearing, I'd move the admission of Exhibit 1.
No objection.
It's received and admitted. Thank you.
Please play that video. Okay, will you describe where this is we're seeing, or what we're seeing and where this video is capturing at this point? And we are at 14 seconds into the video.
This isn't
This is
the
Mr.
video.
Cook's arrival to the event. As I mentioned before, that kind of concrete breezeway that was behind the stage area. Mr. Cook made his way through that. And then he would have been stage right when he first entered into the amphitheater. I didn't know at the time, but I guess he has a tradition of throwing out hats to the audience, and so that was what he commenced doing at that time.
Okay, and then in a minute, we're going to see the video capture the actual amphitheater area. Is that accurate?
I believe so, yes.
Okay, go ahead and hit play, please.
I don't have the video. I did my research about this hearing though. And they really, the defense did not want this video to be shown. I'm definitely getting flagged for that, man.
Thank you. Are there other videos that the Bureau of Investigation collected
No.
that capture the crowd in the event?
Yes, there are numerous videos that were collected from individuals who had been attendees at the event, and also videos from the university itself.
Meaning University of Utah Valley University surveillance footage?
Correct, yes. Utah Valley University has a comprehensive surveillance system.
And Turning Point USA, Charlie Kirk's organization, did they also capture videos at the event?
They did, yes.
I'd like to show you State's Exhibit number 2.
I'll get flagged for the fact that they were starting to play Thunderstruck.
I have in front of you.
I've already
State's
been
Exhibit number
flagged like
2.
3
Do you
times
recognize
this
that?
week for stupid
I do,
shit.
yes.
And is that a video that's collected in the investigation in this case?
It is, yes.
For the purpose of the limited purpose of this hearing, I'd move the admission of Plaintiff's Exhibit 2.
Defense.
No objection.
It's admitted. Thank you.
Okay. Will you describe what
This
we're going to
must not
see
be
here
the
before
video
we
either,
hit the
'cause-
play button?
Yeah, this video will actually zoom into the roof area of the buildings. You can see center screen. In doing so, the video will capture an individual on the corner of the rooftop.
Was this video captured by the person we're referring to as Prosecutor A's daughter?
No.
I was going to say, what?
Just press play.
What? That would have been wild.
I think he'd already be in place.
You would think that. So there's somebody on the roof right there? Just saying. He just ran from over, where's my finger? Whoa. From over there, ran in. And now he's right there. Just saying.
Now, that roof that was recorded in that video, first, is there other surveillance of that person in a person in that location at that time running to that spot?
There is additional footage, yes.
Where does that come from?
That came from the Utah Valley University security cameras.
All right. Is there another individual that also recorded a person running after the shooting from the roof?
Not to my recollection, no.
Any video from someone, you recall a video from someone in the Hall of Flags who may have recorded someone running after the shooting?
Yes, there was an individual who recorded from the Hall of Flags. It's an interior video looking through the windows, but I believe an individual is visible on the rooftop also in that video.
Okay, thank you. As far as other witnesses, some of the other relevant witnesses in this case, who is Hunter Kozak?
My recollection is he was the individual who was asking the question to Mr. Kirk at the time that he was shot.
Okay. Would he
Wasn't
be a
it
witness
about-
in this case?
Never
Could he
mind.
be a witness, I should ask?
Potentially, yes.
Where was he positioned in relation to Mr. Kirk?
I believe the way the stage was set up, he was approximately the same height level of Mr. Kirk, but he would have been directly in front of him where they had the barriers set up separating the crowd from the stage area.
Okay. I would like to show you Exhibit 4.
Y'all,
Now, Exhibit
really
4,
have
this is a
to
screen capture from a video. Do you
Please
recognize Exhibit 4?
I do, yes.
You remember the video
Hey.
from which this is taken?
Yeah, it was a cell phone video belonging to an attendee of the event.
And that attendee was not the prosecutor's child.
It was not the prosecutor's child, no.
Will you just describe what the video shows?
If I recall, this is a graphic video that does actually show the time that Mr. Kirk is impacted by a projectile.
Okay,
and the
so this is what I was
subsequent
talking
and
about.
reaction of the crowd.
Okay. Does it show the position of the people to his right and to his left?
Mr. Kirk's right and left?
Yes.
In a limited manner, it does, yes.
Okay. Does it show the position, the video, we're speaking of the video, does the video show the position of the questioner, Mr. Kozak?
I don't recall if it pans all the way to the question asker or not specifically, but there is potential that it does, yes.
I'd move the admission of Plaintiff's Exhibit 4.
No objection.
It is admitted into evidence.
Did you interview mothers with children that were at the event?
I believe there were some mothers who had children at the event who provided witness statements to the State Bureau, yes.
Okay. I'd like to show you Plaintiff's Exhibit number 5. Do you recognize Exhibit 5?
I do, yes.
And this, my understanding is this is also a screenshot from a video from Turning Point USA. Is that accurate?
Yes, this was a video taken by Turning Point USA.
Does this show the questioner, Mr. Hunter Kozak, in front of Charlie Kirk?
It does. You can see him holding the microphone just above Mr. Kirk's head.
Okay. And the video, will you describe what the video shows?
From my recollection, this video also shows the point that Mr. Kirk is struck by a projectile, and it shows the reaction of the individual asking the question, along with the reaction of Mr. Kirk's security detail and those others in the crowd.
Okay. I also see another, I'll leave it at that. From what you have gathered in the investigation, were you able to determine the direction from which the bullet came?
Yes.
And in this Exhibit 5, where would that direction have been?
Essentially from straight in front of Mr. Kirk.
Okay. And which side of Mr. Kirk's body did the bullet strike him?
It would have been his left.
All right. All right, and finally, Exhibit number 3. Oh, I'd move the admission of exhibit number 5.
No objection.
It's admitted.
I have exhibit number 3 up in front of you. Do you recognize that?
Yes, that's a university or a Utah Valley University video of the kind of the breezeway area that I previously described.
And exhibit number 3 is a screenshot from that video. Is that right?
Yes, that's correct.
And will you describe what plaintiff's exhibit, well, the video itself actually shows?
Yes, if we were to play this video, this shows also the time that Mr. Kirk was impacted by the projectile. And it shows the activity that occurs behind the stage area and the movement of people prior to, during, and then after the incident. On both sides of the breezeway where the barriers are, the crowd actually break through the barrier in an effort to escape the area.
Had to let the dogs out. Sorry,
Does this
guys.
video show others that
While I
may
was
have been
up.
exposed to risk if that bullet would have missed Mr. Kirk?
I believe so, yes.
Oh my God, it's so cold outside.
When you responded on September 10th, did you know who Chad Grunander was?
I did not know.
Did you know anything about his daughter?
I did not.
Did you eventually learn that the prosecutor's daughter was on the scene?
Oh,
I did.
When did you learn that?
I believe when I found out, it was when the motion had been filed for the conflict argument.
Okay, so prior to that, did the presence of that person, that individual, have any bearing at all in your investigation in the case?
No, I was not aware of her presence at the event.
You have read that that adult child's affidavit in preparation for this hearing, right?
Correct, yes.
And was there anything in that affidavit that changed your view of the case or the investigation you should do?
There was not, no.
Was there anything new in the affidavit?
No,
You're here for her testimony today, correct?
correct, I was.
Same questions. Anything new in that testimony?
No additional information.
Now, I want to ask you a little bit about the value of the witnesses as it relates to this case. Did the witnesses on scene identify the shooter?
No, we did not have a witness that identified the shooter on scene.
What was was that the primary goal of your investigation, to identify the shooter?
It was, yes.
And I want to ask you about the existence of other evidence. You said you collected surveillance evidence from Utah Valley University. Is that right?
That's correct.
Did that give you some additional information on identifying the shooter?
It did, yes.
How about doorbell cameras for the areas around Utah Valley University?
Yes, we collected a large number of doorbell camera footage from multiple residences in the area, not just in Orem, but also in St. George. And we also recovered video footage from multiple businesses in the area of the university campus in Orem, and also from businesses between Orem and St. George. So there's a large amount of video footage obtained.
And did those help you identify the shooter?
They did, yes.
Text messages, did you collect text messages from associates of Tyler Robinson?
We did, yes.
And did those have any evidentiary value?
They did, yes.
How so?
Some of the communications between Mr. Robinson and people that he knew indicated that he had been involved in the incident at Utah Valley University.
Okay, and you say that indicated he'd been involved. What do you mean by that?
There was, I don't recall specifically with text messages, but some of the social media chats, there were admissions that he had been involved in the incident as the shooter.
Okay.
Hey, make sure to
CSI
give
evidence,
this video a like,
was
please.
CSI
Thanks.
evidence, crime scene investigation collected in this case?
It was, yes.
Was DNA evidence collected?
It was, yes.
Does that evidence help you identify the shooter?
It does, yeah. The evidence that was obtained did provide us with DNA evidence in relation to items used during the commission of the crime, and then they were compared to Mr. Robinson.
Okay, items used meaning what?
Specifically, a screwdriver that was recovered on the rooftop of one of the buildings, and a firearm that was recovered in a tree area on
Well, that
campus.
makes sense.
And
Okay.
what? Oh, you didn't do the DNA testing yourself, correct?
I did not know.
But you're aware there have been reports that have given evidence as to the identity of DNA on that rifle. Is
That's
that
correct, yes.
Was a search warrant on the defendant's house executed in this case?
It was, yes, down in St. George.
And was evidence obtained from his house?
It was, yes.
What kind of evidence?
Kind of putting me on the spot, but if I recall, there were some bullet casings that had some inscriptions on. There were some tools that were believed to have been used to make those inscriptions. There were targets, I believe, that had been used, and also targets that had been purchased recently or just prior to the event. There was ring doorbell camera footage obtained from other residences down there. And then a number of electrical items, laptops and such that were collected as part of the warrant.
You said inscriptions on some shell casings found in his apartment. What value do those have?
That was relevant because the shell casings recovered with the firearm also had inscriptions on.
You said there was evidence. The DNA was evidence consistent, or DNA consistent with the defendant's DNA found on that rifle.
Object to hearsay.
Counsel?
This really ought to be considered under kind of a 104 rule of evidence here. We're not offering the admission of this to prove guilt, but whether or not there's a conflict of interest.
That's where my mind
existence
was.
of other evidence besides the adult child in this case is relevant to whether or not she is a material witness.
Right.
If we've got DNA proving or suggesting or proving otherwise, it's directly relevant to that. And under 104, the court can consider it.
All right. Ms. Nestor, anything further?
No, sir.
All right. Based off, so I will overrule the objection based off Rule 104, and as it relates only to this case, this hearing today.
Understood.
Sorry, could you repeat the question?
Is DNA consistent with the defendant's DNA found on the firearm that was found at the scene?
Yes, the DNA on the firearm was consistent with that of Mr. Robinson.
You said the etchings, there was etchings in that firearm, and that there's also etchings in rounds in the firearm. Is that what I understand?
Yes, I believe the chambered round and other rounds found at the time had etchings upon them.
And you said there are rounds with etchings also found on them in the defendant's apartment. Is that right?
That's correct, yes.
Okay. That firearm, where was that found?
It was found in a wooded area just off of Campus Drive, wrapped in a black towel.
Okay.
Those text messages were so weird, right?
How critical are eyewitness statements of those present to the event to identifying the shooter?
They did not provide any information that allowed us to identify the shooter.
Okay. Okay, just a moment. I move the admission of State's Exhibit 3.
No objection.
It's admitted. Thank you.
Okay, nothing else.
You're right.
All right. Counsel, I'll give you 6 minutes for redirect.
Woo, I'll talk fast, Your Honor.
All right.
And I'll run up to the front. Good afternoon. My name is Kathy Nestor. I represent Mr. Robinson, Agent Hall. You certainly seem familiar with a lot of the evidence here. Is it fair to say you're one of the key case agents in this matter?
That's correct.
All right. And as one of the case agents in this matter, certainly it's up to you to look at every piece of evidence that could be important in this case. Is that right?
That's correct.
And as a matter of fact, if I understood your testimony correctly, you said that you guys put posters up asking students, if you have videos, please give them to us. Is that right?
I believe that the posters were asking if anybody wanted to
Pretty old
provide a
school.
statement to us, that they would be encouraged to do so.
Just
You
scan the
encouraged
QR
all
code.
the kids that were there and other people to come forward and give you a statement. Did you not?
I did not personally know.
Your posters did.
The posters did, correct.
Okay. And you also put out a request for videos, if anybody had videos to present them to you. Did you not?
We asked if anybody had any information that would help us with our investigation, if they'd be willing to provide it to us. That's correct.
And it doesn't sound like you screened it. You were so like, if you have it, bring it to us, right?
I'm not sure what the question is.
You didn't screen for, well, we'll take your evidence, but we're not interested in your evidence. You took any evidence that came at you, right?
I guess the answer would be yes, because I can't.
It's about to
screen it
get
till I
really
have
loud
it.
here.
Exactly.
So I'm going to mute myself.
Is there anybody that came forward and you said, yeah, we're really not interested in talking to you at all? We're not even going to take your statement?
I believe there were people who were pre-screened who wanted to provide information that didn't have any substantiated connection to the investigation.
But somebody connected with this investigation, spoke to them and decided they didn't have any valuable information, correct?
Yeah, they documented their contact and then made that decision.
Okay. And the videos that you got, you understand that these videos have been used far and wide to look to see if there were potentially other shooters in the crowd. Have you seen this on social media? Thousands of them?
Again, I guess I don't know what the question is.
All right. Are you aware that the videos that have been taken from the scene have been analyzed by people on social media and in the press to see if there was somebody else that could have been involved in this? Are you aware of that?
I'm aware that everybody has a theory on the case. Yes.
Everybody has a theory on it, right? So wouldn't you think it would be fair to say that any video that was taken there that could one way or another address whether those theories are good or bad, or whether your theory is good or bad, you guys should at least take a look at them? Fair?
Yes.
All right. And you became aware that Mr. Grunander had a child that was present at the scene. Is that right?
That's correct.
And did you look at her videos?
I did, yes.
When did you look at her videos?
When I received them, when she was interviewed by Agent Mortensen.
So that would have been a couple weeks ago.
Correct.
All right. But when you were doing your investigation of this case initially, you never looked at her videos.
Ms. Grunander did not come forward as a witness, no.
And the Utah County Attorney's Office knew that she had been there, right?
I'm sorry?
The Utah County Attorney's Office knew she had been there that day?
At the event?
Yes.
Correct.
And they knew she had videos?
I don't know if they knew she had videos or not, but they knew she'd been at the event.
But they sure weren't forwarded to you, were they?
Not until last week, no.
Okay. When this came out and there was a motion filed in court.
Correct.
All right. And have you ever interviewed Mr. Grunander's adult child?
As I said, Agent Mortensen did that interview. I did not.
And that was done when?
Either a week or 10 days ago.
Right. And so up until about 10 days ago, you all did not look at her videos, right?
Wow.
You did not interview her.
Wow.
And the county attorneys knew that she had been there, right?
Correct.
And they knew she had videos.
Correct.
And were you?
We have an uptick in people here, and I'm sorry to be annoying, but please hit the thumbs up on the video and make sure that you are subscribed. Thank you.
You told by anyone not to interview her?
No, I was
Were
not.
you told by anyone to leave her alone?
I was not.
She seems like she kind of scares me.
You said the SBI collected over 40 statements. Is that right?
Correct.
And that's from people that were just in the audience?
The 40 that I mentioned is from people who were at the event, yes.
So people in the exact same situation that the prosecutor's daughter was in?
In terms of being at the event?
Yes.
Yes, people who were at the event.
And you thought they were worthy of taking statements from, right?
They came forward to give us statements, correct?
Because everybody's perspective is important.
If they're willing to share it, yes.
And as a matter of fact, you've gathered, as I understand it from today, I want to say around 300 terabytes of video information from the scene. Is that right?
I believe there's in the region of 248 terabytes of data from Utah Valley University alone.
And the adult child of Mr. Grunander is in the exact same position as everybody else who's given evidence in this case, isn't she?
In terms of being an attendee at the event?
Right?
Yes, she was an attendee.
And having video?
Hold on.
Yes.
Sorry,
And
guys.
having
Hold on.
witnessed things herself?
You would have to refer to her testimony as to what she witnessed.
Okay. And you mentioned, I know I have 2 minutes. I'm going to talk very fast. I know she's about to kill me. You mentioned the DNA evidence. You're certainly not a DNA expert. Is that correct?
I'm not, no.
And are you aware that the DNA evidence that was seized from the scene consisted of a mixture of at least 5 different individuals?
I'm not a DNA expert, so
So you know enough to say what helps him, but you're not going to answer whether or not there were 5 individuals mixed into that DNA.
I'm not aware of that, no.
Okay. And you're certainly not qualified to interpret complex DNA mixtures, are you?
No, I'm not.
Okay. Court's indulgence for just one moment, Your Honor. Six minutes.
Ms. Nestor, is there, I know I gave you that 6 minutes. Is there any other questions that you feel you need to ask?
Thank you for asking, but I think I'm done. Thank you.
Thank you.
Way to go, ma'am. You
All
still
right,
scare me. but-
that concludes the taking of evidence, this portion of the hearing. We'll turn to closing arguments or arguments by the parties as it relates to this. May this witness step down.
Yes.
As much as he'd like to sit there indefinitely. We'll go ahead and excuse him. All right, council, we have.
Boy,
before
mate.
we begin, I note that we have a hearing set on the break for February 24th at 10:30 on WebEx. Does that comport with the agreement of the parties?
On what day, Your Honor? I'm sorry.
February 24th at 10:30 in the morning on WebEx?
Thank you, Your Honor.
All right, and so it's the intent that the court will issue an oral ruling and a written ruling on that same day. And at that time, depending on how the court rules, will determine what we address next in regards to the motion regarding media in the
Very
courtroom.
inefficient.
And so we'll take to that point. I do wish to state that this court's mind is not made up and that I would ask all parties to continue in their roles because the court has not issued a decision in regards to the disqualification of the Utah County Attorney's Office. So I would ask that all parties continue to move forward diligently as they have, and I've made a note of that. All right, so it's 4:37. My lawyer math,
Go.
let's see.
Go. You better go.
It looks like you would get 10 minutes each for your arguments, and we will end at 5. And if you want to reserve time, you certainly can do so, but take that into account when you're making your argument. Mr. Novak.
Thank you.
Sir, you better hurry the heck up. Let's go.
Your Honor, there are legal issues and there are factual issues that we think that the court needs to look at very closely. I would ask the court, because I only have 10 minutes, to look at both the briefing in the original motion, and I will point out some specific cases that we think the court should pay attention to, as well as the briefing in the what I'm going to call the renewed request. And they're both informative. The briefing in the renewed request doesn't just go to the question of should this court encourage, that's the language that the statute hints at, the state attorney, the county attorney to refer this to the attorney general, but it also refers to when a trial court does or does not abuse its discretion with respect to recusal. The last witness, and I'm gonna just go with the principle of recency here. The last witness's primary purpose was to focus on this question of whether the adult child student at UVU is what the state has referred to as a material witness or a critical witness. And that is actually either intentionally or unintentionally a distraction from the real question here. This is not a question of whether, in order to prove its case, the state needs to call as a witness a family member of the prosecution. Okay, that could, in another situation, be a source of a conflict. But the issue here is that the most experienced and most senior prosecutor in the office other than the elected county attorney, Mr. Gray, should have been walled off from this prosecution until this court had an opportunity to consider whether disqualification is necessary. And it is important to note a couple things that Mr. Grunander said. One of them was that he'd never seen, in his experience, a decision to seek the death penalty made without regard to information about the accused. And there's a hint there that there was an emotional response to Mr. Kirk's
That I
death,
agree with.
which there's a strong implication creates an appearance of impropriety. And so this court doesn't have to make a finding that there's a conflict of interest, an actual conflict of interest. What the standard says, and that's the standard that Mr. Gray read into the record from the Organization of Utah Prosecutors that he's the president-elect of, which refers to the public perception of the integrity of the prosecutor's office and the public confidence in the handling of the case. Okay, so that was standard 1.3-3C. The failure of Mr. Gray to at least temporarily wall off Mr. Grunander, to seek guidance from any other prosecutor, ethics expert, the court, the state bar, people who are leaders or members of SWAP, the Attorney General's office, demonstrates both a very an inappropriately casual approach to this issue. And it also demonstrates that what Mr. Gray did is he put his need for Mr. Grunander to lead this case ahead of the ethical consideration of whether that might create.
If they want to win this case, he better go to Toastmasters. He better just like really improve his argument skills, because this is, I'm just saying,
An appearance of impropriety, not an appearance in Mr. Gray's opinion, not an appearance in Mr. Grunander's opinion, but an appearance in the public eye. And that's actually your honor's project, if I may, is to determine what a reasonable member of the public would think of this scenario. The other thing that is important here is that we are dealing with a proceeding where the Eighth Amendment to the United States Constitution and the parallel constitutional right in Utah require, and this court has heard it already, and the court's going to hear it over and over again, a heightened standard of reliability. This is not just a court proceeding, and it's not just a criminal proceeding. This is a capital proceeding, which is at this point in time sort of almost the only proceeding where the Eighth Amendment comes into play. And so this court needs to view the appearance of impropriety under this heightened standard of reliability.
Today, counselor.
A couple Utah cases that I think that this court, we would ask this court to look at very closely. State v. McClellan, Utah Supreme Court, 2009, Utah 50. State v. Cater, C-A-T-E-R, 2014. I'm sorry, yeah, that's a Court of Appeal decision. 2014, Utah Appeals 207. Mr. Gray should have implemented a firewall, and he didn't. And that has created this problem. And then what we see is isolating Mr. Gronander's daughter from the investigation, isolating her in some way so that she hasn't provided a statement, she hasn't provided videos until we bring this issue to the court's attention.
Okay, you done?
The decision as to what charges to file, the decision as to whether or not to seek the death penalty should never, ever have been made in consultation with Mr. Gronander, even if he's the most experienced homicide prosecutor in the office, even if he has one of the longest tenures, and even if it's Mr. Gray's ultimate decision. Because now we don't really know, and the court doesn't know, and the court just can't defer to the prosecution. That's the whole point of the court having the supervisory power over this issue. What influenced Mr. Gray? I would also point out that Mr. Gray did not disclose until asked,
I don't
while
know,
under oath,
Chris.
that 2 members of his faith community were also present there. That was not disclosed to us when he found out about
That I'm sorry, but this is my channel, so I'm going to pause it. What he just said is 100% where my mind was at. Like, he didn't disclose that they were a part of the same ward. And as we learned in the Jodi Arias trial, we learned how important the ward is amongst its members. So this is just mind-blowing to me. If you don't understand that, I absolutely recommend you either go back to my videos on Jodi Arias, or you Google like the importance of a ward or what is a ward in a Mormon community. And hopefully that will explain it, because this is absurd. We are setting this case up for appeals, and it's very disheartening.
that, and that he has a relationship with the family of some young person who was also negatively impacted. This line of sight analysis, this PIE that has been diagrammed is not the question. That is not the question. The question is whether Mr. Gray should have isolated the prosecutor whose child was there, and I say this with all due concern and respect, could have been injured in any number of ways. People could have been hurt leaving the scene. And I'm not saying that in any way to minimize the effect that experience had on Mr. Gronander and his family.
Hasn't it been 10
I think,
minutes?
as I said in
Will?
court last time, I've been through this, where I learned that my child is somewhere where there was a shooting. And until I knew my child was safe, that was an overwhelming emotional experience. So the problem is that Mr. Gray approached this in an incredibly casual way. There isn't a single memorandum, he testified to this, documenting the process of whether there's an actual conflict or an appearance of conflict. The mere disclosure of it to us and us bringing it to the court does not wash this clean. That is our concern.
He was definitely not on the debate team, y'all.
I also want to
God.
cite the court, because I'm running out of
Yeah,
time,
you are.
to a decision that is not a Utah decision, but it's cited on page 12 of our motion, which is Tate, 925 Southwest 2nd, 548, a Tennessee decision.
What do you
Where
guys
basically
use
the
for
court
driving?
says where there were no screening procedures and the prosecutor, as to whom there was an appearance of impropriety, maintained the role of a supervisor, and there was open discussion of the case with him, there should have been a disqualification. And what the court did there is it disqualified the entire office.
Mr. Cameraman, what are you doing? You've already been in trouble
Avoided
once
if
today.
Mr. Gronander had been screened off, if Mr. Gray had sought this court's guidance early,
the state, I'm sorry, they were in court on September 16th. This could have been brought to the court's attention in September. Counsel were appointed shortly thereafter. We could have addressed this a long time ago. And now, frankly, it's too late. So we understand that there is pressure on the judicial system to move this case expeditiously. There is also a countervailing, and we believe
horrible order,
stronger need to make sure that there's a heightened standard of reliability, that there is no conflict, and that there is no appearance of conflict. And if that takes a little bit of time for another prosecution office to get up to speed, the investigation is going to continue, the discovery production is going to continue, the lab work is going to continue. None of that is going to change. So we would ask the court, I'm not reserving any time in rebuttal. I'm going to ask the court to grant the motion, both parts of it, which is to make a finding that Mr. Grunander should have been walled off and that Mr. Gray's failure to do so, and sort of the casual way that Mr. Gray approached this whole thing requires, unfortunately, the disqualification of his office and the appointment of a new group of prosecutors to be responsible for this case. The case will continue. What we are asking the court to do today does not in any way change the fact that Mr. Robinson is charged. He's charged with an aggravated homicide. We all have to deal with that, but we have to deal with it in a way where there is no question that the decisions that have been made or decisions that will be made in the future, which is some questions that were brought up to Mr. Gray by his own counsel.
Oh my God.
And the public's confidence in the outcome of this case are tainted by what should have happened and did not happen.
How?
And I appreciate
Why
the
is the
Thank you, Mr.
cameraman
Novak.
doing this?
To the state, looks like Mr. Novak took
Way too much friggin' time.
13 minutes.
I'll pay you back later.
Thank you. To the state, I will afford you that same time frame. If you want to take all 13 less, I'll leave it to you.
I know everybody in here is going to blame me if they don't leave at 9, which is 5 o'clock. So,
Okay.
The reality is, Your Honor,
Violin.
the adult child is not a witness here. She didn't see Charlie Kirk get shot. She didn't record him get shot. She didn't see his wound. She didn't see him get carried off. She's just not a witness. And as a result, there's really no conflict here. Now, I understand that conflicts go beyond just that, but most of the cases that we look at where there's some kind of conflict are where there's confidential knowledge that has been obtained by the prosecutor, right? A defense attorney becomes a prosecutor and now has confidential knowledge about that person, right? That's the typical conflict we see. Has some kind of proprietary or financial interest, right? That's the kind of conflict we usually see. Occasionally there are personal conflicts, but there's a lot of good case law that talks about what kind of conflicts constitute that personal interest. And I think the best case law on this is cited in our opposition to the renewed motion to refer the matter. And in that case, State v. Newman, the court found, this is a Missouri case, the court found no conflict of interest in prosecuting a defendant for murder, even though the prosecutor had done business with the victim, knew him personally, and served as a pallbearer at the victim's funeral. In the Gwinnett County District Attorney, nor his Georgia office had a conflict of interest, even though his chief investigator dated and later married the victim in a case that the office was prosecuting.
They're the most corrupt out of them all. So
in Kansas, prosecutor's office did not have a conflict, even though the defendant threatened to blow up the very courthouse and also housed the district attorney's office. I mean, these are cases where the prosecutor has a close relationship with the actual victim of the crime. Look, if Mr. Grunander were related to Charlie Kirk, we would acknowledge there's a conflict here, right? But we're not even close to that. the adult child is not even a witness in this case, is not a witness to the murder. Is the child a witness to the circumstances? Sure, but so are 3,000 others, as well as dozens of video recordings. She's not a witness. She's not necessary in this case. And as a result, there's no conflict here. Now, is he going to be motivated because she was present? Is he somehow going to be motivated to do something he otherwise would not? Well, again, maybe if she were injured, maybe so. Maybe there would be a good argument there. Maybe it still doesn't rise to the level of these cases that I've talked about, but that's just not the fact. She has not been traumatized. She has not had to seek therapy. She has not had to miss class. It's not affected her friendships. As a result, the idea that Mr. Grunander is going to be motivated by some kind of retribution for what happened to her is just flatly false. The idea that the defendant was charged for killing someone because a prosecutor's child was present when it happened is just, it's almost laughable. He's being prosecuted for killing someone because he killed someone. At least that's what the evidence will show, we believe. The idea that he has been, that the death penalty has been elected because a relation of a prosecutor was there is just laughable. It's because someone was shot and killed. That's why the charges were brought. I just don't think that proposition is palatable at all. The evidence is what this case was charged on, both at the charging level and at the death penalty level. None of this was motivated because of some relationship. And I think that anybody who looked at this would agree that you don't charge someone with murder because a witness was affected by it. You charge someone with murder because someone was killed, right? The standard. The defense has tried to elevate the standard here by looking at best practices, the SWAP's Statewide Association of Prosecutors best practice. Even so, I think it's been misstated. The standard says that when there's an appearance of conflict, the prosecutor should, I quote, consider recusal.
Yeah.
Well, that's the question. They should consider it, right? It doesn't say it mandates recusal or disqualification.
Yes.
And that's not even the ethical standard that this court goes by. That's the best practice.
This is
and
all
the best
a
practice
joke.
was followed in this case because once that fact was known, there was a discussion. Of course, it was disclosed immediately. It was disclosed 5 days after defense counsel was appointed. The idea that the child was isolated is just flatly false. She just was not a witness. And the follow-up with her showed as much. The standard is there a significant risk that representation of the state will be materially limited by a personal interest of the lawyer? In this case, the decision to prosecute and the prosecution of this case will not be limited in any way. Moreover, if anything, the interests would align. Regardless, the motivation here is clearly not because of the presence of this child. It's because Charlie Kirk was murdered in front of everybody. She's not a material witness. Everybody knows Charlie Kirk was shot and killed and murdered brutally. Everybody knows that. I don't think that's going to be what this case is about. It's going to be about identity. And neither the child nor any of the other 3,000 witnesses present really have a whole lot to say about who this was that did the shooting. And that's what this case hinges on. There's been no evidence that Prosecutor A's child
I would assume it
had
would.
any effect on the prosecution of this case to date. And there's no reason to believe it will have any effect in the future. The testimony was clear that no one anticipated that based on her lack of value as a witness and the lack of trauma or injury to her. There really shouldn't be any question about that for this court, for the public, or anyone else. Thank you.
Thank you. Thank you to all parties. I acknowledge the hard work and effort that went into today, and this court appreciates that. We will reconvene on February 24th at 10:30 in the morning via WebEx. And just for clarification to defense, in regards to Mr. Robinson, how would you like Mr. Robinson to be present at that hearing?
Your Honor, Mr. Robinson, I believe it's WebEx for everyone, right?
It is.
He can also be on WebEx, Your Honor. We would waive personal appearance for that.
All right, thank you. All right, with the new date set.
Wait, I'm sorry, just a minute. Oh, sorry, audio only. Thank you for my co-counsel. Audio only, no screen.
All right, I appreciate that clarification.
Thank you, Your Honor.
And with that, court is in recess.
Okay, but I'm not, so don't leave yet.
10:30.
So, first and foremost, if you haven't done so already, please make sure to hit the thumbs up button. That gives me a like. And if you aren't already subscribed to the channel, please double check. I heard about a bunch of people, like legit content creators, million plus creators, having YouTube delete non-bots recently. So that's very concerning. So if you could just make sure that you are subscribed, that would be immensely helpful. Coco is very concerned about it as well. As you can see, let me go ahead and get this off the screen. And this was wild. This whole situation. And I can't believe that, like, I really can't believe that the judge is going to wait until court that day to issue his ruling. Like, not a week before, not a day before, the day of that they are supposed to meet on this WebEx. They are going to have to wait to receive his ruling, which there shouldn't. I can't even believe that we're here. The defense and the state, well, I would argue that the state did a far better job in that closing, but defense really crapped the bed, as some may say, with that argument. It did not go well. That was very disappointing because this is so important. They need, I think, a change of venue and to have different prosecutors. And I don't think it's going to happen. I think that the judge is very much convinced that there is no issues of impropriety or appellate issues, which is just crazy. All we're doing right now is we are watching a case go through the motions only to end up in appeal. Period. Stop. Like, full stop. Also, another thing, if you have not filled out the Google form, just so you know, the idea is that I'm going to be launching my merchandise website, and I finally have items on there, but I want to do a little bit of hype before I launch it. So if you could please make sure to fill that out, and you will be on the prize wheel next week when I'm giving away prizes during my streams. And if you are new here, I go live Tuesday through Fridays, beginning at 3:30 p.m. Eastern. And when you are a member of my channel, you get your comments on stage. You are invited to exclusive members only live streams, you receive an extra discount on the merchandise website, and you get emojis that other people don't have. And when I start to implement the game nights, you get like reserved spots to participate in the games. There are some other things. If you look on my channel, it'll explain everything that comes along with being a member. But in order to become a member, you have to make sure that you are able to receive gifts. And I have just linked that. Well, I've just posted that link right there. So you can click on that and it'll tell you if you are able to receive gifts. And then here is the merch giveaway form. So in order to be considered for it or have your name entered, you have to fill out a very non-exploitive questionnaire, like, do you have Discord? If not, can you provide me with your email and what's your YouTube username? If you don't want to have your address, if you don't want to provide me with your physical address, what I was going to do was send you like a virtual gift card that you can use on my website. So I've thought through this, you guys. I think that you will like it. Also, I know that we've got things to do, people to see, people to do. Oh, was that offensive to you, Coco? But I personally would like to finish the opening statement of the state in the Edrick, state of Georgia versus Edrick, whatever his last name is, case. We'll fly through it. We have like 30 more minutes left, and I have it at 1.5 times speed. So it is regarding the unaliving of Tara Baker that happened in 2001. And they basically took a whole bunch of DNA at that point, but this guy just flagged the system. So he is on trial for 12 counts of very horrendous crimes. I would really encourage you to stick around, because what I'm looking at right now is the screen that I'm about to share with you of the opening argument for the state, and it explains the case. So let's go ahead, get that done, and then tomorrow we will continue with this.
$480 from the teller. I expect you're going to hear about some visits that he made to a place called Truck Customs. Remember, Chris is starting to do his own thing. He's got a truck. He's in the plumbing business. He needs a pipe rack. He needs a ladder rack. So we go into this place called Truck Customs. First time, I think maybe around 10 o'clock. Second time, later in the afternoon. And it's at that second trip to Truck Customs, ladies and gentlemen, where Chris gets a call from Tara's mother. Something's happened in Athens. You need to come over.
Faust.
Ladies and gentlemen, all those facts were established fairly early in the investigation. Now, you're going to hear about Chris's reaction when he got the call from Tara's mom about something happening in Athens, how Josh actually had to drive him in his own truck to
Chris
Athens.
is the boyfriend.
And even with all of this, ladies and gentlemen, with those facts being established early in the investigation, Chris was always under the microscope as it related to Tara's murder. He was asked to give blood. He was asked to give a sample of his head hair. He was asked to give a sample of his pubic hair. Chris was subjected to repeated interviews by law enforcement. Every time anything's ever been asked of him, his answer's always been the same: whatever you need. The evidence will show that Chris has been fully cooperative for over 25 years. I'm going to try and move a little bit quicker now because I think I'm taking longer than I intended. But there is a lot of other investigation going on in this case, ladies and gentlemen. This is a 20-plus-year-old case. The state is not going to present to you everything that was done over the course of this 23-year investigation. From a period of time, several months after Tara's death in 2001 until 2024, we're going to talk more about that soon, there was a lot of work being done on this case. But there was nothing that would point the police in the direction of Tara's killer. There are tens of thousands of pages of police reports, records. There are hundreds of hours of interviews. It would take months to present all that in court, and we're not going to do it. And in so doing, we're not trying to hide anything. We're being mindful that it is an absolute impossibility to show you every lead that was chased down and every lead that became a dead end. About the dozens of persons of interest who were identified but ultimately ruled out. Hard work, frankly, just didn't result in any relevant evidence.
If you are interested in seeing what he was charged with, please look at the chat. I am not able to say those words out loud without getting in trouble because YouTube doesn't like real life. Thanks.
One example, in 2010, the ligature, the printer cord, and the knife were retested for DNA. Not just the blood, to see if there was any touch DNA on those items. And once again, only Tara's DNA was found. I expect over the course of this trial, you're going to hear about some missteps and some unanswered questions. Remember that window frame I talked about earlier? Well, the window frame was obviously taken into evidence back in 2001, but now, 25 years later, it's missing. And that's unfortunate. But what is fortunate is that you're still going to hear about the processing of that windows frame that was done back in 2001 and how, again, there were no prints recovered. You'll hear that Tara's laptop, the one that I mentioned had been taken from her room, has never been found. And lastly, as far as unanswered questions go, I'd submit to you the evidence can show that no one investigating this case has been able to quite figure out exactly how the defendant got in and out of 160 Fallen Drive. Was it the kitchen window with the frame that showed signs of tampering? Was it the back door? To this day, ladies and gentlemen, there's no definitive answer. And the state's not going to be able to show you the answer to that in this trial either. That fact is not necessary to prove the defendant's guilt.
Inexcusable.
And so again, with all this investigation going on and no leads being developed, the case goes cold. Something happened that changed all of that in 2023. Something called the Coleman-Baker Act was signed into law by Governor Brian Kemp. In case you hadn't figured out, the Baker part of that act is named after Tara. This is a law designed to address cases exactly like this one, where all leads have been exhausted and no likely perpetrator has been identified. What the law does is it directs new eyes to be placed on the file. See if all appropriate forensic testing and analysis was done in the first instance, or if additional testing might produce evidence or information relevant to the investigation. And so at this point, enter into our story Agents Liz Bigham and Jeremy Howell with the Georgia Bureau of Investigation. Agent Bigham, Agent Howell are longtime agents with the GBI, and they joined that cold case unit after the law was enacted. In December of 23, they started looking at this case. And one of the first things they did was a dogged re-examination of all the physical evidence in Tara's case, including the sexual assault kit that had been taken at her autopsy. That kit was resubmitted for testing in February of 2024. And so, ladies and gentlemen, lots changed about DNA and the way DNA is tested from back in 2001. I expect you're going to hear that the sensitivity of that testing has improved greatly. And so, in February of 24, the crime lab was able to find first male DNA and then obtain a DNA profile from item 2I. It's going to get confusing. We can clear all this up later about the names of those items. 2I is labeled oral swab B. It's pretty confusing. And so,
how is that confusing, sir?
Upon further testing of 2I, what they do is they separate the DNA into what's called fractions. I'm not going to get too much into the details of it now, but the idea is you're trying to separate the female DNA from the male DNA. 2I, the oral swab B, the first fraction is a match to Tara Baker. In the second fraction, there's a partial major profile of male DNA. And that DNA is not Tara Baker and is not Chris Melton. In case I haven't been clear, when I refer to a profile, what I'm, for lack of a better term, talking about is a DNA fingerprint. So when I talk about profiles, that's what I mean. But that profile, that partial major profile from item 2I, was eligible to be submitted into something called CODIS, CODIS.
Look at
That
the
stands for
chat.
Combined DNA Index System.
Everybody.
CODIS is a national database of known DNA profiles. I think that as of November last year, there are about 26 million known profiles in CODIS. And once that profile from item 2I was uploaded into CODIS, the way it works is it is routinely compared against the 26 million known profiles to see if any leads could be developed. On April 30th, 2024, there was a hit. And it was that DNA, again, matched from item 2I, and that hit was to the defendant, Edrick Faust. Ladies and gentlemen, that is the first time in 23 years and tens of thousands of pages of this law enforcement file that Mr. Faust's name shows up. So what do we know about Mr. Faust? He lived at 350 Cooper Road, and we talked about Cooper Road earlier. You can see it there. It's actually at the top of this picture. The star represents 160 Fawn Drive. I'll get more into that in just a minute. Cooper Road, again, at the very top, going horizontally in the picture. If you were to go left on Cooper Road, that's where you're going to run into Lexington Road, just to give you some orientation. Mr. Faust is living at 350 Cooper Road. 350 Cooper Road, ladies and gentlemen, is literally 585 feet from 160 Fawn Drive.
Yep. I remember that he lived close by.
So, next, what happens? Agents Bigham and Howell obtain a warrant to get Mr. Faust's buccal swabs, cheek swabs. And the purpose of that is to get a known sample of his DNA. CODIS, only lead, you got to confirm it. And again, the first fraction from oral swab B, Tara's profile, it's always Tara's profile, vaginal, oral A, oral B, we'll clear that up later. Always Tara's DNA in that first fraction. And in that second fraction, you're gonna hear about there being two profiles, but the major profile, the partial major profile from item 2I was a match to Edrick Faust. And that match, I might mess up the wording of it, was 1 in 800 quadrillion.
I have objection, Your Honor. And I have a motion.
Oh, he's got a lot.
All right, ladies and gentlemen, I'm going to have you go back into the jury room. Don't discuss the case. Thank you.
Okay. Her nerves. She's like, I'm trying to scoot. What in the actual heck?
Pretty conversational nature between the defendant and Agents Bigham and Howell. And then at the end, they tell him what the charges were for. Agent Howell actually says, he's referring to Tara here, don't you remember? It was kind of a big deal. Agent Howell offers, if you can help us understand why your DNA is in that house, help us. I'm here to exonerate just as much as I am to hunt. And you'll hear the defendant's reaction. Ladies and gentlemen, at the beginning of my opening remarks, I talked about how this trial represents the final chapter in a long, sad saga for both the Baker family and for the Athens community. For decades, everyone who loved Tara wanted to know who killed Tara Baker. Ladies and gentlemen, Edrick Faust killed Tara Baker. Edrick Faust sexually assaulted Tara Baker. Edrick Faust set her house on fire. And now, the final chapter begins today.
Yeah, they're not letting in the
last few pages of the
sidebars.
story haven't been written. At the end of the trial, we're going to hand you the pen, and you, the jury, will write those last few pages. And when you do, you'll have the evidence to write the correct ending to this horrible saga. Ladies and gentlemen, I didn't say the happy ending. That's not possible. The correct one. You'll have everything you need to know to write the ending that the facts support and that justice demands. An ending that finds, beyond a reasonable doubt, the defendant, Edrick Faust, is guilty as charged. Thank you.
All right. We have a little bit of time, and I know that viewership is not as high but it hasn't been ever since I've been on vacation. I'm going to start the defense and go until 8 and then cut it off. So just giving you guys a heads up. Oh, I have to go to the dentist tomorrow. So tomorrow's live stream is going to be short and sweet. That was the other factor into having a little bit of a longer stream tonight. So it doesn't help me with getting back on YouTube's good side with the algorithm, but I gotta go get my teeth checked out before I go back to Florida. All right, here we go.
My name is Attorney Ahmad Cruz, and I have the privilege.
We are
and the
definitely
honor
going fast with
standing
you,
beside
boy.
Mr. Edrick Faust during this case. First and foremost, I want to thank you all for your sacrifice and taking time away from your families, your jobs,
Thank you.
and your very important matters to sit and listen to the evidence the state presents in this case. We intend to get you all home as quickly as possible. Once you have all the evidence that you need to make a decision, and not a moment before. First off, you can see on your screens, I'd like to tell you what happened. You all sat through 5 days of jury service and no one ever explained to you what happened. Then we're going to talk about how this is a crime of opportunity, the evidence that you were here supporting that this is not, let me put it this way. You'll hear evidence supporting that this is a crime of opportunity. Then we'll get into Chris Melton's and Tara Baker's relationship and what the evidence will show there. That is going to be very important in this case to understand what was going on with Miss Baker and Mr. Melton before she passed.
A lot. I can tell you that right now.
Excuse me. Then I'd like to talk about with you the initial investigation in this case. This investigation, when it came to Mr. Faust, that isn't the initial investigation, but this investigation, when it came to Mr. Faust, you may decide that this is one of the most thorough investigations in Georgia history. In fact, you will learn that this investigation reached a level of desperation. And at the end of this trial, you are going to have questions that the state is not going to be able to answer. And I believe during the state's opening, they admitted one, which is they cannot present evidence to you, or they cannot answer the question of how Mr. Faust would have gotten into Miss Baker's home. They also can't answer the question of when did Mr. Faust's DNA get in Miss Baker's body. They don't know. They won't be able to answer the question, how would Mr. Faust get away from Miss Baker's home unseen at the time of the morning that they said he committed this crime? The evidence will show that in Deer Park, Black people simply walking were reported. In fact, on January 19th, 2001, the day Miss Baker passed away, there were 3 individuals reported, excuse me, 2, but one person was reported twice.
Why are you running?
Black male. He had a afro, and he was wearing a bright orange shirt. And the witnesses say, hey, he's just walking normally through the neighborhood. Is he looking around suspicious? No. Is there anything unique about him? No. Actually, when I pulled out my car to get out the driveway, he stopped for me. So the state won't be able to answer if they're reporting individuals walking through the neighborhood. How did Mr. Faust get away unseen?
We have Mr. Attorney at 1.5 because the people down in Georgia talk real slow.
If Mr. Faust killed Miss Baker, why was the hair that was found on her body, around her body, in her hand, and on the murder weapon of Caucasian origin? You will hear evidence in this case that there is not a shred of evidence that puts Mr. Faust, let alone a Black person, in Miss Baker's home. All of the evidence, including the gift Miss Baker left in her hand, for police, it's Caucasian hair. Now, the state, these questions have to be answered with evidence, not speculation, not with sensationalized media coverage, and not with unsupported conclusions. These are questions the state must answer for you with evidence and proof. The state may spend a lot of time talking about Mr. Faust's DNA. That is not an issue in this case. DNA is not an issue in this case. But they may spend a lot of time talking about Mr. Faust's DNA being present among, as they presented to you, the multiple DNA profiles that were found and identified. But you may find yourself asking this question at the end of the state's presentation of evidence. How does Mr. Faust's DNA simply being in Miss Baker's body, along with someone else's DNA profile, establish that he is the person that killed Miss Baker?
This is a different case.
And this is why you all are here today. This is why we are here today. We're not here to talk about, and the state is going to present this type of evidence. We are not here to talk about how bad of a person Mr. Faust may have been, how horrible of a boyfriend he may have been. That's not evidence in regards to what they must present to you to prove that Mr. Faust is the individual that committed these acts that they've chosen to charge him with in the indictment. We're here to talk about and find out whether the state's evidence proves beyond a reasonable doubt that Mr. Faust committed the crimes that he's charged with. That's it. That is why we are here. And in this trial, the question is not who killed Ms. Baker. That is not the question that anyone is asking you to determine. But again, the question is simply, does the state's evidence that they present to you prove that Mr. Faust, proves beyond a reasonable doubt that Mr. Faust is the person responsible for burglarizing Ms. Baker's home? He's charged with burglary in the indictment, sexually assaulting Ms. Baker, and killing Ms. Baker. That's the sole question you have to answer. Not who did it, just does the state's evidence support beyond a reasonable doubt that Mr. Faust is the person that committed this crime? And that's the key issue in this entire case. And you may get distracted by emotion in this case. You may get distracted by your dislike of Mr. Faust's life choices. But you cannot lose focus, and you cannot forget why we are here today. You are here on a murder, a rape, an aggravated sodomy, and a burglary case. You're going to learn that this is not a case of stranger on stranger violence, but rather a case of interpersonal violence. Interpersonal relationship violence. But you cannot be distracted. You can't be distracted. The reason we all chose you is because we thought you were the best jurors to sit on this case. You would not be distracted by emotion, and you would let the law guide you and come to a just decision. The death of a person is a horrible, horrible tragedy, and no one in this courtroom would tell you otherwise. We are not the media. We don't have the opportunity to speculate and draw in viewers. We don't have the opportunity to sensationalize this case of Ms. Baker's life. And that's what we're going to talk about during this trial, is Ms. Baker's life. We're going to show you what Mr. Faust looked like in the year 2000.
You just say
This is
what?
Mr. Faust in the year 2000. He looks completely different than he looks now. What we put emphasis on, and what you'll hear in evidence, is this is how Mr. Faust carried himself. He was a very well-dressed, clean-cut individual. He wore jewelry, he drove nice cars. We expect the evidence to, we expect the evidence to show that. We're also going to show you a picture of Mr. Faust on February 8th, 2001, which is about 2 or 3 weeks after Ms. Baker's death. This is Mr. Faust about 3 weeks after
He's
Ms. Baker's
handsome.
death. Without a haircut, obviously, without his jury in, but this is a picture of Mr. Faust. And the evidence will show this is how Mr. Faust looked after Ms. Baker's death. In 2001, the evidence will show that Mr. Faust was a 25-year-old bar-hopping playboy. You will hear from some of Mr. Faust's ex-girlfriends, particularly the state will call Ms. Brenda Sweeney. And you will learn in this case that the state, Ms. Elizabeth Bigham, she will testify that she's reviewed every single document in this case file. And based on her review of that information, what you will learn is that Mr. Faust did not stay at 350 Cooper Road. Mr. Faust actually stayed in Knollwood Apartments with his girlfriend, Ms. Brenda Sweeney at the time. And this is information that the state has had before today and during the entire pendency of this case. So what happened? That's the question that we're here to figure out. What happened with Ms. Baker? This is Ms. Baker shortly before she passed. This is her law school photo that she took while she was a student at the University of Georgia. And these are Chris Melton's hands after Ms. Baker's death. So Ms. Baker was killed on January 19th, 2001. These photos were taken on January 21st, 2001. This is Mr. Melton's left hand. This photo, these are Mr. Melton's right hand. During this trial, you will learn the nature of Ms. Baker's death. It was an overkill. And what we mean by that, it was terrible. That's the best word I could use. It was terrible. It was a horrible death. Ms. Baker was not only unalived, but the person who did this to Ms. Baker, they beat her, they punched her over and over and over again. And you will hear from the medical examiner the injury she had to her face. Her eyes were swollen and blackened. And then this individual, and we don't know the order, but this individual, this sick individual, then took Ms. Baker's printer cord and wrapped it around Ms. Baker's neck.
Oh, God.
And he laid on top of Ms. Baker as he pulled the opposite ends of that printer cord, strangling her. That individual at some point, again, we don't know the order that this took place, but these are the things that took place. This individual at some point walked to Ms. Baker's kitchen, pulled out a knife out of her knife block, and then stabbed Ms. Baker in her neck. And you'll hear that Ms. Baker was stabbed on the right side of her neck. This wasn't enough for this individual. This individual then went into the living room of the home, took Ms. Ashley Hall's chenille blanket off of the couch, went and turned on the eye of the stove. They put the blanket on the stove. When this blanket caught ablaze, what occurred was this person walked back into Ms. Baker's room while Ms. Baker laid on the floor, still grasping for air. You will hear that.
Oh, sir, we cannot hear you, sir. We have another defense attorney who doesn't understand the concept of a friggin' microphone.
But this person takes her laptop, again, closes her door, locks it, goes to her bathroom door. You saw a picture of it in the States opening. Closes the bathroom door, locks it, and takes his time to clean up Miss Baker's house. As the state mentioned in their opening, this person wiped down the door. This person wiped down the stove handles. This person wiped down the back door. This person wiped down the windows. And when firefighters, obviously fired a couple hours later, fire burst through the roof, you will hear from firefighters that in order to get in his home, they had to kick in the door. And it was deadbolt locked. And the type of doors you'll learn that Miss Baker had, the top lock has a key that you can put in. You have to unlock it to unlock the deadbolt. The bottom lock,
Hey, Nicole.
just twisted. They had to kick in the front door. It's deadbolt locked. And the back door. There's so much smoke, and the state said this in their open. There's so much smoke in the house. The firefighter goes to the back door to unlock the door, and the deadbolt is locked on the back door.
Buffalo, it's about the question on the screen right now.
Is that when firefighters found Miss Baker, the individual that did this to her, this was somebody she was comfortable being naked with.
Oh, I have to take Prilosec with spaghetti.
The state's not going to present any evidence that clothes were found near her. The state's not going to present any evidence that a towel was on her. She was completely nude. No clothing on her body at all.
Well, I'm glad we made conversation while he was talking to the jury because I didn't hear jack for crap. Really trying not to curse so much on here.
Now, while this individual was strangling Miss Baker,
just stay by the microphone.
Scratching at this individual's hands while he was trying to strangle. While he was choking Miss Baker, trying to get him off. While he was choking Miss Baker, grabbing his hair, trying to get him off. And the forensics evidence, we'll get into forensics, I won't go there now. The forensics evidence will support that Miss Baker was fighting for her life. Now, I mentioned the back door, that the back door was deadbolt locked. You will hear from a young lady by the name of Miss Kishana Armstrong. She's Miss Baker's niece. Miss Baker stayed at 160 Fund Drive. Miss Armstrong stayed at 140 Fund Drive. So if you're looking at this map, Miss Baker's home is here, where the blue target is. Miss Armstrong's home is right there. And what Miss Armstrong can tell you, and this is the same thing she told law enforcement 20 plus years ago that they ignored, was that, hey, it was 7:45 in the morning. I was going to my car because I had classes. I was getting ready to go to school. And to my surprise, I found it odd that a white guy was running through my backyard with a white t-shirt on and light blue jeans. And Ms. Armstrong is going to tell you. You'll see a photo of it. But Ms. Armstrong is going to tell you, she's going to testify. What she'll tell you is this person, I can't remember the face, this is 24 years ago. And you'll learn police never followed up with it. They never showed her a photograph of Chris Melton. And as the state said, Chris Melton was the center of the investigation, right? But they never showed her a photograph of Chris Melton. They never gave her a photo lineup. They said, hey, you recognize anybody in the photo lineup? So what she'll come in and testify to is, hey, I don't remember the person's face. I can't really remember the person's hair, but I do remember the person has the exact same color hair as Chris Melton. That's what Ms. Armstrong is going to tell you. This is Chris Melton, back in 2001. Ms. Armstrong is going to tell you that
This cameraman sucks.
I do vividly remember this person's hair color. And what you'll learn is police never even asked her hair color. They don't even ask her. When they interviewed her 20 years ago, they don't ask her the hair color. Only thing they ask her, how tall is the person, what age group does he look like he's in, and she'll say
He kind of looks mean.
kind of like a medium athletic type of deal. And they're aware that Miss Baker is dating Chris Melton. They never show her a photo of Chris Melton. You will learn in this case that law enforcement ignored Miss Armstrong for 25 years. We had to reach out to Miss Armstrong. Once Mr. Faust was arrested, Miss Armstrong was no longer needed. Crime of opportunity. I told you that I would talk about how this crime is a crime of opportunity. During this trial, one of the most important facts that you all will learn is that Ms. Baker did indeed have 2 roommates. One of her roommates is Dr.
It's not his mic connection. It's him friggin' walking away from the platform.
PD Hall. At the time of this case in 2001, she went by Miss Hall.
It's always the defense
You will learn
attorney's
that
tale.
each girl had a boyfriend. We were counting Miss Baker, Mr. Mel. So at any given time, you learn 6 people in the house. And it was very rare, your testimony was very rare that someone would be at the house alone. However, on January 18, 2001, being great roommates, Dr. Lowe tells Miss Baker, hey, I'm not going to be home. We can tell that she was going to her boyfriend, so she's going to be out of town. Miss Ashley P. Hall tells Miss Baker the exact same thing. And you will hear testimony about Miss Baker's response. What you will know is that Miss Baker was home alone. What you will also hear is that Miss Baker and Chris Melton spoke the day before her death 5 times. There was a 22-minute call. There was a 5-minute call. There was a 19-minute call. And there was 2 other short calls the day before her death between Miss Baker and Chris Melton. And when law enforcement asked Chris Melton the day of the crime, the day close to the crime, hey, did you know that Miss Baker was going to be by herself? He said, of course not. He said, of course not. I didn't know that. She wouldn't have told me anything like that. But I do remember me telling her that I wouldn't be able to come down to Athens to spend the night with her. A couple of years go by. And police do this as part of the investigation tactics. Police asked me again, hey, do you remember if Miss Baker told you that she was going to be home alone by herself the day before she died? Chris Melton then tells law enforcement, I don't remember. So a question that you will have to ask, maybe a question that you will have, is if your future fiance told you she was going to be by herself and died the next day, is that a fact that you will forget? You will also learn about the nature of their relationship. Dr. Lowe will tell you.
Stay.
Ms. Baker and Mr. Melton, first semester of law school like this. Mr. Melton will probably testify that if there are 7 days in a week, 5 of those days, him and Ms. Baker would be together. And this is first semester. But you will hear from Dr. Lowe that on New Year's Day of 2001, she came home, and to her surprise, Ms. Baker was home alone. She talked to Ms. Baker about it. She asked her about it. Ms. Baker didn't respond. But Dr. Lowe will say there was a change in relationship from that day up until the time Tara had died. They were not spending as much time together as they used to. But you'll also hear from Ms. Baker's best friend. And I say best friend because Chris Melton stated, and that may be his testimony, that Mrs. P.D. Hall was Tara Baker's best friend. She described the relationship with law enforcement as it's pretty much like watching the normal ending of a relationship. But when law enforcement asked Mr. Melton about the relationship, Mr. Melton said, oh, everything was fine. I was about to shoot my borderline fiance, we were about to get married. It wasn't until 5 months later in June when law enforcement approached Mr. Melton and said, Chris, we heard about a fight that you and Tara had a week before her death. Do you know about that? And for the very first time, he admits that there was trouble in paradise. He says, oh yeah, I know about that. It wasn't a big deal. It was something minor. Now, in the evidence that was provided to us, it wasn't provided to us. You'll learn that we don't have any information on what that fight was about except what Chris Melton said it was about.
Really inconveniencing us there.
Chris Melton, when he interviewed with police in 2024, he told law enforcement that he had not seen Tara Baker in 10 days. Okay? That is very important. He said that I had not seen Tara Baker in 10 days. That 10 days lines up with their last fight. When Chris Melton said, 5 months later, I remember this fight. That is an important date to remember. Because in 2001, when Chris Melton was asked, or matter of fact, he wasn't asked, Chris Melton was told that there was DNA evidence in this case in 2001. When they told him it was DNA evidence, Chris Melton volunteered. I was with her 6 days ago. She was at my parents' house, and we had sex 6 days ago. And then he asked, did y'all find semen or anything on it like that? But this is the issue. Law enforcement failed to follow up. They met with Chris Melton's parents, and you would think it's a significant piece of information that you saw a young lady that died at your home the week before she died. The parents never mentioned or confirmed seeing Tara Baker at her home. She was at their home the weekend before. But it's verified based on Chris Melton's own words twice, 2024 and 2001. He saw her 10 days before she died, and they had a fight the week before, which aligned with this. I promised you that I would talk to you about Chris and Tara's relationship. So this was a relationship where these individuals met at college. Chris was in school as a pre-med major. So pre-med is pretty much when individuals going to school to become doctors. Tara was in school, Miss Baker was in school to become a lawyer. So these individuals were equally yoked.
You made me remember I should take a Pepsid before I eat the soup.
Mr. Melton dropped Mr. Melton dropped out of school, Miss Baker, she moved to Athens to attend law school. And I'm sure Chris Melton, he had to make
This would require effort.
And he didn't follow moving with Miss Baker. What he did, he followed and moved into a room with someone else that Miss Baker introduced him to. And you will learn that Mr. Melton, to stay close to Tara, was traveling back and forth every day for work from Athens to Covington, Loganville, Gwinnett County, Georgia, every single day while Miss Baker was attending law school.
Stay.
You will hear that towards the end
No.
of 2000, as I mentioned, that Miss Baker was distancing herself from Mr. Melton, and she was developing a friendship with another individual that was in her profession. Her roommates will also tell you that the
You are not
relationship
wrong,
with
Beulah.
Mr. Melton was coming to an end. Now, this is the biggest thing I want you to focus on during the closing. During the evidence. Is Chris Melton's behavior after Miss Baker died. This is going to be extremely telling evidence. Miss Baker dies on January 19th. On January 25th, Mr. Melton goes to Miss P.D. Hall's home to spend the weekend with her and her boyfriend, the family. On the 25th, he calls a girl by the name of Lisa Tucker and invites her on a lunch. Goes on a lunch with her. I'll say that. He goes on a lunch. I don't want to say anything. We're talking in a week of this borderline fiance dying. Then on this next day, after he set up a lunch with Miss Lisa Tucker, he then calls a woman by the name of Holly Comfort and sets up a lunch with her as well. And Miss P.D. Hall went to this lunch with Chris and Miss Holly Comfort. She took her boyfriend at the time, Chris Hall. And what she'll tell you, or what the evidence will show, is that during that lunch, Miss P.D. Hall witnessed Mr. Melton flirting with Holly Comfort and even rubbing Miss Holly Comfort's back a week after his girlfriend has just died. And when Miss Ashley P.D. Hall says, all right, me and Chris are leaving, Chris Hall, the boyfriend's Chris Hall. Me and Chris are leaving, Mr. Melton explained to them that he was going to stay and hang out with Miss Hubbard. And this, again, is within a week of this borderline fiance being brutally murdered.
Borderline fiance. That'd be a really good show. Not 90 Day Fiance, Borderline Fiance.
You'll learn on January 27th, after hanging out with Miss Hubbard, he called her around 10 o'clock that night and told her if she was out on the town, to give him a call. Again, this was a week after his girlfriend's just been murdered. Miss Hubbard did not call that. You will also learn that there was a candlelight visual for the woman that Mr. Melton claimed that he loved. And if you consider his death, death is like this. He was in an instant. There was a candlelight visual held for Miss Baker. And instead of going to that candlelight visual for Miss Baker for his girlfriend, Mr. Melton told law enforcement, because they had confronted him, nothing that he told law enforcement. Mr. Melton told law enforcement that, yeah, I knew about the candlelight visual. I knew about it for about 4 days. But, Lauren, she already had these tickets to this country concert at Turner Field. And, she told me that she talked me out of going. She said that, Chris, that isn't somewhere you need to be. So instead of going to his girlfriend's, if they were still together, his girlfriend's candlelight visual, he went to a country concert at Turner Field with 2 other couples. It was him and Laura Sherling. It was Laura Sherling's mom and dad. And it was also another guy and gal couple. You, the jurors, will have to decide if Chris Melton's actions after Ms. Baker's death were consistent with someone who had suddenly lost their future wife. Next, I'd like to talk to you about law enforcement's failures. And there was a lot of failures in this case. During the trial, you will learn this case is not simply about my client, Mr. Faust. This case is not simply about Mr. Melton, nor is this case simply about Tara Baker. You will learn that this is a case of law enforcement neglect and failure. The evidence will show while this entire community was in dread and fear, law enforcement had enough evidence supporting that the person that killed Ms. Baker was right in front of them. But because of the cameras, because of the media attention, and because of the sensationalism, they have Mr. Faust sitting in that chair. The evidence will show that law enforcement knew, this is information they're aware of, law enforcement knew and ignored, as I mentioned, that all the human hair found on her body that did not belong to Ms. Baker was of Caucasian origin. You will not hear a shred of evidence that there's an African-American man's hair on Ms. African-American's hair on Ms. Baker's body. And the reason we showed you a photo of Mr. Faust with the afro is because he had a lot of hair.
Oh my God.
The evidence will show that law enforcement conducted a DNA test. A DNA test was done. This isn't the first DNA test. A DNA test was conducted on a pubic hair found on Ms. Baker's butt. Now, in this case, and the state has already told you this, so I'll follow up with it. In this case, it is undisputed that Ms. Baker was sexually assaulted anally. A piece of evidence that law enforcement had was a pubic hair was found on her buttocks. They conducted a mitochondrial DNA test on this hair. And the results of the test was that Mr. Melton could not be excluded as the contributor of the hair.
Where do we know mitochondrial DNA from, class? Miss Casey. Nope. Nope. I don't like that. I mean, how did this guy's DNA get all over her in her if he didn't do it? But what in the actual heck? This boyfriend sounding sus as all get out.
This is information law enforcement had. Law enforcement knew, and this science is now not good science. I do want to be very clear with you. So we're not talking about it because of its scientific purposes. We're talking to you about it because they knew this information. There was a hair found on the murder weapon, Ms. Baker's murder weapon. So on the cord that was used to strangle her, the cord block was next to Ms. Baker's head. I'm sure you'll see photographs of how Ms. Baker was found. On this block, they found hairs, human hairs. And one of the hairs, they did a test. It's not good science anymore. I want to make that clear. But at the time of 2001, law enforcement knew that that scientists had determined that this hair was similar to Chris Yelton's hair.
Well, he was her boyfriend. That argument.
Law enforcement knew and ignored, and the state has already told you this. There was no evidence of forced entry in Ms. Baker's home. They talked about a window. This is what you will see.
That's concerning.
This is the window that the state talked to you about. It's not the best picture, but what you'll see is there's a screen in this window. Because they could not figure out how the person got into the home, they started going around the house and they saw a bent screen. You were here, they saw a bent screen. And because the screen is bent and in the window, they assumed, hey, maybe this person broke in the house by taking the screen down, lifting up the window, lifting up the blinds, climbing into the window, committing this crime. Then, because the doors are locked, they climb back out the window, let the blinds down, close the window, then put the screen back in place. Now I'll show you a closer picture of what you will receive in evidence of that screen. That's a closer image of it. And this is one more image of that screen as well. And it's just showing the shape it was in when law enforcement saw this screen window. That's the outside.
Wow.
I'll show you the inside, and this is what you'll see in evidence as well.
It's sped up, which is why it looks like he's going so fast.
This is the inside of that window.
Hold on.
Chair in front of the window, blinds down, unruffled. But this is how they're.
Hold on.
Alleging Mr. Faust
Oh my
entered
God,
into
it's
Ms.
so
Baker's
slow.
home and exited Ms. Baker's home to commit this crime.
This is normal speed.
The law enforcement ignored that there was no signs of forced entry into her home.
Nope, I
They
can't.
ignored that both the front doors were deadbolt locked and the back doors were deadbolt locked. Law enforcement knew and ignored, and this is very important too, because Mr. Faust is charged with a burglary. Dr. Lowe tell you that in her room, she had a change jar with money, she had jewelry in her room, she had electronics in her room, and nothing was touched. Nobody had even rambled in her room. You would also hear from Miss Ashley P.B. Hall, who will tell you may even see images, but you will learn that she had jewelry in her room and she had electronics in her room, and nothing was touched or taken. Nothing was rambled through. Then you will hear about Miss Baker's room. Miss Baker had heirloom jewelry in her room. Heirloom jewelry. She had diamond earrings in her ears. And the only thing that was taken is a personal item, which was her laptop. Police ignored that fact. Law enforcement also ignored, and well, let me say this. So we don't have to prove anything, right? We don't have to present evidence. The state has to answer the questions when it comes to this case. There are no questions that we have to answer. But something that law enforcement knew and ignored was after Ms. Baker's death, a young lady volunteered. She called in to law enforcement and said, hey, I believe Ms. Baker was out at a Mexican restaurant with me the night before her death. This young lady's name is Jessica Gann. And we're either get it through Ms. Gann or we're get it through the law enforcement officer she told it to. But she said, hey, Ms. Baker was out with me the night before she died. She said, we're at a Mexican grill, and, I don't know if it was her, but I believe it was her. One girl she was talking about law school. I think I heard her. Law enforcement never followed up on this information. Law enforcement never showed Ms. Gann any type of photo of Ms. Baker. Law enforcement never followed up on her to figure out, okay, what more information do you have? They never even confirmed whether or not it was Ms. Baker she saw. They just ignored it. So the state cannot present evidence to you supporting that Ms. Baker, after she left the law library the night before she died, that she did not go out. They don't know. They don't know if Ms. Baker went out. They don't know if Ms. Baker went home. They just don't know. And they don't have any evidence to show one way or the other.
Wow.
Now, they mentioned Chris Melton's alibi. On January 21st, Chris Melton's parents told him, law enforcement, they are after you. They are coming for you, Chris. And that is a quote from Mr. Melton. That his parents told him, Chris, they are coming for you. This was January 19th, 21st. It was in January 2001. Police wait 4 months to go speak to Mr. Melton's parents after they've already told him 4 months prior that they're coming for you. And mind you, Mr. Melton is staying with his parents now. So he's in the house every single day. They asked the parents, hey, can you tell us what your son was doing 4 months ago on January 19th, 2001 at 7 o'clock in the morning? Can you give me a rundown? Surprisingly, Chris Melton was their only son, unless they've had children since then, but he was their only son at the time. They say, oh, he was at home. He was here. I remember seeing him. He was walking around. We were mulling around that morning. And then he left our house, and we know exactly where he went. How would they know that information? How would they know where Mr. Melton was going 4 months prior? But this is law enforcement confirming Mr. Melton's alibi, speaking to his parents 4 months. 4 months after Ms. Baker's death. Law enforcement failed to verify Chris Melton's alibi thoroughly. They just started taking words for, oh, he was here. Okay, perfect. He was with you. Okay, perfect. And this is the important thing in this case. The most important time in this case is
I don't know why it does that. Goes so close.
Whatever happens after 9 a.m., it doesn't matter because the murder has taken place. So 7 a.m. to 9 a.m. Remember, Ms. Kashana Armstrong at 7:45 said she saw this guy running. 7 a.m. to 9 a.m. is the most important window in this case. Law enforcement also waited 4 months to try and get Mr. Melton's phone records. They waited 4 months after Ms. Baker's death to try to get the phone records for his apartment phone. And that may or may not be important to you all, but to get the records for his apartment phone and his parents' phone call records, resulting in those records being lost forever. So what the state will not be able to present to you in defense of Mr. Melton is that, hey, we have these phone records showing where he was. Those records were lost because law enforcement did not act to get those records.
Okay, I'll be right back.
This is the most important thing. So they showed you all a map of Mr. Baker's home on Cooper Road, and they showed you where Mr. Faust's home is located. Do y'all remember that? It's in the box? Okay. This is what law enforcement, this is what you want here. They did a neighborhood canvas. They had roadblock, all this great stuff. Things you want here. One, they did not talk to the residents on the other side of your apartment. They could have simply went to 350 Cooper Road and knocked on the door. And they would have had all the information they needed about Mr. Faust because, as they mentioned, 350 Cooper Road was his stepmother's home. So she could have gave them all the information they needed. Two, law enforcement was aware, because you would hear Ms. Stevens say that, hey, I've looked at every document in this case. They were aware that Mr. Faust or his grandmother, if they notated, I don't know how good their notes were, but those were not two individuals that were notated as individuals that they spoke to around the time of Ms. Baker's death. But this is a failure of theirs, because if they're saying that Mr. Faust stayed a block away, they're basing that on him saying, hey, I stayed at this address for a year. But again, they didn't go and interview those folks. They interviewed people in Deer Park, in the neighborhood that Ms. Baker stayed in. Chris Melton, another important fact. After Ms. Baker's death, Chris Melton comes to the police department with his hands covered in blood. You will hear from law enforcement that there was a shirt that Miss Ashley T.V. Hall, she's an amazing friend. She did everything she could to try to figure out what's going on with Ms. Baker. When Chris Melton came to her house, there was a shirt that she washed, and it was a substance. She called police and said, hey, we believe there's an issue with the shirt. And what law enforcement determined was the substance on the shirt was the exact same substance Chris Melton showed up to the police department with his hands covered in the day of her death. Now, you may hear the audio is brand new. I'm going to try to play it for you all. But you may hear law enforcement. I'm going to play it. I have to play it a couple of times. But you'll hear law enforcement ask him, and this is a quote, do you want to watch them things? And Chris Melton says, no, this is neat right here. They never searched Chris Melton's apartment. They never searched Chris Melton's car for blood. You'll hear about by the name of Lindsey Baker. He begged. You'll hear he begged law enforcement. Search his car. Did you search his car? Did you search his car? But what you will learn is, and the state already told you this, when Chris Melton came to Athens, he didn't bring his truck back. He rode in Josh's truck. And law enforcement never searched his car for blood. They didn't care. You won't hear evidence presented by the state that they searched Mr. Melton's car. You won't hear evidence by the state that they searched Mr. Melton's apartment. You won't hear evidence from the state that they searched Mr. Baker's parents' home. In regards to the claim that Mr. Melton made that he saw Ms. Baker 6 days before her death, law enforcement never attempted to confirm that. They just took his word for it. Parents didn't confirm it. No one confirmed it. They just simply, well, Chris said it, so it must mean it's true. Let's talk about the forensics. I've already talked to you about the hair. There's no, and I'm gonna talk about this twice. When law enforcement met with, and the state told you this, when law enforcement met with Mr. Faust in the interview, what they told Mr. Faust was that your DNA was found in a house in Deer Park. You will hear no evidence that Mr. Faust's DNA was found in any place other than Ms. Baker's body. His DNA was not in the house unless you're saying in the house because it's in Ms. Baker's body. There's no DNA of Mr. Faust ever being present in that house. And you will hear he is adamant. I have never been to, I don't know anybody over there. He's going to say that. What law enforcement did not do, before I get to that, there are no handprints belonging to Mr. Faust. There are no fingerprints that the state will present to you belonging to Mr. Faust. There is nothing inside of the house that the state will be able to present to you to connect Mr. Faust with Miss Baker's house. The state wants you to believe that Mr. Faust is smart enough to enter Miss Baker's home, fight with Miss Baker, kill Miss Baker without leaving a trace of evidence behind, sexually assault her, right? Because they're charging him with aggravated sodomy based on the allegation that he sexually assaulted Miss Baker anally, but sexually assaulted her without leaving any identifiable DNA behind, then escaped Deer Park just unseen. But he is dumb enough to leave his DNA in her body and commit the charged crimes at the busiest time of the morning. And I don't think the state ever told you what time they are alleging that Mr. Faust committed this crime. Their window is between 8 a.m. and probably around 8:45. And you don't leave your common sense at home. You know what's going on at 8 in the morning and 8:45 outside your neighborhoods. But you have to decide as the jurors, does that make sense? That's the question you have to answer. The DNA. I think this is the most important part of this case that I would like to talk about. We talked about the DNA test conducted on the pubic hair found on Ms. Baker's butt. But I would like to talk about the sexual assault kit that the state talked to you about. So the sexual assault kit, as I explained to you, came back with multiple DNA profiles. Mr. Faust was one of the identifiable profiles. Mr. Melton was one of the identifiable profiles. Mr. Faust's DNA. If I understand the DNA correctly, and I may not, the testimony would be much clearer to me.
Well, like you must have missed when I explained this. I've been keeping up with this since 2001.
That's very important fact.
I always thought it was the boyfriend.
From the charge for the indictment, Mr. Faust is charged with aggravated sodomy for anal sexual assault. Chris Melton told law enforcement when they asked him, do you all engage in anal sex? No, never. She doesn't do anything like that. You know, we just have normal sex. Well, lo and behold, when they get the DNA results back, the only identifiable profile in Ms. Baker's anus is Chris Melton's profile. Now, something the state mentioned, they told you in opening that gravity can make the DNA go into that area. What the state says isn't evidence. But what Dr. Falzone says will be evidence. He is the medical examiner. He's the person that did the autopsy. And what he's going to tell you is that it is clear that Ms. Baker was sexually assaulted anally based on the injuries. Well, let me use the right language. He's going to say it's consistent. That's the proper language. That her injuries to her anus are consistent with sexual assault anally. And the only identifiable DNA profile is Chris Melton.
Don't forget to like and subscribe.
The state will not present any evidence to you supporting that Mr. Faust ever engaged in anal sex with Ms. Baker. It is important that you focus on the evidence that is presented. He is charged with aggravated sodomy, and his DNA is not even identified. All right.
I think it was 2021.
There's no evidence supporting that Mr. Faust had anal sex with Ms. Baker anytime or anywhere. The state will not be able to present evidence supporting that Mr. Faust and Ms. Baker engaged in that act. Now I would like to talk to you about what I call directing the investigation. You will learn that once law enforcement became aware of Mr. Melton's DNA in Ms. Baker's body,
He was charged in
that information
2024.
that Chris Melton had previously told them was false. Okay? You heard the state tell you that DNA typically in certain places only lasts about 5 days. I left out of this. Mr. Melton's DNA was also found in her vagina as well. So if his DNA was found in her vagina, anus, Mr. Faust's DNA was found in vagina and mouth. Okay? But you will learn that this DNA of Chris Melton, as the state said, only lasted about 5 days. When law enforcement interviewed Chris Melton, they asked him when was the last time you saw her. He said 10 days, which I said was in line with their fight that he was approached about in June of 2001, the week before her death. Law enforcement says, well, look, and I want to make sure I say this correctly. Instead of interrogating Chris Melton and confronting him and saying, hey, you've been dishonest with us, something's not right here, we've seen the picture of your hands, what law enforcement tells Mr. Melton is they sit down and meet with him. And you're going to hear from the lead detective in this case, Elizabeth Bigham. That, she asked Chris, and this is a quote, so was there ever a time in those 10 days, leading up into her death, that y'all just had a quick booty call or met up real fast or anything like that? Chris Melton responded, no. She knew what the DNA evidence was telling her. Ms. Bigham then tells Chris, I need you to be 150% honest with me. And I know that what I'm about to ask you, and I emphasize this language, is not what has been said for 23 years. And that may hinder you from wanting to be honest with me. But you've got to be honest with me. She then tells Chris Melton, look, your DNA will only last in her body 2 to 3 days. And that she needs to, and you'll hear this, she needs to separate Chris Melton's DNA from bad guy's DNA. She says this. I need to be able to explain it. I need to be able to explain it. Jeremy Howell tells Chris Melton, you'll hear Jeremy Howell testify, that the timeline needs to be correct. Everything needs to make sense. And if we know that this window is here and you're over here, I can explain this gap. You need to be here. But Chris Melton, and you have to decide if he sticks to his story because he knows he's lied before, continuously denies being with Miss Baker of her death. They asked Mr. Melton, well, were you with her the night before? You had a booty call with her at 12 o'clock? He says no. They said, well, how about 2 days before? No. Well, how about 3 days, Mr. Melton? Were you with her 3 days before?
Like the day
No.
before CCTV
And
was
eventually
everywhere
they get
too.
Mr. Melton for the first time to say in this interview, for 23 years, he changes his story to, you know what? Well, we maybe did it on Sunday. We might have did it on Sunday. And then Elizabeth Bigham tells Chris Melton in this interview, not an interrogation, in an interview, I think we just have to be able to explain it. I think we just have to be able to explain it. And that is our job, is to explain it. So we can then go after the one that we think did this. She laughs. I mean, and evidence will show Mr. Faust is the individual that she was referring to. My client. When Chris continues to refuse to put himself and Miss Baker together.
I'm sorry. What is that?
She says, if you're like, you know what? I effing lied about it 23 years ago because I was it's the individual that she was referring to. My client. When Chris continues to refuse to put himself and Miss Baker together. Miss Bigham, she says, if you're like, you know what? I effing lied about it 23 years ago because I was a scared, terrified kid. And you're right. I had a booty call with her that night. I left at midnight and I don't know what happened after that. It'll be, thank you. Have a nice day. We'll let you know what happens. Like, that's it. We just want to be able to explain it and make it make sense so we can focus on this, So they can focus on this. You'll learn the lead investigator in this case, Elizabeth Bigham, told Chris Melton it was okay if he changed his story or changed his timeline of when he was with Miss Baker. And if he admitted to lying to police for 23 years so that she could explain away his DNA and put the focus on Mr. Faust and the responsibility for Miss Baker's murder on Mr. Faust, everything would be okay. She would explain it away. When Mr. Melton would not help Miss Bigham explain away his DNA, despite the 23 years of conflicting statements from Mr. Melton, and evidence, and you have to decide, but evidence pointing away from Mr. Faust's involvement in this case, the allure of being a hero, the allure of being on TV, being the officer to solve the 23-year-old Tara Baker case became too strong. And we ended up in the courtroom before 12 jurors to decide Mr. Faust's fate.
Hi, best friend.
The allure of being on TV became more powerful than following the evidence. And on May 9th, 2024, while Mr. Faust had just finished working, he's at Walmart buying a Simply Lemonade, police cars swoop in on him and put him in handcuffs and arrest him. Solely because, and this is very important, and follow the state's timeline, solely because his DNA was present in this case.
Oh my God.
What you'll learn is not, and this is not a DNA case. We didn't come here to fight with DNA. You will learn Chris Melton's DNA is present, unidentified DNA is present, Mr. Faust's DNA is present, and based on his DNA being identified, he was arrested and charged with burglary based on DNA alone. He was arrested and charged with aggravated sodomy in the anus, even though his DNA isn't present. He was charged with 4 counts of felony murder. He was charged with malice murder and every other count in this indictment solely based on his DNA being present, along with Chris Melton's DNA. Let's discuss the state's evidence against Mr. Faust, and I thank you for your patience. Do you all need a break? Let's discuss.
I like him. Y'all need break.
To meet its burden of proof to establish beyond a reasonable doubt that Mr. Faust killed Ms. Baker, the state is going to rely on, they're going to present evidence of Mr. Faust's DNA being present. Okay? That isn't anything we're fighting with. As I told you, Mr. Faust's DNA profile was not the only DNA profile present, but these are the questions you have to answer, or the state has to answer. Mr. Faust's DNA profile being present does not tell you why this crime occurred or how this crime occurred. You have to ask for that evidence. It does not tell you when the contact happened. And we don't know. It's been 24 years, 25 years. They've charged him with rape. They have to present the evidence that it was rape. The only thing that we could possibly say that you're here in the testimony in this case is that maybe when she was out in the Mexican restaurant, we don't know because they never followed up on it. They came into contact. We don't know. But that's a question the state has to answer. If you're saying it's rape, explain to us why his DNA is there. If you're saying it's rape, prove it. It does not tell us how the contact between Miss Baker and Miss Baker and Mr. Faust took place.
What did he just say?
Ladies and gentlemen, we're going to have you go into the jury room for a few moments. Please don't discuss the case. We'll be with you shortly.
Okay, give me one moment.
For that evidence. It does not tell you when the contact happened. And we don't know. It's been 24 years, 25 years. They've charged him with rape. They have to present the evidence that it was rape. The only thing that we could possibly say that you're here in the testimony in this case is that maybe when she was out in the Mexican restaurant, we don't know because they never followed up on it. They came into contact. We don't know. But that's a question the state has to answer. If you're saying it's rape, explain to us why his DNA is there. If you're saying it's rape, prove it. It does not tell us how the contact between Miss Baker and Miss Baker and Mr. Faust took place.
No, maybe we're gonna listen to this.
Yes, Judge, because I think this relates to our ruling as to 412 evidence, which I just think Mr. Cruz violated in a manner that borders on placing in contempt, quite frankly. Mr. Cruz just intimated about the possibility of prior consensual contact that resulted in Mr.
It wasn't this guy's pubes on the suspect. It was her boyfriend's.
Faust's DNA being present in Miss Baker's body outside of the complained of contact, which would be previous sexual contact that requires 412 notice, Your Honor. So I think Mr. Cruz has quite intentionally actually violated the court's order, which court has made clear to him after multiple hearings on the issue. And so I'd like the court to instruct Mr. Cruz that that's, again, I guess for the third time now, that that's a wholly inappropriate suggestion to raise in any manner before the jury without having given notice, which he has repeatedly failed to do during the deadline set by the court, or from the point at which the court reiterated the fact that he had failed to procedurally give notice prior to today's date, which would be, well late of the time period in which he would have to do it. It would be 10 days late if he gave it today, but he has not. I would say further to the court that Mr. Cruz has represented to the court that he has no evidence other than what's in the state's file. Now, I guess he's making reference to this random tip that was received that Ms. Baker may or may not have been in a Mexican restaurant, which again doesn't say anything about her alleged contact with Mr. Faust. So there is no evidence supporting this, which is a finding the court would have to make, even if Mr. Cruz had provided proper notice, which he has not done. And now in opening statements after a week of jury selections has intentionally violated the court's order. So I'm asking the court to instruct Mr. Cruz not to engage in any further statements regarding that type of allegation, as the court has already instructed him, and to refrain from engaging in any questioning after opening statements, as is prohibited by Rule 412. So that's the state's objection that Mr. Cruz has intentionally violated the
boyfriend.
And the instructions.
I've always thought it was the boyfriend. This isn't her boyfriend.
Again for the third time.
Just a moment, sir. Yes.
But can we also acknowledge, like, real talk, y'all? When that guy, you heard his voice and you saw who was speaking, you did not think that was an older, like, well put together black man. Like, I thought that was a guy who went to like Caltech and majored in bioengineering nerdery and was like I was just not expecting the face to fit the voice. That really threw me for a loop.
Ms. Setterfield, are you able to read back the question prior to the objection? Are you able to do that?
Jeez Louise, is the courthouse on fire? It reminds me of Karen Reed all over again. The boyfriend was a big white guy, not this guy. That's why it was weird when the neighbor said there was a big white guy running through my backyard last night.
Would you mind reading that to the court? Thank you.
Where's her southern accent?
Of course.
Oh, you need more time? Okay. We're gonna pump it up. She's like, let me check my Facebook friends. Carol. Oh, that's such a good photo of us from high school. She left it today. What you talking about, Willis? Have you guys liked the stream yet? Double check to make sure you are subscribed. Oh, she left her accent at home. I'm very thrown off here in Georgia, y'all. My dad is a hybrid of North Carolina and West Virginia, and oh my hillbilly. Oh,
Unable to find it? So if you can't, that's fine. I'll go ahead and ask the state for something. I'll let Mr. Cruz respond. If you can't find it, that's fine. I am going to go back on the record when you're ready.
for real.
You good? Thank you for trying. Okay, thank you. Mr. Yalmanchili, please tell the court exactly what you feel, the words that you feel Mr. Cruz deliberately said to violate the order that the court gave.
Yes, Your Honor. So Mr. Cruz initially said the state can't prove when it is that Mr. Faust's DNA entered Ms. Baker's body. Mr. Cruz then said the police didn't follow up on this tip about the Mexican restaurant. Mr. Cruz then said it's the state's burden to prove that, and then said something to the effect of it could have gotten there when they had contact at that Mexican restaurant the night before the incident, essentially. Now that's paraphrasing, but Mr. Cruz stated that there was a separate time when Mr. Faust could have had contact with Ms. Baker in a manner in which DNA would have been found in her mouth and in her vagina that is a match to Mr. Faust, which they are not contesting, Your Honor. So I think that is pretty clearly a violation of 24-4-412 when no prior notice has been made and no showing of competent evidence showing that would
Like a
pass
Brady violation?
has been presented to the court as required by 412. So that's the actions that I think that Mr. Cruz has taken in order to intentionally violate the court's previous instructions.
All right, thank you, Mr. Cruz.
So part of the state's case, Your Honor, is that Mr. Faust and Ms. Baker doesn't know each other. Like I was telling them, that
Sir!
Court explicitly told me, or explained to me, that I could not make an argument about consent. So I did not make an argument about consent. A big part of their case is there's no way possible that you should be the random teacher. I'm just addressing that fact. Nothing in regards to the unenforced order regarding force will or in regards to argument of consent. Now, I am arguing as an important juror that it's the state's burden. That's as far as I understand that law will go, considering the unenforced orders to be not arguments.
Mr. Cruz, what would be the purpose of even mentioning the possibility of prior contact if it wasn't to violate the order?
Because the state's position is simply that these two would have never run into each other. We're just speaking that way.
Right, thank you. Yes, sir.
And Your Honor, since it is my motion, that is a complete and total misrepresentation of what just happened. Mr. Cruz was talking about DNA.
We ain't in Utah anymore, y'all. They mean here.
When his client was raping, sodomizing, and then murdering Miss Baker, and then said, alternatively, that could have happened if they had run into each other at this Mexican restaurant the night before in the context of where the DNA came from. So the idea that this is just an attack on the idea that Miss Baker and Mr. Faust could have randomly run into each other in some other social setting and that it has nothing to do with intimating that there was some kind of prior consensual sexual contact, something that Mr. Cruz seems to want to create the impression of with, as he says it himself, no evidence existing to support, is a violation of 412. And I don't see how it could be possibly interpreted as anything other than an intentional act on Mr. Cruz's part after repeated instructions from the court that he hasn't followed the proper procedural rules in order to introduce such evidence, and his own statements that would support a finding by the court, even if he had given notice, that there isn't any evidence, much less sufficient evidence under 403 to allow that allegation into the trial of this case.
Thank you. Yes, sir. And Mr. Yalmanchili does get the last word. It's his motion, but go ahead.
I think the prosecutor's taking my statement.
Here you go.
We're allowed to rebut evidence by saying, hey, they didn't have contact. I'm not speaking of sexual contact, I'm speaking of consent. The state position is just simply there's no judge don't like to go consent. For the state to get us to say, hey, this attorney should be held in contempt because he made statements about DNA saying that, hey, they could have had contact with her. And I didn't say they had sex at the Mexican restaurant. All I'm going to say, hey, there's a chance these two were around each other. I understand the other court's rules, but to get up, object, and say, hey, this attorney should be held in contempt and to intentionally violate the court's order, that's not this. I have not said one time in this open, consistent with the court's order, consistent with my understanding of 412, that Mr. Faust and Ms. Baker had sex. What I've said is the state may charge them with this offense, so they have to present evidence to support their allegations. And I've stated most different ways, but that's exactly what the position is now.
Yes, sir. Anything else?
Your Honor, Mr. Cruz just said that it was about the DNA in his response. There's no other way to interpret DNA that is taken out of an oral sample and a vaginal sample that is male DNA other than claiming some sexual act. So I think not only is Mr. Cruz intentionally violating the court's previous orders, he's also being disingenuous in his representation of what just occurred in the courtroom, which the court saw for itself.
That's all. All right. With regard to this particular moment, Mr.
Oh,
Cruz, we have had
shit.
discussions about this issue. And I am finding that your comments were deliberate, that you are deliberately trying to circumvent 412. I'm not going to find you in contempt because
So basically, what 412 means is that it's supposed to shield previous rape victims. And the prosecutor had said, like, you can't. Here, I'm going to let her explain this. And if she doesn't hit on what I'm hoping she hits on, I'll come back.
this moment is very similar to an argument you made about the state's comments about a word that you did not agree was appropriate. Attorneys' comments, attorneys' arguments, openings and closings are not to be considered as evidence. But I am offering this to you, Mr. Cruz, as a warning that
He
it
was
is imperative
fine.
that you follow the court's order. I've made several rulings with regard to this case. You are not allowed to talk about any issues of consent. You are not allowed to circumvent 412 without a proper motion. You have not filed a proper motion with regard to 412. If you do, the court will hear it. The state is correct. Even if we do hear a 412 motion, you have to have evidence supporting your motion. It can't just be something that you throw out there and assume that is something that could be properly admitted. But until a motion has been filed by the defense regarding 412, my order stands, and you are not allowed to go down that road. Am I clear about that, Mr. Cruz? All right, thank you. You may bring the jury. You may bring the jury back in. Thank you.
Oh no, it happens again. Sorry.
You all may be seated. Thank you. Mr. Cruz?
Also, his last name is not spelled the way that you would think.
The state's evidence includes, we mentioned the DNA, but what they also intend to introduce, and this is a question you have to ask yourself, with anything they introduce, how does this support that Mr. Faust is responsible for death, burglary, rape, escape? They intend to bring in a long-term girlfriend of Mr. Faust by the name of Miss Brenda Sweeney. Okay? Now, the thing is, Miss Sweeney and Mr. Faust were in a long-term relationship. They are not strangers. Okay? The state won't present any evidence of strangers coming in saying Mr. Faust broke in their house and did these terrible things to them. But what Ms. Sweeney will testify to, you may get three different things, because I believe we've gotten two. Okay? Police go to Ms. Sweeney's house when Mr. Faust is first arrested. The news report. Right? She's getting phone calls. You'll see this. She's getting phone calls from people saying, "Hey, did you?" I don't know what I'm assuming. Pretty much, she ends up saying that I just got a phone call that Edrick has been arrested. So what happens is law enforcement goes to her house, and the way they find her, based on what the officer says, police reports. Mr. Faust and Ms. Sweeney have a tumultuous relationship. They call a lie. Okay? Their police report of Ms. Sweeney calling the police on Mr. Faust and saying he beat her up, and she gets arrested because there's witnesses saying no, it's the other way around. She was jumping on him. You're going to hear testimony from Ms. Sweeney where she says, "Hey, Edrick hit me, and I beat him so bad I threw him into a DJ booth one time. Edrick took my car without permission. I went to his grandmother's house, and I beat him so bad he was trying to get me off of him, so he was scratch me. And other people had to come take me off of him. And she's going to give you multiple stories like that. But during this interview,
Hillbilly.
it gets to a point where
Hillbilly.
this interview stops. And she says, "Hey, the worst thing I can say that Mr. Faust has done to me, he's hit me. And when the relationship is over and I'm with somebody else, he just won't leave me alone." Police don't take that as true. When they didn't get this scandalous story from Ms. Sweeney about how terrible of a person Mr. Faust is, he's terrible, black bitch, the other, what they say is, a young lady has been killed. And we want to get justice for this young lady. And we know, he's a terrible guy, he's done terrible things to you. And just like we want to get justice for this young lady, we also want to get justice for you too. And she says, "Wait, guys, I don't know anything about a code case. I don't know anything about a girl dying. All right? Are you saying Edrick did it?" "Yes, we believe he did." "And Brenda, you were involved. You were with him at the time." And you'll see her, she misinterprets it. She said, "What? How am I involved?" And he says, "Well, Brenda, you were with them, so forth and so on. We've seen police reports of you too." And then all this word said, and she says, "Edrick used to force himself."
She says, "I want a lawyer," right?
Tell me more about it. He says, "Did he punch you?" She says, "Yeah, he punched me." "Was he violent?" "Yeah, he was violent." "When he would do this to you, was it vaginally, orally, anally?" She said, "Well, you'll hear." She says, "I don't know. For me, that." Right? And they continue talking to Ms. Sweeney. And it gets to a point, and they may present it, they may not present it, but I want you to know this is evidence that may come into this case. It gets to a point that Ms. Sweeney is under so much pressure. Forgive me, I forgot these. Ms. Sweeney tells law enforcement that she's had multiple strokes, by the way. So she's physically suffering, and she also says it affects her memory. But it gets to a point where they get Ms. Sweeney so worked up, she says, y'all, God just gave me something. She said, I'm very biblical. She said this one time, Edrick went to this house, and there was this girl, and I don't know what he did, but he set the house on fire. And they say, well, did he hurt the girl? She says, I don't know. She says, was anything taken? She says, yeah, he probably took the TV. He probably took it to his stepmother's house. Officer asked, well, how do you know this? Did he tell you? She says, he must have told me. I knew too much. And police at that moment, they don't take it like, oh my goodness, she may not be in the best place to talk, right? They continue talking to her, telling them all types of fantastical stories. But what ends up occurring is, once I found out about Ms. Sweeney's interview, you'll hear this too, that's why I say it's two sides.
Okay, I'm going to slow it down. He's talking real fast.
In front of the prosecutors, in front of Mr. Faust, in front of myself. And she says, you know, I felt like it led me to those incidents. She says, the only thing that I can remember from my relationship with Mr. Faust is that there was one time that we had unconsensual sex, and it was not violent. The state will introduce Ms. Sweeney not as evidence supporting that Mr. Faust committed these crimes against Ms. Baker, but to get you emotionally riled up. And that's why we chose you as jurors, because we believe that you will focus on the evidence. They're also going to bring in an individual by the name of Mr. Cedric Jeffries. Mr. Jeffries is serving a 105-month federal sentence. You will learn throughout this case, multiple people, since 2001, I know at least one officer has testified that there's been people from prison call with tips. Like, hey, you know,
Hey, yo, I got a hot tip.
Now, what you'll learn in this case, Mr. Jeffries is going to testify that I don't have a deal. I don't have a deal. But what you have to admit is that after he testifies in this case, he doesn't have a deal now. Because it'd be terrible for him to have a deal now. Because of course, we're talking about his deal. What happens after this case, after he testifies and says Mr. Faust told him in 2003 that he committed this crime, I'm going to get into the details for you. Federal prosecutors are going to meet with him. They're going to review the transcript. And if they determine that Mr. Jeffries assisted the state in this case, he is going to receive a benefit. Okay? You have to consider that information in determining his credibility. But this is what he says. He speaks with, he sees the news. The news breaks of Mr. Faust's arrest. He's in jail. He says this. So you'll hear this. He admitted it or they're recording it. He's sitting there watching TV. He sees Mr. Faust get arrested. Okay? He doesn't call police. He doesn't say, hey, correctional officer, come here. I know something about a crime. He calls his lawyer.
Well, of course he does.
And of course, we don't know what the conversation is with his lawyer, but he ends up meeting with the lead investigator in this case.
Sir, you are a defense attorney. You know
when he
better.
meets with Ms. Bigham, she says, hey, tell me what you know about this case. He says, well, when I was 14 years old, Mr. Faust came to my house. And he was saying, oh, my goodness, I'm about to get into it with police because they know that I killed this girl in your farm. Okay? That's what he's going to testify to. So police ask him, why did you wait 20-something years to say that? And Mr. Jeffries says the most important thing and the reason why he's testifying in his trial. Mr. Jeffries tells him, jail helps me remember things. But you hear Mr. Jeffries. That is the state's evidence.
Okay, buddy. Cuckoo.
Not a single shred of evidence will place Mr. Faust in Miss Baker's home. And the state has told you themselves, they've admitted it. We don't know how he got into the house. The evidence will show that Chris Melton admitted that Miss Baker had a key to his house. You have to decide if it's reasonable that Miss Baker.
I'm going to sustain that.
Yes, ma'am. But the state will rely on Cedric Jeffries, who, when he walks in this courtroom, he is serving a federal sentence right now, 104 months. And this isn't the first case Mr. Jeffries has testified on. Now, he may admit it, he may not admit it. But Mr. Jeffries at this time has testified on 2 other cases.
Yeah.
Here's a witness that gets in on cases and comes and testifies for the state.
That's a little sus.
Something that's important, you're going to hear the interview of Mr. Jeffries, or he may admit it, so we may not get into the interview. You're going to hear that Mr. Jeffries, one of the things he says is that I've never heard of this case before. Okay, and the state brought it to your attention that Mr. Faust stated that, in his interview, he made statements about Miss Baker. We're going to get into those statements.
Miss Bacon? Is that what I just
But
heard?
before I get into those statements, I want to talk to you about sketches you'll see. The state is going to present sketches to you. Okay? And what these sketches are of African-American men walking through Deer Park neighborhood, right? Police does a canvass after they found out about Ms. Baker's death. And during this canvass, they're talking to neighbors saying, hey, what did you see? The person that stays directly across the street, and Your Honor, maybe switch back to here.
So cold. My temperature thing is right there. Oh, what does it say?
So, thank you, Your Honor. So what you'll see, as I mentioned, the blue target, I think you all have to be there, but the house with the blue target is Terry Baker's house. The house across the street, I believe that is Mr. Matthew Owens, Mr. Jay Anderson, I may be mistaken. I think Matthew Owens definitely stays there, Mr. Jay Anderson, and another individual. And when police come and talk to them, what they're going to tell you is that you see a guy in a bright orange shirt. And as you know, in UGA country, you don't wear orange if you're trying to be here. You see a guy in a bright orange shirt, he's wearing khakis or jeans, and he was walking in front of, down the street in front of Ms. Baker's house. And the officer asked, can you describe him? He says, yeah, he has like small afro hair, black male, orange shirt, jeans. They said, well, how's he walking? He said, he's just walking regular. He's walking. But he says, I leave to go away. I walk away from the window for a second. He said, it's maybe 5 or 10 seconds he walks away from the window. And he says, when I come back, that person is gone. I don't see him anymore. He said, there's no way they could have made it to the end of the
I
street.
do need
He said,
an
I see both
electric
sides.
blanket.
He said the person had to cut
Add
through
it
the
to
house.
the list.
And then you will hear from Miss Tiffany Riker. And that individual, I think Jay Anderson, but the evidence will show the proper name. He doesn't do a sketch, just to be clear. But you will hear from Miss Tiffany Anderson, Tiffany Riker, who stays right here, this house here. She's going to say when she's coming out of her house to get in her car, she also sees a black guy. And she gives the same description. Wearing an orange shirt, blue jeans, khakis. He's walking down the street. And that's the gentleman I said, she backed up. She said, you stop for me to get out of my car. Now, what you'll learn in this case is on the other side of your park, there's another photo you'll see during this trial, there's a Walmart. There's the Walmart on Lexington Road. So people travel from this neighborhood up here at the top.
Where's Willa at?
And around here, I think somewhere around here, you can cut through and go to the Walmart on Lexington Road. Okay? And Chris Melton would tell us that African-American foot traffic was coming. Tiffany Riker would tell us that she didn't think anything of it because African-American foot traffic is coming. She thought the guy was walking to Walmart. But when police get this information, despite Ms. Kashona Armstrong saying we saw a gentleman running through my backyard, police say, okay, let's do a sketch of this person. So you're going to see a sketch of a guy who may not even know his pictures involved in this case. But they're going to show those sketches. But they're also going to show a sketch from a young lady. She was the wife of the tow truck driver. Okay? And the state may, they may change it, I'm about to say it, but the state may try to make this one person. Okay? That's two different people. She says, hey, I see a guy. I was out with my husband, we were picking up a car. I saw a guy walking down the street. She says this guy has a heavy set face. He's kind of heavier looking. I can't really tell his body because of the jacket he has on. She says it's a bright jacket, but she says it's long sleeve, which is different from the individual that Ms. Riker and the individuals that stay across the street from Ms. Baker. Different from the individual they saw. They say, well, how was he acting? She said, well, he was just walking down the street. She said, I actually watched him in my mirror the entire time he walked, and he was just walking. They said, well, did he have on a hat? No hat, no hood, just a jacket, just walking down the street. The state is going to present those pictures to you as Mr. Faust. They're going to say, hey, it's a black guy in the neighborhood. This is Mr. Faust. But again, the only evidence they can present to you is that this gentleman was just walking. One, heavier set in the face. Another, wearing a short sleeve orange shirt. One wearing a
They must be on the
jacket.
phone.
Right? But those are the sketches they're going to present to you. One of the sketches, and it's up to you to decide, does not fit the description given at all. And you will hear evidence, you will see those sketches, you will hear the information given by those witnesses about what the person looks like. But the photo that I showed you, Mr. Faust with the hair, they're going to say, hey, this is Mr. Faust with his hair, and these are the sketches. Ask questions about the sketches. Look at the sketches. Listen to the information that the state gives you about the sketches. And just make sure I'm clear, the person that was reported walking in front of Ms. Baker's house, our position would be this is the same person that Ms. Riker saw coming down this way, just to be clear. Lastly, you are going to hear Mr. Faust's interview. You're going to hear what Mr. Faust himself said about this case. You will learn, contrary to what the state has told you, that Mr. Faust was told when he was arrested, we're arresting you for Murder and aggravated sodomy. They hadn't asked him anything. That's what you're here for. Murder and aggravated sodomy. Mr. Faust is confused. He talks to him. He chooses to talk to him way this right because, of course, he's trying to figure out what the heck is going on. While they're talking to Mr. Faust, they didn't tell him whose murder. You will hear Elizabeth Bigham and Jeremy Howell ask Mr. Faust, did you hear about a cold case from 23 years ago? And that's how they ask him, did you hear about a cold case from 23 years ago? Mr. Faust tells him, I vaguely remember, and this is a paraphrase, not a quote, but I vaguely remember it. I think I saw something in the paper about it. You will learn Jeremy Howell nor Elizabeth Bigham show Mr. Faust a photo of Ms. Baker. Jeremy Howell nor Elizabeth Bigham tell Mr. Faust Ms. Baker's name. They don't say, Taylor Baker case. They just say, hey, you heard about the cold case from 23 years ago. They don't even give Mr. Faust the opportunity to explain the DNA because what they tell him, and this is very important stuff, they tell him, why is your DNA found in that house? Mr. Faust said, house? I've never been to a house in Deer Park. My DNA in the house? Your DNA is in the house. And just as much as I'm here to exonerate, I am here to hunt. But the truth is, as I've told you, the evidence will show there is not a shred of evidence putting Mr. Faust in the house. They didn't have that evidence. They misled Mr. Faust, and of course, hearing he's charged with murder and aggravated sodomy, he's probably freaking out. And he says, I don't know anything about the house. I don't know that woman. But again, they never gave him an opportunity to confirm who they were talking about. No name, no photo, just the cold case from 23 years ago in Deer Park, your DNA was found in the house. What you're learning in this case, one person lied to police over and over and over and over and over again. One person simply said, I've never been to the house in Deer Park, whatever you're talking about, I don't know. And the person that's in the next chair is Mr. Faust. Now, Miss Baker, as we all know, is a very beautiful woman. They showed us a photo, or the photo that Mr. Faust would have been aware of. It's a glamour shot. The photo that you all saw was not a photo that was shown to Mr. Faust. I do predict that the state, they may change this, I predict that the state is going to attempt to play for you an audio version of Mr. Faust's interview. Because the video version will show that Mr. Faust was given no information other than that he was charged with murder and aggravated sodomy for a cold case that occurred 23 years ago. On the video, you will see no pictures shown to him, as I mentioned. The state's evidence may get you emotionally riled up, but those are not answers. I think this is significant for everybody to know. So in 2001, Mr. Melton is told, as I told you before, that Ms. Baker was sexually assaulted. I mean, I said sexual assault, but he knew. They told him in 2001, and that's when he came back with, I saw her 6 days before she passed away. When he was meeting with Elizabeth Bigham and Jeremy Howell, they told him, hey, we found another person's DNA in her body. And Mr. Melton's response was telling. Mr. Melton himself said, sounds like she was with someone else. This is evidence in the case.
Ladies and gentlemen, I'm going to ask you to go into the jury room for one more moment. Please don't discuss the case.
Oh shit, he in trouble. Boy, you done fucked up. Did you see? Oh. Let's listen one more time before we. She looks pissed.
I saw her 6 days before she passed away. When he was meeting with Elizabeth Bigham and Jeremy Howell, they told him, hey, we found another person's DNA in her body. And Mr. Melton's response was telling. Mr. Melton himself said, sounds like she was with someone else.
Yep, that's it.
This is evidence in the case.
Ladies and gentlemen, I'm going to ask you to go into the jury room for one more moment. Please don't discuss the case.
Hey, boy. Okay, I gotta see his reaction again. I'm not laughing at the situation. I'm laughing. Well, I am at him. It like, man. We see it all the time. We see it all the time. God, I hear Pearl from your snoring.
Holden, you have an objection?
I do, Your Honor. Mr. Yalamanchili and I had talked in anticipation of us getting to this point over the weekend. But since I had made opening statement, I
Pull that microphone towards you. Thank you.
that I would object since I had made the opening statement. But since Mr. Yalamanchili had made the 412 arguments in the past that he would handle.
All right. Thank you. Go ahead, sir.
Your Honor, as the court's aware, as the state's aware, if Mr. Cruz wasn't aware before we started all the pretrial motions in this case, he ought to be aware now. Making reference, whether it's a statement made by some other witness, whether it's elicited in direct examination, cross-examination, or any other method to a relationship between Ms. Baker and anyone else that was not noticed by the defense as a 412 act is prohibited by 24-4-412. I'm not sure how much clearer the statutory language could be. Not sure how much clearer the court could possibly have been in its instructions. But whether it's Mr. Cruz making reference to a statement that some witness made during an interview with law enforcement, or whether it's Mr. Cruz eliciting the testimony on direct examination or cross-examination, it is all prohibited by the rule, which Mr. Cruz has violated now for the second time in his opening statement. It does not matter. It does not matter one bit whether or not Chris Melton said that in an interview to law enforcement for the analysis of whether or not it is admissible and the methods that must be adhered to if the defense intends to admit it in any way, shape, or form, Judge. And so this is the second time before we've called the first witness to the witness stand that Mr. Cruz has violated 412 in what seems at this point to be an intentional pattern to try to work his way around the laws and rules of the state of Georgia as it relates to admissible evidence in cases involving allegations of rape and aggravated sodomy, Your Honor. So again, at this point, I don't know what the remedy is that the court wants to enact, but obviously telling Mr. Cruz not to do it isn't effective because he's not listening and he's not following the court's order.
Any response?
Absolutely, Your Honor.
Our theory of this case is that Chris Melton committed this crime. Chris Melton's statement when he's confronting DNA that he already knew was present, that she was with someone else, and it has nothing to do with trying to get around Chris Melton. That statement is for the sole purpose of showing his consciousness of guilt. He knew this information in 2001. He told the exact same information in 2024. And his response isn't, oh, my girlfriend, I can't believe this happened, you guys better find her. His response is just simply to say, oh, well, must be me, she was with somebody else. There is no evidence that I intend to present that Chris Melton knows about Ms. Baker's sexual history. There's nothing I can intimate that Ms. Baker knows, that Mr. Melton knows about Ms. Baker's sexual history. The purpose of that statement has nothing to do with her character, her 24-4-12 sexual character. The purpose of the statement is to show Chris Melton's response. When he's presented with some evidence, he gives a response that's inconsistent with the person that is innocent. So this isn't a 412. I understand the state may not like what I present, but that does not mean I have to preview every single statement I have to them so they can prepare their case. This open statement. I respect the right to anything. I've told the court that multiple times. This is not a 412 argument. This is Chris Melton who knows nothing about Ms. Baker's sexual history, being confronted with a piece of evidence and making a statement that shows consciousness of guilt in our. This has nothing to do with sex.
Right, thank you. As this court has stated multiple times, this is the second time today, multiple times during hearings, that there is a process that must be adhered to in order to get the appropriate permission from the court to introduce statements, evidence that another party objects to. In this particular case, it is a 412 motion. We have talked about this over and over again. What I have said over and over again is that the defense has failed to file a motion under 412. The state did. The defense has failed to file a motion, and I've said many times that if the defense files a 412 motion,
accent.
even though it's not timely, the court will consider it. There has been no motion filed. Mr. Cruz, you've been made aware many times that you are not to bring in this kind of statement. I mean, I realize I have said several times today that opening and closing arguments of the attorneys and arguments are not evidence, and I'm going to say it again when the jury comes out. But you've been told many times that in order to, I'm talking on Mr. Cruz, thank you. You have been told many times that in order to present statements like that, ask for the admissibility of evidence like that, you have to file the proper motion, and the court may consider it even though it's not timely. As I just stated 10 minutes ago, I do find your statements to the jury to be avenues to circumvent 412, and it is not appropriate. I'm finding you in contempt of court. You have had the opportunity to explain yourself, and I'm finding you $1,000. And you are to present that $1,000 tomorrow morning by 9 a.m. Put it into the registry of the court. And
Mama,
that is
can
my
I have
sanction
some money?
for continuing to not abide by this court's orders. I don't know how many times we're going to have this, but it really can't happen again. $1,000 tomorrow morning by 9 o'clock. You may bring the jury out. Thank you.
Reaction, he's like, he should have known better. That's why we're laughing. Like, he is not a dumb man. Not by a long shot. He's very, very well versed. He's a great orator. He knows what he's doing, and he's trying to pull a loophole Lacey, and only Lacey can pull the loopholes. Sorry. Gotta be a lobbyist, act like a lobbyist.
All right, you all may be seated. Thank you. Ladies and gentlemen, I want to remind you that any statements made by the attorneys, whether it is in opening statements or closing statements or during arguments, any statements by the attorneys are not to be considered as evidence. Mr. Cruz?
She moves that microphone.
At the end of this case,
I just give
you
up.
go back home, you're sitting around the dinner table, and someone says to you, "Why did you find Mr. Faust not guilty?" You're going to say, "Well, I was fed a wealth of information. All this information came and it boiled down to one thing. The state couldn't prove that Edrick Faust was the person that killed Tara Baker. The state could not prove or present evidence that Mr. Faust was in Miss Baker's home. All of the hair found on and around Miss Baker's body was Caucasian hair. Mr. Faust is an African-American man. And that's why we voted not guilty. The prosecution in a murder case is required to prove their case beyond and to the exclusion of every reasonable doubt. Not a forced doubt or a speculative doubt, but a reasonable doubt. They have to present a case from you from A to Z. If A is Mr. Faust's DNA and Z is law enforcement's investigation, they never answer the question at G, at H, at I, at J, K. They don't answer the questions about personnel. They don't answer the questions about hair, even the hair found in her hand. If he did it, why would she have somebody else's hair in her hand? Why would she have non-African-American hair in her hand? If Mr. Faust did it, how did he get in and out of the house unseen? Why didn't anybody see a black male running through the neighborhood? If he did it, why would he take so much time cleaning up her apartment? He doesn't know who stays there. There are 3 bedrooms. If he's a stranger, why would he take that time to clean her apartment? This was a crime opportunity. You all swore to uphold the law, to hold the state to its burden. There is evidence here of reasonable doubt that Mr. Faust did not kill Ms. Baker. And it is not just sprinkled through this case. Reasonable doubt lives in this case. When you all have heard the evidence in this case, we're going to ask you to render a verdict of not guilty. In this nightmare for Mr. Faust, I am asking you individually and as a body to find Mr. Faust not guilty. Thank you.
All right, thank you, counsel.
All right, that's that. Guys, it's going to be a different day tomorrow. I have a dentist appointment, and I'm not going to disclose that time, but keep an eye out. Turn on your notifications. That's the best way to do it, so that you are notified when I do go live. And until then, I hope you have a lovely and safe evening. And don't forget to brush your teeth. All right. I'll see you guys tomorrow. Thanks for being a part of this. Bye-bye.